Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ನೆನ್ನೆ ಅದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಇದ್ರಿಂದ ಅದು ನೆಕ್ಸ್ಟ್
ಡೇಟ್ಸ್ ಹೋಗಿದೆ, ಅಪ್ಡೇಟ್ ಆಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ ಸರ್.
ಡೇಟ್ ಹೋಗಿದೆ ಮೇಡಮ್, ಅದಕ್ಕೆ
ಡೇಟ್ ಹೋಗಿ ಎಲ್ಲ ಅಪ್ಡೇಟ್ಸ್ ಆಗಿರುತ್ತೆ. ನೀವು ಇದ್ರಲ್ಲಿ ಸ್ಟೇಜ್ ನೋಡ್ಕೊಳ್ಳಿ, ಕೇಸ್ ಸ್ಟೇಟಸ್. ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಇದೆ, ಯಾವ್ದು ಡೇಟ್ ಕೊಡ್ದಲ್ಲ ಇರಲ್ಲ.
ಎಸ್ ಮೇಡಮ್, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್, ನಾನು ಚೆಕ್ ಮಾಡಿದೆ ಆಕ್ಚುಲಿ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ಡೈಲಿ ಹಾರ್ಟಸ್ ಅಲ್ಲಿ, ಬಟ್ ಅದು ಬ್ಲಾಂಕ್ ಇದೆ ಮೇಡಮ್. ನನ್ನದು ಏನ್ ಡೇಟ್ ಇದೆ ಅದು ಬ್ಲಾಂಕ್ ಇದೆ. ನಾಟ್ ಮೆನ್ಷನ್ಡ್
ನೋಡಿ ಸರ್.
ಇಲ್ಲ, ಬ್ಲಾಂಕ್ ಇದೆ ಮೇಡಮ್. ಅದನ್ನ ಹೇಳಕ್ಕೆ ಇಷ್ಟಪಡ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಮ ಹತ್ರ.
ಅಪ್ಡೇಟ್ ಆಗಿಲ್ವಾ ಸರ್ ನೆನ್ನೆ ಡೇಟ್ಸ್?
ಇಟ್ಸ್ ನಾಟ್ ಅಪ್ಡೇಟೆಡ್ ಆಕ್ಚುಲಿ. ಸೊ ನೆನ್ನೆ ಡೇಟ್ ಬಂದು ಬರೀ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ, ಒಳಗಡೆ ಏನು ಕಂಟೆಂಟ್ ಬರ್ದಿಲ್ಲ. ಇಟ್ ಇಸ್ ಬ್ಲಾಂಕ್ ನಾವು.
GMFC ಇವ್ರಿಗೆನಾ
ಒಂದ್ ನಿಮಿಷ ಹಂಗೆ ಇರಿ ಸರ್.
ಮೇಡಮ್? GMFC ನಿಮ್ಗೆನಾ? ಯಾರಿಗೆ ಮೇಡಮ್? GMFC ಇವ್ರಿಗೆ ತೋರಿಸ್ತಾ ಇತ್ತಲ್ಲ.
ಏನ್ ಹೇಳಿ ನಿಮ್ದು ಸೀರಿಯಲ್?
ನಿನ್ನೆ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಮೇಡಮ್, CRP 245 of 2018.
ಒಂದ್ ನಿಮಿಷ.
ಹಾ
ಅದು 16/7 ಹೋಗಿದ್ಯಲ್ಲ, CM ನಾಗಭೂಷಣ್.
CM ನಾಗಭೂಷಣ್ ವರ್ಸಸ್ ರತ್ನಮ್ಮ ಏನಿತ್ತಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಅಡ್ವೊಕೇಟ್ CM ನಾಗಭೂಷಣ್.
ಹೌದು, ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದ್ರಲ್ಲಿ. ಹೇಳಿ ಮೇಡಮ್.
16/7 ಇದೆ ಸರ್ ಡೇಟ್ ಅದು.
16/7 ಇದೆ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಅವರು ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ತಾರೆ. ಇದು ಡೇಟ್ ಎಲ್ಲ ಕೊಟ್ಟು ನಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಹಾಕಿ ಆಲ್ರೆಡಿ ಡೇಟ್ ಅಸೈನ್ ಮ್ಯಾಟರ್ಸ್ ಬರಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗೋವರೆಗೂ ಬರಲ್ಲ. ನೀವು 10 ಮೆಮೊ ಕೊಟ್ಟರು ಬರಲ್ಲ. ನಮ್ ಕೋರ್ಟಲ್ಲಿ ಬಂದಿತ್ತಾ? ನಮ್ ಕೋರ್ಟಲ್ಲಿ ಬಂದು ಆಲ್ರೆಡಿ ಏನಾದ್ರು ಆರ್ಡರ್ಸ್ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ರೆ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ಬೇಕು ಮೆಮೊ, ಇಲ್ಲಾಂದ್ರೆ ಬರಲ್ಲ ಸರ್. ಅದು ಸ್ಟೇಟಸ್ ನಮ್ಗೆ ಕ್ವೆಶ್ಚನ್ಸ್ ಇದೆ.
Court officer. Court officer. Court officer. Court officer.
Court officer? No audio.
ಕರಿತೀನಿ. ಸರ್ ನಾವು ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಕೇಸ್ ರೀಚ್ ಆದಾಗ ನೋಡ್ಕೋಬೇಕು ನೀವು. ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ಸ್ ಏನು ನನಗೆ ಮಾಡಕ್ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ. ಆಯ್ತು ಸರ್, ಆಯ್ತು.
ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮೊದಲು ಕರಿತೀರಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಕುಡಿಯಲ್ಲಿ ಸೈಡಲ್ಲಿ
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳ್ಬೇಕು. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮೆಮೊ ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾವ ನೋಡ್ರಿ, ಅಷ್ಟೇ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು.
ನೀವು 21st ಅಂದ್ರಲ್ಲ ಮೇಡಮ್, 21st ಅಂದಿದ್ದಾರೆ. ಅದು ಗೊತ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ಅದು ಆಡಿಯೋ ಕ್ಲಾರಿಟಿ ಇಲ್ಲ. ನೀವು 21st ಅಂದ್ರಲ್ಲ ಮೇಡಮ್, ಆನ್ ದಟ್ ಡೇ ಇಟ್ ಸೆಲ್ಫ್ ಯು ಲಿಸ್ಟ್ ಇಟ್ ಅಂತ. 21st 22nd ಲಿಸ್ಟ್ ಆದಾಗ 21st ಅಂದ್ರೆ ಜುಲೈ ಅಂತ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
ಈಗ ಲಿಸ್ಟ್ ಆಗಿದೆ ಕೊಡ್ತಾರೆ ಅವ್ರೆ. ನಾಳೆ 25th ಅಂದಿದ್ರು ನಾನು. ಸರ್ ಏನು ಅಬ್ಜೆಕ್ಷನ್? 29th ಇರೋದು ಮಂಡೇ ಮ್ಯಾಟರ್ ಇದೆ. 25th ಬೇಕು ಅಂತ ಕೇಳಿದೆ.
ಡೇಟ್ 21st ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಫ್ರೆಶ್ ನಾಳೆ ಮೇಡಮ್, ನಾಳೆ
ಬೇಕಾಗುತ್ತೆ. ಮ್ಯಾಟರ್ 29 ನಾಳೆ 27th ಕಷ್ಟ ಇದೆ. ನಾಳೆಗೆ ಬೇಕಾಗ್ಬೋದು ಅಂತ ಹೇಳಿ ಮೆನ್ಷನ್ ಮಾಡಕ ಆಗಲ್ಲ. 25th not 21st ಅದು ನೆಕ್ಸ್ಟ್ ತಿಂಗಳು ಮೇಡಮ್ ಇದೆ ಅಲ್ವಾ? ನೆಕ್ಸ್ಟ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ಗೌರ್ಮೆಂಟ್ ಡಿಸಿಷನ್ ಡಿಸ್ಕಸ್
ನಾಳೆ ಬೇಕು ಅಂದ್ರೆ ನಾಳೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ ಸರ್.
ಕೊಡಿ.
ಏನು ಎಲ್ಲ ಕೊಡೋವೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹಾಕೊಂತಾರೆ
ಮೇಡಮ್. 29th ಡಿಸ್ಪೋಸಲ್ಗೆ ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್.
ಇಲ್ಲ, ಮೆಮೊ ಕೊಟ್ಟಿದ್ದನ್ನು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ತಗೊಂಡಿದ್ದಾರೆ.
ತಾವು
ಎಂಟ್ರಿ ಮಾಡ್ರ ಹಾಕಿದೀನಿ.
ತಾವು ಅನುಕೂಲ ಹಾಕಿ ತಮ್ಗೆ ಯಾವ್ದು
ಅದಾದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಹೆಂಗೋ ಬರುತ್ತೆ ಅಂತ
ಮೆನ್ಷನ್ ಮಾಡಿ.
Court officer and BC.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ, ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಮೇಡಮ್ ಬಂದಾಗ.
Thank you, madam.
ಏನಪ್ಪ ನಾಳೆಗೆ ಅರ್ಜೆಂಟು?
29th ಲೋವರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಿಯರಿಂಗ್ ಇದೆ ಮೇಡಮ್, ಅದಕ್ಕೆ ನಾಳೆನೇ ಬೇಕು.
ಎಲ್ಲ ಬರಿಬೇಕು ಡೀಟೇಲ್ಸ್ ಮೆಮೊನಲ್ಲಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ ತರ ಎಲ್ಲ ಹಿಯರಿಂಗ್ ಇದೆ
ಮೇಡಮ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನಾಳೆ ಬೇಕು. ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ ಮ್ಯಾಟರ್. ಅವರು ಬಂದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ. ಅಲೋ ಮಾಡೋದು
ಏನು ಸೆಟ್ಲ್ಮೆಂಟಾ?
ಸೆಟ್ಲ್ಮೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿದೆ. ಇಲ್ಲಿ ರಿಪಿಟಿಷನ್ ಅಲೋ ಮಾಡೋದಕ್ಕೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ. ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಮೆಮೊನೂ ಹಾಕ್ತೀವಿ ಅದಕ್ಕೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಪೆಂಡಿಂಗ್ ಆಯ್ತು
ಸರ್. ಆ ಕಾರ್ನರ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ನೋಡ್ಕೊಂಡು ಸರ್. ಏನ್ ಹೇಳಿ?
ಅದೇ 2:30 ಮೇಡಮ್ ಬರ್ತಾರೆ, 2 ನಿಮಿಷದಲ್ಲಿ ಬರ್ತಾರೆ.
ಇವ್ರೆ ನಾವು ಅದೆಲ್ಲ ನಾವೇನು ಅದನ್ನೆಲ್ಲ ಅಕ್ಸೆಪ್ಟ್. ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಸಬ್ಮಿಷನ್ ನಾವೇನು ತಗೊಳಕ್ ಆಗೋದಿಲ್ಲ. ಅಡ್ವೊಕೇಟೇ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು. 2:30 ಬೇಕಂದ್ರೆ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಬಂದು ಆಯ್ತು ಸರ್. ನಾವು ಅದನ್ನ ಸಬ್ಮಿಟ್ ಇರೋ ಸಬ್ಮಿಷನ್
ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋದೇ 2:30 ನಾವು ಕೇಳ್ತಾ ಇರೋದು.
ಇದೆ ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದ್ಯಾ?
ಯಾವತ್ತು ಬರ್ಬೋದು?
6th ಜುಲೈ.
ಸ್ವಲ್ಪ ಆದಷ್ಟು ಬೇಗ.
ಅದೇ ಆದಷ್ಟು ಬೇಗ ಎಲ್ಲ ಬೋರ್ಡ್ ಫಿಲ್ ಆಗ ಸರ್. ಒಂದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಜನರೇಟ್ ಮಾಡಿ ಸರ್. ಡೇಟ್ಸ್ ನೆನ್ನೆದಲ್ಲ, ನೆನ್ನೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್. ಯಾವುದು ಇದಾ? ಸರಿ ಸರಿ. ಯಾಕಂದ್ರೆ ಒಂದಿನಕ್ಕೆ ಫೈಲು. ಆಯ್ತು ಆಯ್ತು, ಓಕೆ ಸರ್. ನೀವು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಸರ್. ನಾವು ಡೇಟ್ ಕೊಡೋದು ಕೊಡ್ತೀವಿ. ನಿಮ್ಮ ಫೈಲ್ಸ್ ಎಲ್ಲ ಏನಾಗಿದೆ ನಮ್ಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಡೇಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ವಿ ಲಾಸ್ಟ್ ಮೆಮೊಗೆ? ಹೋಗುತ್ತೆಪ್ಪ. ಜುಲೈ 1st ವೀಕ್ ಅಲ್ಲಿ ಯಾವತ್ತಾದ್ರೂ ಕೊಡ್ತಾರೆ. ಇಲ್ಲೊಂದು ಮೆಮೊ ಇದೆ ನೋಡಿ ಯಾವ್ದು ಗೊತ್ತೋಳು ಸರಿ ಜುಲೈ ಅದು 21st ಜುಲೈ 21st ಅದು ನಿಮ್ಗಾಗಿಲ್ಲ SMC-ಗಾಗಿದೆ ಅವರು 21st ಅಂದಲ್ಲ ಇವ್ರು 21st ಅಂತ ಮೇಡಮ್ ಹೇಳಿರೋದು 21st 5th ಅವ್ರಿಗೆ ಆಡಿಯೋ ಇದಾಗ್ಬಿಟ್ಟಿದೆ 21st ಜುಲೈ ಅಂತ ಹೇಳಿದ್ರು ನಾವು 21st ಜುಲೈ ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ವಿ ಸ್ಟೆನೋಗ್ರಾಫರ್ಸ್ ಆಯ್ತು ಸರಿ ಹೇಳಿ ಸರಿ ಯಾಕೆ ನಿಮ್ ಕೇಸು ನಿಮ್ ಗ್ರೀವೆನ್ಸ್ ವಿ ಕಾಂಟ್ ಇಂಟರ್ಫಿಯರ್ ಇನ್ ದಟ್ ಸರ್ ಹೇಳಿ 25th ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ದ ಕೋರ್ಟ್ ಈಸ್ ಅಡ್ಜರ್ನ್ ದ 21st ಜುಲೈ ಅಂತಾರೆ ಯು ಸಿ ಇಟ್ ಅಂತ ನಾನು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡು
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಯೋ ಯಾಕೆ ಅವಾಗ ಅವಾಗ ಆಫ್ ಆಗ್ಬಿಡ್ತಾ ಇದೆ ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಆಡಿಯೋ ಮೇಡಮ್ ಬರೋ ಟೈಮ್ಗೆ ಆನ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆರ್ಡರ್ಸ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ತಗೊಂತೀರಾ?
Sir, the list will go chronologically.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
there was one matter, my lord, which came up before this court, my lord, on 22nd. My lord, I requested a date for 25th, my lord, as the matter before the trial court is coming on 29th, my lord. My lord, but in advertise, my lord, in the website, it's showing us 21/7, my lord. So kindly, I'm moving a fresh memo that may be listed for 25th, my lord.
25th.
Tomorrow.
Milords, may I have your ladyship's leave to mention, Milords? Writ
Tomorrow I'm
petition.
pronouncing that.
I'm grateful. I'm very grateful. I'm very grateful.
Yes.
Serial number 34 in the second list, there is urgency. Be taken up at the end of the list.
What is the urgency?
Urgency is my case is coming up on 27/6.
27?
Saturday.
Yes, tomorrow.
My lord,
Tomorrow
my lord,
is the
serial
first
number.
list.
Tomorrow first list.
My lord, serial number 25 in the second list.
Not out of the list. Now, first mentions out of the list. You want that matter to be taken up at 10.
No, my lord, fresh matter because the ongoing construction is halted because of interim order basis. I have filed the vacating interim order, my lord. Serial number
No, that is urgency in every case.
urgency, my lord.
That's urgency in every case. That is not only urgency to be mentioned before this court is if the matter is coming up before the trial court. Otherwise, I will not hear any other mentions.
My lord, the trial court is a fresh matter. They've taken, suppressed all the materials and my construction is halted. That is.
Yes.
My lord,
Madam.
since the interim relief and the final relief was the same, emergent notice was issued, but the date was not assigned, my lord. I'm a beneficiary of an injunction order, and my police said request came to be denied by the trial court. The same may be taken.
Matter came up
The matter is the posted next week, my lord. Next week on Wednesday.
before this court.
The matter never came up, my lord. Only in the first hearing, admissions it came up. After that was 3 months back.
We'll see.
Well, any date,
My
short date, my
lordship
lord.
on VC. My lordship, party in person on VC, my lordship.
1 minute.
Okay, my lordship.
Now the plaintiff has filed a summary suit.
No, which year is the writ petition?
This fresh matter.
No, fresh matters will come.
The urgency it's posted on Monday, so can we have it tomorrow?
When was the order?
The order rejecting what had happened is the defendant without filing a
No,
leave.
I'm saying impugned order is when?
The impugned order is dated 8/6, madam.
The matter is coming up tomorrow.
On Monday, madam.
Yes, tomorrow.
My lord, I am mentioning, my lord.
I don't want all those details. I only want to know, is it a fresh matter? What is urgency, sir? In spite of me repeatedly explaining to the advocates that that is the urgency in all the petitions, I cannot take up. If I entertain like this, it's difficult.
I understand. What will happen was on 3 clarifications, they just moved a memo without taking a motion before that. For some reason, the office is not listing the matter at all. So the office have to read and receive from history. That is all.
So if I direct them, they will definitely list the matter. I might have not directed them.
I have not made a mention before that. I just passed on the memo. It's by having exhausted those options that come before us.
Not now. Yes.
My lord, we had taken the interim order in the above case, my lord, and it was been listed on 16/6. The respondent had informed me that they are going to take an adjournment. My lord, they have taken an adjournment, but there is a preemptive order on the said date, my lord, which was we are not aware of the same. Now there is a preemptive order.
That is your problem.
Please, my lord, can
You
you?
have accepted for their, you acceded to the request. They mentioned I adjourned. Now every matter I cannot, hearing one time, one opportunity itself is a very big thing in this roster. And I'll not have to do it for twice.
Lord, we are ready to comply the said compliance, my lord. Kindly list it on Monday,
Yes.
my lord.
And for the respondent, my lord, the petitioner has obtained the interim order. It was an FDP proceedings, really oldest matter before the trial court.
What is urgency?
The matter is kept pending, my lord.
In every matter, there are about 5,000 matters where stay is granted. What we can do?
FDP matter, my lord, the oldest.
FDP of 2005 is also stayed. Yes, call the list.
My lordship, I'm on BC. My lordship, may I make one submission, my lordship? I'm a party in person. Yesterday, my writ petition was first time has been listed in list 2 serial number 8, my lordship. The other side petitioner, without intimating me, taken a long date, my lordship. That is the reason court officer told me to mention.
They have not taken the long date. I have given the long date because the court cannot hear those matters.
My lordship, what has happened? I received a belated notice 13A notice after 50 days of RJ office no intervention, my lordship. I would like to just 5 minutes, my lordship, time to make my submission, my lordship. After
Court will not grant you in the morning without your matter being listed 5 minutes time. So
yesterday,
without the
no, not today,
without the matter
not today, my
being listed,
lordship, because I have to
any day,
comply my notice. Please tell to the court officer.
Yes,
My lord, list number 2, serial number orders of
she will call the list wise. Please
Date
wait.
wise adjournment, list 1, page 1, serial number 2,
My
page
lord,
2.
serial number 3 and 4, my lordship. Main matter is July month of connected, my lordship. 2 matter.
Page number 2.
It is submit. Take that. What is it?
3 and 4, my lordship.
3
List.
and 4, my lord.
Serial number.
My lord, the government advocate informed me, my lord, yesterday with regard to that there are respondent number 2 and 3, my lord. I appear. 3 and 4. I appear. Karnataka Neeravari Nigam.
3 and 4.
Please.
Mr. Prashant.
Prashant BR. Prashant BR.
Prashant BR takes notice on behalf of respondents 3 and 4. 3 and 4. List this matter along with the WP number 37702 of 2025. Land council shall serve the copy of the writ petition on the council. Yes. Huh? HB Devraj for respondent number 4 in both 5 in both the matters.
9 matters pending, my lordship. Connected 9 matters pending, my lordship.
List along with those matters.
Yes, my lordship. Serial number 3 and 4, my lordship.
Yes.
Serial number, page number 3, serial number 13 to 21, page number 4, serial number 22 to 28, page number 5, serial number 29 to 32.
Serial number 29, my lord. I kindly seek for a week's accommodation, my lord.
What accommodation you require?
My lord, senior is out of station due to this nephew's wedding. I don't have instructions with respect to the maintainability.
So
I kindly seek for a week's.
this is matter in the month of September. Yes.
Page number 6, serial number 33 to 38, page 7, 39 to 41, page 8, 42, page 9, 43 to 45, page 10, 46 to 50, page 11, 51 to 56, page 12, serial number 57 to 60, page 8, page 13, serial number 61 to 65.
Your lordship, serial number 63. Yesterday it is 2 matters listed connected on 66 and 68. At 5 p.m. I have taken the time for the 13 July. 66 is adjourned to 13 July, but 68 this matter mistakenly did not. 13 July.
Huh?
13 July.
List along with give the date.
25,400.
Write on a paper and give it to the
Please,
court
please,
officer.
please, Your Honor.
List along with the connected matter so and so. Yes.
Serial number, page number 14, serial number 66 to 70, page number 15, 71 to 77, page number 16, 78 to 82, page number 17, 83 to 87, page number 18, that is dismissal. List number 2.
88, serial number
89, Mila. I'm sorry, last occasion I could not be present here and this was discussed today. In the afternoon, I'll be held up in court number 15, Mila. That could it be tomorrow or any other convenience?
It will be there in the list.
Mila, I'll be held up in the afternoon.
Tomorrow it won't come. If I delete this, it will.
Monday, maybe.
Once it is out of list, it is out of list. If it's good for you.
Any other debit, I'll be held for that.
This is matter in the month of July. Don't give the date.
That's in 88. From yesterday, your lordship listed it today, my lord.
I have said specifically, this should be on the top of the list.
Again, it is.
88. I told that when she came in the evening, when she was showing, still she posted it here. Tomorrow on the top of the list, 88. And tell her what is happening. Find out from her. Yes.
Page number, list number 2, page number 1.
Serial number 1, Madam Chief, for respondent number 10 to 12. I informed to the petitioner council. 2 weeks time may be granted.
This is matter in the month of September. Look at it if interim order is there, extend.
Serial number, page number 2.
At the request of land council for the respondent. Yes.
Page number 2, serial number 4 to 6, Page 3, 7 to 10.
Serial number 10 minus 2. With respect to respond number 21 and 22. Take first step.
They moved memo. Who moved the memo? So when they have moved a memo, they must have some urgency. Have you informed them? No. Wait for the matter to reach. Yes.
Page
Serial
number.
number 11, madam.
Serial number?
Serial number 11, madam. Madam, tomorrow,
Leadership.
trial court for dependent argument, madam. Trial court for tomorrow for dependent argument, today at end of the list, madam.
This is matter tomorrow. In the first list, 11. Yes.
Page number 5, serial number 14 to 18.
16, your lordship, serial number 16. The respond number 1 ಗೆ notice ಹೋಗ್ಬೇಕು, steps ತಗೊಳ್ತೀವಿ. 2 weeks time.
2 weeks.
Interim order extend.
Taking steps. Interim order earlier granted is extended, or else if the steps are not taken, the writ petition shall stand dismissed. Yes.
Page number 6, serial number 19 to 23.
My lord, serial number 21, my lords. Matter was there before the trial court yesterday. It's posted for judgment, my lord. Can it be in list number 1 any day this week? I am seeking to withdraw the plaint with liberty to file a fresh suit. There's some formal defects in my plaint. Therefore, I am seeking for withdrawal.
Tomorrow.
List number 1.
First list.
Grateful.
Page number 7, serial number 24 to 32.
Serial number 29.
Yes.
I am for petitioner. Kindly grant me one.
Other side has moved a memo. That's how the matter is listed.
Petitioner, sir. I am for petitioner.
No, you are for the petitioner. You have a stay. Then
Yes, now move ಮಾಡಿ but senior is senior ಮಗನಿಗೆ admissions ಇದೆ.
no, when somebody has moved the memo, I can't adjourn the matter like this without even informing to them. Yes, next.
Page number 8, serial number 33 to 38. Page number 9, 39, 40. Page number 10, 41.
Lordships, kindly leave. Lord, memo for being spoken to. May I mention, my lord, two matters were listed last week. In both of them, identical interim orders were passed. But in the second matter, the interim order is not reflecting, even notice is not issued, although it says they've been connected. So it appears to be a typographical error. Maybe had tomorrow, my lord, there is a time-bound direction to comply.
Tomorrow.
Could it be had in the first list, please, my lord, because there is a time-bound direction.
First list.
Grateful.
For list number 1, serial number 1 for being spoken to.
This court on 1/6/2026 has dismissed the petition. However, while correcting the order, the court found that there is the certain judgments in favor of the petitioner were not considered by the court. Hence, the order dated so and so is recalled. Will list this matter for hearing. For hearing on this is matter for primary hearing on 6th of July.
Serial number 2. Recall. Serial number 2. 14%. Vinita Thomas.
Appearing in person, my lords, it has been posted for dismissal on certain inconsistencies. So I'll just clarify that, my lords, please kindly.
Use the mic.
Listed actually for dismissal.
Use the mic, ma'am.
The process is not paid for issuance of notice to the second respondent, my lords. The first PF has been paid by me, by the petitioner, by 29/3/2025. Wherein the notice issued to this honorable, from this honorable court has been returned unserved on both the parties. That is, first and second respondent itself, it has been returned.
Who is the second respondent?
That is the first defendant in OS 26942-2000.
What is the relation between you and the?
Plus first
My
defendant-
husband, my lords.
First defendant appeared through the council and thereafter he is not participating in any of the proceedings. So in every writ petition that is filed, he does not participate and it has been taken as not served and the matter has been proceeded till now.
In the court below, was he contesting?
He is not contesting. So she impleaded herself.
He was at ex parte before the trial court.
Yes. He has filed his
He impleaded
wakalatnama. I will come to that, my lords. It has been returned and served on 29/4/2025.
That notice to second respondent is not served.
No, it has been, it is returned and served 3 times.
Yes.
And then
No, the.
thereafter, my lords, 1 minute. Thereafter, this honorable court has passed an order stating copy to be served to the second respondent's counsel appearing in criminal appeal number 2067 of 2024 before the appellate court. That also I have served the copy to the counsels who are appearing for the second
Have you
respondent.
filed the memo to that effect?
Yes, I have filed the memo.
Memo.
That is filed by 12/5/2026.
Look at it.
And also there is an application filed for affixture under Order 5 Rule 70 of CPC for affixture of notice to the second respondent.
A memo is filed stating that as per the order passed by the court, this is not that. That as per the order passed by the court, she has served the notice on the counsel appearing for the second respondent in criminal appeal number 2067 of 2024. The same
So
is
my
taken
lords,
on
I
record.
have partially
Notice
complied.
Notice to second respondent is held sufficient. Please argue on the main
My
matter.
lords, I have one submission to make with respect to that, because I have filed an application for affixture by 15/4/2026, only because it is mandatory in this case. In this case, it is mandatory, I'm saying, because even though second respondent is not appearing, it is the first defendant.
That is now that the court will take care about service of notice. That's not your problem.
My
You
lords,
argue
I
your
wanted
matter.
one submission. I wanted this second respondent, even this application, one of the application is under Order 16 Rule 1 and 2, read Section 151 of CPC for summoning the first defendant for cross examination. So the first defendant, why I am
Please
summoning?
come to the impugned order. Court, the matter has to be argued how the court wants to understand it.
Yes.
And you have to explain to the court.
Yes.
Please come to the impugned order. Where
Yes,
is impugned order?
I'm just coming
I
to
don't
that.
require all that. Come to the impugned order and you can argue later.
Yes,
Where
I
is
am
impugned order?
arguing, but I am stating that one submission, please allow me. Because this first defendant is actually, though he has filed his wakalatnama, but has never appeared in this case. But all the documents which they are relying on, the plaintiff is relying on, that is exhibit P1, P2, P3. All the documents, the only documents in existence to prove the juror relationship and the
If you don't argue the matter, when there is a query from the court, you should answer to that.
So
I am not here to hear what you argue.
Because my lord.
Please come to the impugned order. Let me understand.
Yes,
Which
yes.
page number?
Impugned order, my lords, I have filed at annexure N.
Yes. Page number?
103. From 93 to 106.
1 minute. IA filed by the defendant number 2 under order 11 rule 14 is hereby rejected. Further, IA filed by the defendant number 2 under order 16 rule 1 and 2 is hereby rejected. Yes, please come to the order. Let us read the order.
Yes, my lords. Rule 14 of order 11 I will read it out. That is at page number 102, para number 10, ending paragraph. Production of documents. It shall be lawful for the court at any time during the pendency
Come to
of the
paragraph
any suit
number 10 and read.
to
Paragraph
order.
number
So
10,
here
page
the
number
just and for proper adjudication of the issues involved in the suit. That is
Then
why.
I'll say you're not able to understand the court
Yes, my
questions and
lords.
you require an advocate.
No,
You
my lords,
appear-
I can
Then
understand.
read at page para number 10.
Yeah, para number 10, ending paragraph 102.
Para number 10, before coming to the point, read from there.
Once. Before coming to the point, it is pertinent to note that the brief facts of the case. It is the case of the plaintiff that he is the absolute owner of the suit scheduled premises, serving in the armed force, has leased out the suit premises to the defendant number 1. Lease agreement came to be executed between the plaintiff and defendant number 1 for the period of 11 months, commencing from 1/4/2011 on the rent of rupees 15,000 per month with a security amount of 45,000, and defendant number 1 used the pay rent for some period. Thereafter, the defendant number 1 fell due in payment of rent. Such being the fact, the defendant number 2 is the wife of defendant number 1. Due to matrimonial dispute between defendant number 1 and 2, the defendant number 1 has not paid rent regularly, became defaulter. Plaintiff issued notice to the defendant for vacating the suit premises. Defendant number 1 did not reply to the notice, did not vacate the suit premises, but defendant number 1 remained absent. The plaintiff demanded vacating the suit premises and for payment of rent which is due to the plaintiff on account of notice issued by the plaintiff to the defendant number 1. Defendant number 2 has filed suit OS number 6170 of 2012 against the present plaintiff with a prior note to dispossess the defendant number 2 without due process of the law, and the said suit was allowed. Hence, the present plaintiff has filed this suit against the defendant number 1 for ejectment. Defendant number 1 remained absent. Hence, defendant number 2 has filed IA for impleading her as defendant number 2, and same was allowed, and defendant number 2 has filed written statement admitting the due relationship as plaintiff is landlord and defendant number 1 is tenant and defendant number 1 is husband of defendant number 2. Under such circumstances, when defendants have admitted the ownership of the plaintiff and admitted the due relationship as landlord and tenant, then the defendant number 2 has no local standing to insist the plaintiff to produce the title deeds of the suit property to establish ownership of the plaintiff. Of course, the plaintiff has referred that he is the owner of suit premises, but defendants have admitted his ownership and the due relationship. After admitting such a fact, the plaintiff need not prove his ownership as admitted fact, need not prove under section 58 of the Indian Evidence Act. Again, it is relevant to note here the provision of Order 11 Rule 14, which read thus: production of documents. It shall be lawful for the court at any time during the pendency of any suit to order the production by any party thereto upon oath of such of the documents in his possession or power relating to any matter in question in such suit as the court shall think right, and the court may deal with such documents when produced in such manner as shall appear just. My lords, here for a just and proper adjudication of the issues involved in the suit. So this order has been passed in the year 2019, that is 8/7/2019. Coming to the additional issues framed. So after that only I have filed a amendment, and this honorable court has passed the order for amending that particular admission. That is in WP number 68850/2020 Y25/8/2020.
The application in support of this IA.
So that has been, my lords can come to Annexure K.
Page number.
Page number 69. This is the order passed by this honorable court in WP number.
I am asking you, where is the affidavit that is filed in support of this IA? Where is the
This
IA?
application.
Yes.
My lord, that is at Annexure G, page number 56.
Please, Pratima, what are the facts?
Lots.
What are the facts?
Plus, the defendant number 1 and plaintiff entered into a lease agreement. The dual relationship is also admitted.
For what? Defendant, she is defendant number 2.
2 got herself impleaded because defendant number 1 has not been contesting the matter. Thereafter, issues were framed and then matter went and evidence was led, and she has cross-examined the plaintiff on already 3 occasions. Now the fag end, when it has to be posted for her this thing, now she files application.
For her evidence.
Milords?
For her evidence.
Her evidence, yes. Now there are about more than 50 applications filed by her. There is not a single provision that is not exhausted. The ejectment suit itself is of the year 2012. Now, she's filed an application making it look like as if her husband has bought the property. So she wants the plaintiff to prove his ownership and trying to convert the suit into something else.
She has filed the written statement.
She has filed it. There is admission also by her in the written statement.
But it has been amended.
Dual relationship of plaintiff and defendant number 1 has admitted by her not only in the written statement but subsequently in the CMIS proceedings DV Act that is filed by her against her husband. So I produce that as an exhibit.
Please
Thereafter,
come to the affidavit.
Allow me to make my submission also.
That the court will do. Come to the affidavit in support of the IA.
My lords, I have filed the application has been allowed by this honorable court, though it has been rejected by the learned trial court for amendment. It has been allowed and Annexure K, my lords, kindly please. Writ petition number 6885 of 2020.
I asked for the affidavit in support of the IA.
That I have already stated. It was.
Where is that? I have to read it. It is not just giving that it is at what page. I have to read that. What is the content of that? You said page number?
56. Annexure G.
Plus, there are 2 applications. 56 is the one to summon the defendant number 1, which the court has already summoned. He has remained ex parte. Now, the next application is at 50.
Annexure H, page number
60.
60.
She has filed a counterclaim.
No counterclaim, nothing. Plus, in second para itself, she states, if I may, my lord, that is at page 61, 4th or 5th line, or I'll read the second para. I submit that the plaintiff had referred to his absolute rights and title of the suit schedule property in the plaint and also in his affidavit towards examination in chief. But he has not produced the same or any iota of evidence to prove his ownership of the said suit schedule property. Though I have not taken this very contention in my written statement, as of now, I absolutely have no knowledge about who is holding the rights and title of the suit schedule premises, as I am not a direct party to the above suit, which itself is wrong.
My lords, may I?
And in the third para,
let me complete reading this.
Should I?
Yes.
Should I read the third para, my lords?
Yes, I am at para 7.
Para 7. I submit that as I was not a party in any kind of lease or rental agreement with the plaintiff and never had any kind of communication regarding the suit premises, it is on the word of the first defendant and believing the words of my husband, my parents had paid huge lump sum amount as dowry to lease out the suit premises. And after absconding of first defendant, I came to know of his ploy, and real true facts are yet to be revealed. Such is the circumstances existing, wherein it is of utmost necessity to inspect the documents referred to by the plaintiff in his plaint and also in his affidavit towards examination in chief. The plaintiff had stated in the plaint and also in his affidavit that he is the absolute owner of the property, but is shying away from producing the same while at cross-examination. The plaintiff wants the specific order from this court to produce the original sale deed. Hence, I am reluctantly compelled to file the above application. And these applications were rejected, my lords, 2019. And she files a writ petition 2025, last year, after a lapse of 5 years.
Yes. My lords, allow me. My lords, this petition, yes, what she stated is correct. Both the common OD impugned, which I have filed, that is both the applications has been rejected by the learned trial court by date 7/2019. So that time I did not question it because I was not able to question it because there was no issues framed. The issues has been framed in OS 2694/2012 that the additional issues framed after the amendment by this honorable court WP number 6850/2020 by 25/8/2021. That is why I was asking my lords to come to Annexa K, page number 69 onwards.
I've seen this order of Justice Dinesh
Yes,
Kumar.
yes, please, let me finish. Let me just read it out. Page number 72 and 73, para number 9 and 10 read together, please. In order to demonstrate that there is collusion between first and second respondents, petitioner adverted to a legal notice dated
I have read
12
this
4
order.
2000. Allow me to
I have read
read.
this order.
Just let me
You can
read.
submit, don't have to read, submit.
No,
I've
I
seen-
just wanted to read what this honorable court has
I've
stated.
seen that. That's what I'm saying. I've seen that.
The said legal notice has been, so this honorable court has very clearly stated at page number
Allowed
73,
your writ petition.
para number 10,
Yes.
it has stated these facts lead to an irreversible inference that the same law firm has acted on behalf of petitioner's husband and also against him. Interestingly, petitioner's husband, though served, has remained unrepresented in this proceedings. So here from this, the petitioner, here also it is stating very clearly that they are not only colluded parties, the first and second respondents, that is the plaintiff and first defendant, but also they are having one and the same counsels. They are sharing the counsels. So that on that ground, and also a hearsay admission. My admission at para number 3 of the written statement was nothing but hearsay. And the plaintiff cannot depend only on a weakness of the defendant. Here the weakness of the defendant has been used and my admission has been amended by this honorable court in WP number 6850/2020 by 25/8/2021, then and also upheld by the honorable
It is
Supreme Court of
11:20.
India.
Please listen. Now it is 11:20. By 11:30 you should conclude your argument. You have to concentrate on what is the issue and what
Yes,
is your
that's what
defense.
I'm coming
You
to
can't
that.
tell everything,
So when the
whatever
after the
happened right from
amendment,
2012 to 2027.
No,
Court
my
cannot
lords,
hear all that.
allow me the same, she was allowed, so let me also.
She was making a
Yes.
point
Okay,
to the
I am
question
also
the court
making the
asked.
point. After the amendment of the
Yes.
written statement,
Yes.
after the amendment of the written statement, the learned trial court has framed additional issues number 6 and 7. That is Annexure L, page 81. So it is rule 14 of order 11 of CPC very clear.
come to that.
Just and proper adjudication of the issues involved in the suit.
Yes, come
Here.
to the issues.
Page 81, my lords. Additional issue number 7, whether plaintiff proves that he is the owner of suit scheduled property and entitled for the relief of eviction of the defendant number 2 from the suit premises. So here, the learned trial court is questioning, my lords can see the year 5/3/2022. In the year 5/3, even though the plaintiff has filed the suit.
Yes, Pratima, where is this issue is framed?
She's pointing out at 81.
Yes.
Subsequently, the additional issues came to be framed. The burden is now on the plaintiff, additional issue number 7, whether plaintiff proves that he is the owner of suit schedule property and entitled for the relief of eviction. So the burden is on me if I have to prove it. It's not on her at all. Because
Yes, that is what I am also saying. The burden lies with the plaintiff to prove it in an ejectment suit.
If he fails to prove, what will happen?
My lords, it is not I am questioning, the tenant is questioning. It is the learned trial court questions the ownership of the property of the plaintiff, putting the burden squarely on him, prove the same in an ejectment suit. It is a settled principle of law that plaintiff has to prove the dual relationship that is existing between the plaintiff and that is the landlord and tenant. So he has to prove the ownership of the property. He cannot wriggle it out.
But subsequently, she filed an application for rejection of the plaint. Court, what
Yes,
it did
order
is,
6,
that is
order
fine.
7, rule 11A, we will go to that.
In the light of this issues framed.
burden is on me, I will prove it, my lords. Otherwise,
And what is the, why can't that application be allowed? What will happen? Ultimately,
I have
the
no
test-
difficulty in producing. I have no, I will
Then we'll
continue
allow it.
this
We'll
thing.
allow it. That's the end of it.
Plus,
Yes,
I will
ma'am.
produce. I have no difficulty in producing that. But regards the other one, my lords, summoning, that is
Summoning
not.
the-
And let there be
For
time frame, that is all, my
cross-examination,
lords.
My lords, cross-examination being an indispensable right of a party.
Hmm?
Being an cross-examination being an indispensable right of a party.
If the party is not coming, what is to be done?
No,
He
I
said
mean,
a
we'll
person
try,
is-
my lords, please, at least settle the matter. That's all I am asking for.
Yes, please come.
Unless if it settle the matter, then let her be before this court. I think this, it can be settled if she vacates within 6 months, I think. Because she's not paid
My
damages
lords,
of 20 lakhs.
The writ petition is filed seeking the following prayer. The petitioner before this court is the defendant number 2 in the suit. The petitioner, the respondent number 1 herein has filed a suit for rejectment. In that, the plaintiff has filed an IA under order Reven Rule 14 and 15, read with section 151 CPC, and an IA under order 16 Rule 1 and 2, read with section 151 CPC. The application is filed stating that to direct the application is filed for seeking a direction to the plaintiff to produce the sale deed with regard to the suit scheduled property to establish the right and title of the property. It is a case of the defendant number 2 that the plaintiff has, according to the plaintiff, is the owner in respect of the suit scheduled property, is absolute owner of the suit scheduled property, but he has not produced any document to show his ownership. According to the defendant, plaintiff and defendant number 1 are serving in the same department, and plaintiff has filed the suit colluding with defendant number 1 with an intention to dispossess her from the suit premises. Initially, suit has been filed against defendant number 1, that is the husband of the petitioner herein, and defendant number 2 has been pleaded in the suit on the application filed by her. It is a case of defendant that she has paid huge amount to defendant number 1 as dowry. After taking the same, defendant number 1 remained absent. With this, defendant number 2 sought a direction to the plaintiff to produce the title deeds. The court, by order impugned, had dismissed both the applications. This order was passed on 8/7/2019. While dismissing the application, the court has observed that on going to the provision referred, on going to order 14, If the document sought to produce is necessary for the adjudication of the issue, then court has to direct the party to produce the same. But in the case at hand, there is no dispute regarding the ownership of the suit premises, and there is no issue framed with regard to now, after this order is passed, then the amendment,
Please,
then the
Milords.
writ petition.
What the court said is, earlier in her writ petition, it's after all an amendment to the written statement which does not have much
There
consequences.
is no
Madam,
issue
I'll just
framed
allow
with
it.
regard
This
to
is
the
what
ownership
happened.
of the plaintiff as ownership of the suit premises and jural relationship has been admitted by both the parties. Since there are no grounds made out by the defendant number 2 following the application. Then when it comes to the second IA, with regard to the cross summoning the witness, the court observed that defendant number 1 is a tenant under the plaintiff and defendant number 2 is a wife of defendant number 1. And further, it is also clear that there is a matrimonial dispute between the defendant number 1 and 2, and matrimonial proceedings are going on before the competent court. The defendant number 1 has appeared before the court through his counsel in pursuance of the summons issued by the court in the suit. But defendant 1 did not choose to file written statement. After appearance through his counsel, defendant number 1 remained absent. When defendant number 1 has not filed any written statement, then the proceedings of judgment and decree which is going to pass by this court in this suit is binding on the defendant number 1, as it is well within the knowledge of defendant number 1. When he appeared through his counsel, as defendant number 1 is party to the proceedings, then question of summoning him to appear before the court does not arise. The provision of Order 16, Rule 1 and 2 of CPC is only for issuing of the summons to the witnesses to produce the documents or to give evidence if the evidence of witness is necessary for the adjudication of the issue involved in the suit. The court has further observed that the defendant number 2 has filed the application praying for issuance of the summons to defendant number 1 and secure the presence of defendant number 1, who has already appeared before the court through his counsel. Under such circumstances, prayer sought in the IA is not sustainable. On perusal of the entire application, affidavit of the defendant number 2 clearly shows that there is no merit in the application. The court also observed that the plaintiff has not filed objection to the IA filed under Order 16, Rule 1 and 2 CPC, but they argued on the application. Looking at the facts and circumstances, the court has come to the conclusion that this application cannot be allowed and accordingly dismissed the same. This order of 8719 is questioned by the petitioner by filing WP number 734 of 2025 on 7/1/2025. It is the party in person submits that she sought for earlier an application is filed under Order 6 Rule 17 seeking amendment of the plaint. When that came to be rejected, she filed a writ petition against the same. That is WP number 6885 of 2020, and that came to be disposed of by order dated 25th August 2021, whereby the court had allowed the application filed under Order 6 Rule 17, read with Section 151 CPC. Thereafter, the court has framed the additional issue. Then it is submitted that the additional issues that are framed, that is issue number 6, is within inverted commas, whether the defendant number 2 proves that plaintiff has filed this suit colluding with defendant number 1 with a common intention to evict the defendant number 2, and suit is not maintainable. And the additional issue number 7 is whether plaintiff proves that he is the owner of the suit scheduled property and entitled for the relief of eviction of the defendant number 2 from the suit premises. It is submitted that in the light of the said additional issues, the IA that is filed by the petitioner and filed by the defendant number 2, asking the plaintiff to place the ownership documents before the court is very much necessary, and the court has failed to consider the same. Next, it is submitted that the witness, the party to the proceedings has every right to examine the witness, and summoning the witness is also necessary in the facts and circumstances of the case. This aspect was also not appreciated by the court, and and the court had dismissed that application. When it comes to filing a writ petition in the year 2025 on an order of 2019, it is submitted that
My lords, the additional issues has been framed in 2022, 5/3/2022. So after that, I have filed for Order 7 Rule 11A of CPC. That is at Annexure M, my lords.
it is submitted that after the additional issues are framed, she filed an application on Order 7 Rule 11, and according to the party in
I
person,
was
the
questioning the cause of action.
the order can be questioned at any time, whenever the occasion arises for the party, and there is no limitation for the same. Next, when counsel appearing for the respondent, defendant number 1 submits that this is a suit of the year 2012 and even till 2012.
Yes, plaintiff loss. Counsel for
Plaintiff,
not
and
defendant.
counsel appearing for the plaintiff submits that the suit is of the year 2012, right from 2012 till 2026 till now. There are about 50 applications or filed. 50 applications
And
or
she's
filed.
changed 10 councils
My lords,
and there
what
are
they
about
are saying,
50 memos that are
application.
filed.
It is the IA number 29. That's all, 29 application only it is there.
It is filed, it is submitted
And
that
because of their collusion, I was supposed
her
to be
submissions,
filing.
she has every right to submit. I will record the submission.
No, but that is not correct.
Yes,
In that
President.
case,
Even in my this thing
may I request
also-
your lordship to just take affidavit that she has filed in this petition 12/3/2026,
it's what I'm
alleging
saying is the
on
correct.
the presiding office, my lords, 12/3/2026,
IA
asking
number 29 is the last dismissed one.
12/3/2026 is the affidavit that she files, where she has even written to the
My lords, it is IA
Chief
number
Justice
29 only, it was the
asking the
last.
petition to be
You're not
transferred.
understanding what, that's why the niceties of the court you should understand. When she is arguing, you shouldn't. You can argue once she completes the submission. Yes. What is that?
Because this is the 4th or the 5th court that this case has come up, because every court she says that she has no.
No, where is that?
12/3/2026.
What did they say? Where she refers about the IA?
Well, not IA, about the this thing of the nature of.
Said there are about 50 IAs.
50 IAs, milords, I think I have pointed out in my, if I'm not mistaken, in my application for vacating stay, list of cases before this court I have. I could produce it, milords.
Where is that? Your vacating.
My application for vacating stay, milords, 21/4/2026.
21/4.
Page number 5, I have stated the list of cases she has filed before this honorable court. List of IAs, I could produce it, milords. In fact, there is a list I have made, and
So as for that, how many IAs?
My lords, IAS has been listed by the court.
Look
It
at
is
para
29th
9.
only, it was dismissed before
Para
I
9,
filed it.
milords.
That's all.
No, you can tell the number.
40 IAs and 15 memos.
Now it became.
There are about 40 IAs filed, and the matter is pending consideration from the year 2012. Then counsel for the respondent submits that. Just because this writ petition is filed under Article 227, that doesn't mean that the party can question the applications at their convenience. The order of 2019 is questioned in the year 2025. It is submitted that on that ground itself, the writ petition has to be dismissed. It is further submitted that the the plaintiff who has approached the court in the year 2012, even till 2026 also, the proceedings could not be concluded. It is further submitted that the court has rightly considered and dismissed the application. When the issue is framed that whether the plaintiff proves that he is the owner of the property, the burden lies on the plaintiff, and it is for the plaintiff to make to take necessary steps to prove his title. If the plaintiff fails to prove his as burden lies on him, if he fails to prove the same, then the suit will be dismissed. That is not the botheration, or that is not the concern of the defendant. He submitted that on all counts the writ petition needs to be dismissed. Next part. Having heard the counsel, having heard the party in person, and the counsel appearing for the respondent, peruse the material on record. This is a suit filed in the year 2012 seeking eviction of the suit for eviction. The facts are the defendant number 1 is the tenant of the plaintiff and defendant number 2 is the wife. There are disputes between defendant number 1 and defendant number 2. In the light of the in the light of the disputes between the parties, the defendant number 1 left the premises and defendant number 2 started residing in the said premises. After the eviction suit is filed, she pleaded herself in the proceedings. In the year when she filed an IA to prove to produce these documents, as on that day, it is nobody's case that he is not the owner of the property. On that day, it is a case that the plaintiff is the owner of the property and that is being leased out to the defendant number 1. In the light of those admitted facts as on that day, the court had dismissed the IA. Then next coming to the application that is filed seeking to summoning the witness, the court has rightly observed that defendant number 1 is a party to the proceedings, and defendant number he has not filed the written statement. He is not contesting the matter. When he is not contesting the matter, whatever the court will pass appropriate orders, where the court and whatever the orders that are passed by the court or binding on them. The issue in the case is about the suit is for eviction, whether the plaintiff is entitled for the relief of eviction or not is the issue that has to be decided in the suit. And the inter se matrimonial disputes between the wife and husband are not the concerns of the court. Already an issue is framed with regard to whether there is a collusion between the defendant number 1 or defendant number 1 and 2. And it is a case of the defendant number 2 that there is a collusion that she would be that she has to prove by placing necessary evidence before the court. Now, as on the day the order is passed, there is absolutely no illegality with the order. However, later an application under Order 6 Rule 17 came to be dismissed, which is set aside by the court, and the IA is allowed. And pursuant thereto, the additional issues are framed. In those issues, there is an issue whether the plaintiff proves that he is the absolute owner of the property. In those circumstances, the burden lies on the plaintiff. If this application is allowed, directing the plaintiff to produce a document, no prejudice would be caused to the plaintiff. In fact, that would be helpful to the plaintiff. Then coming to the second issue, in the considered opinion of the court, with regard to the summons, no interference is called for. And accordingly, this court is passing the following order. The IA number so-and-so filed by this is IA number, IA under order?
IA under order 14, rule 5.
IA under
at the last
order,
page, 106.
and order 11, rule 14 is allowed.
Order
under order.
IA under order 16, rule 1 and 2 for summoning for cross.
That I am dismissing. IA under order 11, rule 14 is allowed. And the other IA, as far as order 16, rule 1 and 2 is concerned, the order of the trial court is affirmed. Number 3, the trial court, this is a suit of the year 2012. The court shall expeditiously decide the suit without granting unnecessary adjournment. The suit shall be disposed of
My lords,
as
allow me one
expeditiously as
submission with
possible,
regards to the-
but not later than 6 months.
My lords,
affidavit that she
this case, it's not even having, I did not argue entirely. My lords, it's a collusive case.
Court will decide.
Because allow that cross examination, then
Let-
only the underlying layers can come
Please
out in this case.
understand, I have passed an order. If you are not happy with it, go to the Supreme Court. You can't again argue.
No, my lords, but
Yes, so call the next matter.
order 16 rule 11.
All pending
Affidavit,
IAS are
One or
closed.
two OTP
Next
allowed,
matter.
my lords. Please.
Five.
One prayer, the affidavit may kindly be dismissed 12(3) where she has made allegations against all the presiding officers and everything, and she's filed in
No,
this
how
case.
can an
I don't
affidavit
know.
be dismissed?
Use that.
My lords, my order 16 rule 1 and 2, it's a collusive case, my lords, please
The-
allow.
After the order is passed, the party in person continued to argue the matter.
No,
She is
I'm
not
just
understanding
asking
she is not understanding if this manner, if she continues, there has to be an order by the court where she will not be allowed to argue as a party in person. You want me to record it? You want me to record it?
No.
Yes, then leave it there. Yes, call the next part.
Ramesh VK.
Grateful.
Ramesh VK for petitioner.
Appealing for petition
Yes.
in this case. Lord, suit for declaration in the lower court.
Suit for?
Declaration. And
You are
here-
the
Petitioner.
plaintiff or the defendant?
Plaintiff, my lord. In a
What is
voice
IA?
case. IA only for that 39 rule 1 and 2 injunction, not to alienate the suitable property, that's all, my lord. Because it's involving so many.
What the trial court did?
Trial court dismissed my IA, my lord.
Appellate
That
court
is-
has confirmed it.
No, it is also dismissed.
That's
In
what I'm
MA is
saying.
also.
Appellate court has also confirmed it.
Yes, my
Come
lord.
to the order in MA. Come to the reasoning part. Yes, at paragraph number 13.
Let here whether the impugned order passed by untried judge under IA3 is relinquished interference hand of this. But they said the government made the plaintiff the declaration of ownership in respect to social property along with the permanent injunction restraining the defendants from interfering with the plaintiff peaceful possession and enjoyment of the suitable property. And the schedule, my lord, here the petitioners herein are in the possession of.
Complete reading
Sorry, my
it.
lord. And the schedule mentioned in the plain government in OAC 18 of 2023 in 12/4 guntas of land in survey number 35/2 situated at Malagutta village, Kasba Obli Kunigal Taluk, bounded east the property plaintiff bearing survey number 32/5B and thereafter Karakalu west by Begu Road and Kunigal Road, Kunigal Gadi Road, north the Gangadhara's property, south the family property of Chandrapa. So the plaintiffs claim their ownership in respect of 12.4 guntas of land in survey number 35/2. When we go through the plain government, the plaintiff averred that the suit scheduled property is self-acquired property of the plaintiff's father. And after the death of the plaintiff's father, the suit scheduled property became ancestral property of the plaintiffs. And the said property was a self-acquired property of the Boraya resident of Malagatta village. And after his death, through will, the said property became the property of Boraya's grandson, Bettaswamy, son of Nanjappa. And as per the will, the name of Bettaswamy was entered in the revenue documents in respect of his share in the suitable property. And on 8/9/1993, the said property has been purchased by plaintiff's father Dodda Hanumaya from Bettaswamy, and accordingly, the plaintiff father gave requisition to revenue department to change his kata in his name, and accordingly the order has been passed and it was ordered for entering the name of Bettaswamy in respect to the shoe schedule property on 19/12/1991. Thereafter, on 8/9/1993, the said Bettaswamy sold the shoe schedule property to plaintiff's father K.C. Dodda Hanumaya for registered sale deed, and since from that time he was in the possession and enjoyment of the property mentioned in the sale deed dated 8/9/1993. But the defendants, without having any right, by relying upon the revenue documents, is interfering with the plaintiff's peaceful possession and enjoyment of the suitable property, and also trying to alienate the suitable property in favor of third parties to deprive the rights of the plaintiff in respect of the suitable property. Whereas the defendant denies the plaintiff boundaries towards the western side of the suitable property, the defendant in support of their claim is located to the west of the Begu Road as per the recital of the sale deed relied by the parties, and a revenue sketch produced by Ravi Shankar prepared by RRT Proceedings discloses that the property of Ravi Shankar is located either side of Begu Road, which is contrary to the sale deed of Ravi Shankar, as per the contention of Ravi Shankar, that is appellate in the said MA. The sketch prepared as per the possession of plaintiff is not in a party to the said proceeding, as to notice was given to the plaintiffs prior to deleting the plaintiff's name from the revenue records, and the respondent, that is respondent herein, after purchasing the property, got mutated the revenue records in his name till 2006, but the appellates behind the back respondent deleted the name. My lord, here one submission. At the time of purchasing the property, the land was in a vertical one. Later on, by Swadhina Anubhava, means over the cultivating the lands, they have changed it to horizontally. That is why this confusion arose. Continuation. In the revenue records, and the respondent possession was not at all in the disturbed by the appellates, and as per the sketch relied by the party, the lands of appellates situated on both sides of the road. As such, they might have attempted to put fencing, including 4 guntas of land purchased by the present respondent Narayan Murthy. It is, my lord, to purchase by the respondent Narayan Murthy. By that time in 1992, the records were not changed to the
Now, without going
seller.
into all those aspects, the defendant has already filed a suit for injunction.
Yes, my
There
lord.
is an injunction restraining you from interfering with his
My
possession.
lord, that injunction is granted after DC is converted.
Whatever
Means
it is,
we
no,
have
there is an
challenged that
injunction
RTC.
operating against you. How will there be an order now against him not to alienate the property?
No, my lord, our only request is to not to alienate the property, my lord, because the dispute is there.
Prima facie, right, there are findings against between the same parties on how it is not. The appellate court has rightly discussed all that.
Yes, my lord, but till that, at least they should not alienate
Why
the
should
property.
it be? Because there is no clarity with regard to what is
No,
your
no, my
property,
lord.
what is his property.
My lord, we are in the possession. Only the thing is, at the time of purchasing, the lands were.
Come to para 17 and read.
Yes, my lord. Like 17, at this stage, the document relied by the plaintiffs were compared with the defendant's document. There is no doubt with regard to the title of the plaintiff in respect of the scheduled property. And there is also the difference of boundaries in respect of plaintiff's scheduled property and written statement scheduled property. If it is so, all these aspects require full-fledged trial. When there is no averments regarding the defendants alienating the scheduled property in the plaint, the question of granting the said relief as per IA number 3 to the plaintiff does not arise. So the trial court is considering all these aspects, rightly dismiss the application. Hence, the said order does not call for any interference by this court. Further, it is made clear that the above discussion will not come to the way of trial court while deciding the plaintiffs on merit. Hence, the appellate have not made any ground. My lord, here only the thing is, they have at the time of purchase the property, the lands were vertical. When Swadhinamabha means at the time of
Did they
cultivation,
purchase the property?
1993, my lord. At the time,
When did the defendant purchase the property?
1992, according to his sale deed. But that time, the sellers are not having the title over the property. After only revenue records transferred, only then they can sell the property and the will is concerned. So that is our contention. Right now, we are in possession of the property. That 4 guntas of land, it's not at all there. So that is why we are saying that only that he should not sell the property or alienate the property on the basis of his sale deed. That's only our request before this court.
Please come. Agreed with the order. Passed in. Passed in I number 3 in OS number 18 of 2023, dated 24/7/2024, which is affirmed by the appellate court in MA number 21 of 2025, dated 8/10/2025. The plaintiff is before this court. The plaintiff herein has filed a suit. Where is your plaint?
Plaintiff, page number 86, my lord.
80?
Sorry, my lord.
86 is not the plaint.
Page number 58. Annexure D.
What is the relief? Suit for declaration?
Declaration.
Suit for declaration and injunction. In that, I number 1 is filed seeking injunction restraining the defendants from alienating the property. That came to be that was discussed by the trial court. Against that, the matter is carried in appeal and the appellate court has confirmed the order of the trial court. Next para. While the trial court, the appellate court, while confirming the order of the trial court, has observed that The defendants herein, the respondents herein has filed OS number
18 of 2023.
the OS number 395 of 2016. And in the said suit, he sought for a temporary injunction that was granted. Against that, MA number 7 of 2021 is filed before the additional senior civil judge and JMFC. And the miscellaneous appeal filed by the plaintiff herein in the said suit is dismissed. And it was also observed by the court that the property of the plaintiff is located on the east of Begur Road, and the property of the property of the defendant in the present suit is located on east of Begur Road, and the property of the plaintiff is located to the west of the Begur Road as per the recitals of the sale deed. And the revenue sketches produced by prepared in RRT proceedings discloses that the property of Ravi Shankar is located either side of Begur Road, which is contrary to the sale deed of Ravi Shankar. And as per the contention, whenever I say Ravi Shankar, the plaintiff in the suit, and the plaintiff and the plaintiff herein has placed a sketch prepared as per the possession. And the court has observed that the defendants have purchased a property, got mutated the revenue records in their name, but the plaintiff behind the back of the defendants deleted the name in the revenue records, and the respondent position was not at all disturbed by the plaintiff. And as per the sketch relied on by the parties, the land of appellants situated on both sides of the road, as such they might have attempted to put fencing, including 4 guntas of land purchased by the defendants. The court has also observed that at this stage, the documents relied by the plaintiff were compared with the defendant documents. There is a doubt with regard to the title of plaintiff in respect of the suit scheduled property. There is also the difference of boundaries in respect of plaintiff's scheduled property and written statement scheduled property. If it is so, all these aspects requires full-fledged trial. When there is no averment regarding the defendants alienating the suit property in the plaint, the question of granting the said relief as per I number 3 to the plaintiff does not arise, and accordingly dismiss the MA. Next, parallel counsel appearing for the petitioner submits that there is a dispute with regard to the property, and the petitioner plaintiff is in possession of the property, and as claimed by the defendant, there is no land available. And that is the case. If the property is sold by the defendant, it would cause a lot of hardship to the petitioner plaintiff. When the petitioner plaintiff has shown prima facie case, and there is balance of convenience in his favor, and if the interim injunction is not granted, it would cause loss of hardship to the plaintiff, and it would unnecessarily result in multiplicity of proceedings. These aspects were not at all considered by the court, and the order passed by the courts needs to be set aside, and the petition is entitled for injunction as sought for in the IA. Next para, having heard the counsel for the petitioner, there is a material on record. The suit is filed for declaration and injunction. The plaintiff sought a relief in the IA seeking injunction not to alienate. According to the plaintiff is in possession of the property, and if the defendant alienates the property, that would cause hardship to the plaintiff. This court has perused the order passed in MA, wherein the appellate court has discussed about the earlier suit that is filed by the defendant against the plaintiff, where an injunction is granted, and the appellate court has confirmed the order passed in the said suit. In the teeth of the said order, at this stage, the court cannot consider the submission of the learned counsel for the petitioner, that the petitioner is in possession of the property, and any order of, if the injunction is not granted, it would cause hardship to the plaintiff. The trial court has rightly said that in the facts and circumstances of the case, when the ownership of the plaintiff itself has to be decided in the pending suit, which can be done only after a full-fledged trial. At this stage, the plaintiff is not entitled for the relief, and this court do not find any reasons to interfere. Dismiss.
Cell number 6. Narayan Rao G for petitioner.
Petitioner in this case, my lord. The annexure J at page number 110 is the impugned order.
What is the suit for?
Suit for declaration and mandatory injunction, my lord, and application which is filed for appointment of handwriting experts under order 26/10 is came to be dismissed.
You are the
Plaintiff.
suit is of which year?
Suit is of the year 2016, please, my lord.
What is the present stage?
Present state is set down for argument.
And what is why you want that document to be sent?
I taken a contention that the sale deed alleged to be executed by the one Francis, who is none other than the husband of the first petitioner and father of the other petitioner, as a created document.
Was the suit filed during his lifetime?
No, my lord. It was filed in the year 2016. He died in the year 2014. The document has been created by the first defendant. We have taken a contention that the sale deed was a fabricated document.
Let's see the order.
Please, madam. It's page number 110, please, madam. 110. The reasoning.
Yes. 12.
112, please, madam. The para number 6. The specific contention of the plaintiff is that the sale deed dated 12/1/1993 alleged executed by late Francis is a created document, and the scientific comparison of signature of thumb impression is necessary for proper adjudication of the suit. And para number 7. Per contra, defendant number 2 has categorically contended that similar application were earlier filed and dismissed. That the plaintiff has been repeatedly filing application after completion of cross-examination only to delay the matter, and that the present application lacks bona fide. On careful consideration of the pleadings, objections, and materials placed on record, this court finds considerable force in the objections raised by the defendant number 2 for the following reason. Firstly, the record discloses that the plaintiff had earlier.
So earlier application that was filed are also dismissed.
The earlier application findings was recorded by this trial court. It was filed before completion of the evidence, please, madam. And they have produced that order also. It is at page number.
They are referring to successive applications. How many applications you have filed?
So only one. After that, this is second application after completion of the evidence, please, madam. After completion of both the parties' evidence, this is the application which is.
Where is that order?
Earlier order is page number 65, please, madam. Annexure D. Sorry, not annexure D. Is annexure E at page number 70, please, madam.
Page number 70.
Page number 70. The reasoning recorded at page number 72. In the middle of the portions, after 4 or 5 lines, it has observed that in point number 1, reasoning, please, the defendant appears and contested the matter upon the pleading necessary issues has been framed. Now the matter is posted for cross-examination of PW1. At this stage, present application is filed by the plaintiff for appointment of court commissioner for the purpose of
comparing. The finding at page number 9.
Please,
it doesn't. The court, there is no finding on that. That because no, the evidence is not completed, so I'm not entertaining that application. The court has given reasons.
For that purpose only it was rejected.
No.
In the next paragraph.
Come to paragraph number 9.
Paragraph number 9 also in the 4th line onwards, please, my lord.
Read. It is worth to mention.
It is worth to mention here that the purpose of comparison and referring the documents to scientific expert is also not forthcoming for the application. Therefore, such broad grounds cannot be entertained by any stretch of imagination. This is case of the year 2016. Almost 9 years has been lapsed. The next line is most important, please. The plaintiff has not completed his evidence for the reason best known to him. Under these circumstances, it is prima facie appears that the application filed by the plaintiff.
Agreed by it, you should have questioned it.
I have not questioned it because I have.
That's not how the proceedings go on.
The issues has been raised in respect of that, please, my lord.
We will not open it now.
The issues has been raised, and the core dispute between the parties is in respect of the sale deed, and I have produced the admitted signature documents also before the trial court, please, my lord.
When the earlier application is dismissed.
The
is it
earlier
a question
application
that-
was dismissed not on the merits. There is a clear
No, it
observation.
has dismissed
and-
that, it is only court do not find any reason
And
to
more
do it.
particularly, the defendant has not produced the original sale deed, and the original sale deed was produced after I.
What are you doing till the arguments, the matter is posted for arguments?
No, after completion of the evidence, immediately I filed an application, please.
When was the evidence completed?
Very recently, immediately after.
Date for,
Immediately after
recently.
the next date only, I have filed an application, please. After completion of the defendant evidence.
When is the evidence completed? Give me the date.
And then the application was filed on 22/1/2026, please, madam. And before the 22/1/2026.
When is the order passed?
This was the order passed on the 23rd February 2026, please.
So this itself shows the manner in which you are approaching. Now, matter is posted for arguments.
Please.
Order is passed on 23/2/2026. When is this writ petition filed?
Writ petition immediately after, please, madam.
Then
On 13/3/2026.
it's coming of today.
Please, madam. First time.
Because when were the office objections complied by you?
Very recently, my lord, and subsequently some
So,
objections are raised.
this all the more reason for dismissing your application, which is
very-
only, your only intention
The
is to
issues may kindly
tag
be-
on the proceedings,
issues-
nothing else.
Issues may kindly be taken
When
up.
was, when the office objections were complied with?
Very recently as complete.
Will not consider, Mr. Counsel. Will not allow these.
The one
kind
of the order by the trial court,
No,
page
there
number
are no
6
bona fides. You don't,
65.
you have no intention to, what you want is some application to be filed here and drag on.
Not like that, my lord. My relief is sought. It's only for the declarations declaring that the sale deed is void, and the issues
And
are
nobody
framed.
nobody stopped you from being vigilant.
Issues are framed, my lord, and issues are at page number.
Is it complied?
There is a clear issues. So there is a burden on me. There is office objections were raised in respect of service of the KVA documents, please. Documents to the KVAtor.
No, it is still there are objections on that day. When is that? None appears, list after 3 weeks. Will not allow, Mr. Counsel.
The issues at page number 62 may kindly be.
No.
Please, my lord.
Court should never come to the rescue of a litigant who is not vigilant and who is trying to.
After
protract
completion of the
proceedings.
evidence only, I have filed an application.
No. There are no bona fides, absolutely no.
Very
bona fides.
recently, immediately
come.
after dismissal of the application, I approached the sample.
The
court,
writ
please, my lord.
petition is filed. Agreed with order passed on I number 16 in OS number 1588 of 2016 dated 23rd February 2026. The petitioner is before this court. The petitioner plaintiff has filed the suit seeking declaration that where is the plaint?
The client is at page number 13, please. 15, please, madam.
Seeking a declaration that the plaintiff is an absolute owner of the sue Schedule A property, to declare that the sale deed alleged to have been executed by the deceased Francis in favor of the defendant dated 12/1/1993 as null and void and not binding on the plaintiffs. And also a declaration that the sale deed executed by the first defendant in favor of defendant number 2, which is as not binding on the plaintiffs, and also sought for a mandatory injunction directing the defendants to demolish the entire construction put up on the B schedule property. And also another relief is to hand over the vacant position, seeking damages, mean profits, and also a relief of permanent injunction. In the said suit, the plaintiff has filed the present IA under order 26 rule 10A, read with section 151 CPC, seeking appointment of handwriting and thumb impression expert as commissioner for scientific investigation to compare the disputed signatures and thumb impression of late Francis found in the sale deed dated 12/1/1993, produced by defendant number 2, with the signature and thumb impression found in exhibit P14, P17, and also to obtain an expert opinion regarding genuineness of the signatures and thumb impressions that came to be dismissed by order impugned. Next para. While dismissing the application, the court has observed that the plea of repeated applications raised by defendant number 2 has not been effectively rebutted by the plaintiff. Successive applications on the same issue, particularly after dismissal of earlier attempts, prima facie attracts the bar analogous to res judicata and certainly reflects an attempt to reopen settled stages of the proceedings. Fourthly, the conduct of the plaintiff in filing applications and application at an advanced stage of trial strongly suggests an intention to prolong litigation. Courts cannot permit procedural provisions to be misused as tools of delay. Judicial time is valuable and abuse of process must be curbed firmly. Lastly, the court itself is empowered under Section 73 of the Evidence Act to compare signatures, if necessary, along with other evidence on record. Hence, absence of expert opinion at this stage does not render adjudication impossible. Accordingly, dismiss the IA. Learned counsel appearing for the petitioner plaintiff submits that earlier application is filed before the evidence during the course of evidence, and now this application is filed after the evidence is concluded. When the dispute itself is that they are denying the signatures of late Francis on the sale deed, and according to them, it's a fabricated document. Unless and until the expert opinion is sought, it cannot be clarified. It is further submitted that the court, without considering all these facts, dismiss the application. Next, for having heard the grounds for the petitioner, peruse the material on record. Earlier, this is an application filed to send the application under Section 26 Rule 10A to appoint an expert for comparison of the signatures on the sale deed. Earlier, petitioner has filed I number 2 that came to be dismissed by order dated 27 January 2025.
IA number 12, please. IA number 12.
IA number
12.
IA number 12 came to be dismissed by order dated 27 January 2025. The court, while dismissing the said application, has observed that it is worth to mention that the purpose of comparison and referring the documents to scientific experts is also not forthcoming from the application. Therefore, such bar grounds cannot be entertained by any stretch of imagination. The court cannot entertain the cases of the year 2016. Almost 9 years have been lapsed. The plaintiff has not completed his evidence for the reasons best known to him. It prima facie appears that the application filed by the plaintiff is only with an intention to protract the proceedings and to cause delay in disposal of the suit, and accordingly dismiss the IA. Land counsel for the when this court has asked the counsel for the petitioner why that order earlier filed by the that's IA number 12 is not questioned, there is no probable explanation forthcoming. When earlier application is filed and the same is dismissed, and court has not given liberty to him to on the ground that observing that once the evidence is completed, then they can come up with the application. And now the second application is filed. This also the court observed that only this is filed to delay the proceedings. Thus, that finding of the court further strengthens by the conduct of the party. This order is passed in the month of January, that is 22/1/2026. Then the writ petition is filed on 23 to 2026. Till recently, the petitioner has not, the petition has complied with the office objections recently. This matter came before the court on 22/4/2026. The court has observed that none appears, list after 3 weeks. Then after that, the office objections. Then on 1/6, the matter was directed to be listed for orders before the registrar. Then on 8/6/2026, again, the registrar, as per the note of the registrar, it shows that office to verify whether needful done is done. If needful is done, post the matter before the court. Then finally, the matter came up before the court today. Considering all these aspects, number one, that the petitioner has not questioned the earlier order. Number two, at every stage, there appears to be the intention of the petitioner to delay the proceedings. And on all these counts, this court is not inclined to entertain this petition. And the trial court had rightly dismissed the petition. There are no grounds to interfere. Yes?
Cell number 7. Harish Kumar MS.
Kindly pass over the meeting.
Again, yesterday, then afternoon, he will not be there.
Sorry, ma'am, sorry.
And again, it will come tomorrow next day.
No, ma'am, kindly pass.
Afternoon, please be there at 4 o'clock. Yes, next.
That may kindly call it tomorrow.
Huh?
One parted matter, 2:30 minutes.
Yes, tomorrow in the first place. Yes, 9.
Cell number 9. Cell number 8.
Interim, kindly extend.
Huh?
Kindly extend interim order. Kindly extend the interim order.
Interim order earlier granted is extended. 8.
8. Chandahasa G for petitioner.
It's a defendant's petition. It's a defendant's petition. The plaintiff has filed a suit for partition and they have filed application under order 6 rule 17. The amendment they have sought is to include some scheduled properties. They have sought to include some 18 scheduled properties in the plaint. And the trial court by the impugned order has allowed the said application. My only
Suit for partition.
partition, please.
Why you should not be allowed?
But it's a settled proposition of law that the court cannot presume a property to be a self-acquired property. The onus is on the plaintiff to prove that the property is an ancestral property. Without any particulars or without producing any documents, the plaintiff has filed the application. And the trial court...
Ultimately, it is for the plaintiff to prove that those properties are the ancestor, that is a joint family properties.
Please.
So that will be done during the course of trial.
Please, the practical difficulty is the property was self-acquired property by different number 1, that's the petitioner herein. And
No, according to you, that has to be decided at the stage of order 6 rule 17 itself.
please, madam, my submission is I've sold the properties to the purchasers. And our practical difficulty is that if the said application is allowed, all the purchasers will point out finger at me and the suit will be delayed, my lord, because they have to be implicated in the suit. Around 18 purchasers have to be implicated in the suit and the suit will be prolonged. Due to the fault of the plaintiff, I have to suffer.
The issue is whether the court at a stage of order 6 rule 17 will decide whether these properties are self-acquired properties or joint family properties.
But I produced the registered sale deeds to show that they
You
are
have sold it.
Please.
When you are not the owner and you have sold the properties, and if it's a joint family property, then the consequences will fall.
Please. My only submission is let the order be stayed, not let the proceedings continue on.
Why should we stay?
Because of the fault of the plaintiff, the defendant have been suffering.
You have to convince the court. This is what I'm not convinced. That's what I said.
Please.
Whether you have to tell the court
If your
at the
lordship
stage
may-
of order 6 rule 17,
Please.
all this exercise should be done or not. If it is not, there is nothing wrong.
But there is no merit in the application itself.
Let's see.
Please.
Come to the order.
Before going to the order, may I pursue your lordship the application filed by the plaintiffs, please. The application is on page 56, annexure D.
Hmm. I've not seen it. Yes. Application is at?
Page 56, annexure D.
Yes.
That for the reasons stated in the accompanying affidavit, the plaintiff above name most respectfully place that the honorable court may please to permit to amend the plaint, the proposed amendment, all of the scheduled properties. The affidavit
No,
is
you
at
have to
page
come,
6.
affidavit, come to
Please,
the affidavit.
page 63.
Let's read.
Para number 2. I further submitted previously my earlier counsel had filed 2 interim applications seeking additional sum of the properties which are pending for consideration. But subsequently, some more properties were identified and obtained the supporting documents to substantiate my contention that the said properties were acquired by different 1 to 4 and also proposed different 5 to 6 by the income by down payment business. This is the only reason they have given. The only reason they have given is that I acquired the proper documents subsequently and therefore I filed the application now. My objection is at page 67, my lord. 67, wherein I pointed out each and one scheduled properties, and I've pointed out that every scheduled properties which I am seeking to amend have been sold to the respective purchasers. I have also produced the sale deed before this honorable court also, the registered sale deeds.
No, that is true.
Please.
But that cannot be a ground.
Please.
Yes, please come. Agreed with the order passed in I number, what is this, 7 and 9?
The impugned order is the passed on I number 9. The I number 7 was filed under order 1 rule 10 to implead that we have not challenged the order.
The plaintiff has filed I number 7 under order 6 to 17.
7 and 9.
Right.
It's at page 16. I have challenging the order passed on I number 9, which is under order 6 rule 17. I number 7 was filed under order 1 rule 10, which I am not challenging the order, which I have not challenged.
No,
That's the issue, my lord. The purchaser has been impleaded.
Not by, first of all, he'll amend the plaint and he will include, by amending the plaint, he will include the properties. Those are all like it is consequential to the other. They're not independent.
Please.
Unless he amend the plaint, then only he will include. Yeah, that's why he has filed 2 applications.
Please, my lord.
Agreed with the order passed in I number 7 and 9. Whereby the petitioner, the plaintiff has filed an application, agreed with the orders passed in I number 7 and 9. It's 560 of 2017, dated 28th August 2025. By the 3rd Additional Senior Civil Judge JMFC at Nelamangala. The defendant number?
1 and 2.
Defendant number 1 and 2 are before this court. The respondent, which respondent? First respondent is a plaintiff.
First respondent, the only sole respondent.
First respondent here, and who is a plaintiff in the suit, has filed a suit for partition. That is OS number 560 of 2017. Now the present IS came to be filed to include certain properties as scheduled properties, and also by amending the pleadings. It is a case of the plaintiff that he has come to know that these properties, that item number 41 to 59, are purchased by defendant number 1 to 4 and proposed defendant number 5 and 6 from joint family income and from part of the joint family properties in which the plaintiff has a legitimate share. That order, the court has allowed the said IA. Agreed by that, the defendants are before this court. Next para. While allowing the application, the court has observed that it is well settled law that while considering an application for amendment of the plaint, the court should not go into the correctness or falsity of the allegations made in the amendment. The merits of the contentions raised by either party are to be adjudicated only at the stage of trial. At this stage, the court is only to see whether the amendment is necessary for determining the real question in controversy between the parties, whether the proposed properties sought to be included are joint family properties or self-acquired / absolute properties of the defendants or female members under section 14 of the Succession Act, is a pure question of fact which can be decided only upon evidence during the trial. Merely because the defendants dispute the character of certain items of property, the plaintiff cannot be precluded from including them in schedule. If excluded now, it may lead to multiplicity of litigation, and accordingly court has allowed both the applications. Next para. When counsel appearing for the defendant submits that the properties or the self-acquired properties of the defendants, and they have sold the properties. The defendant, by way of in his objections, are placed before the court. The sale deeds that are executed. The application is filed only to harass the defendants and it would cause a lot of prejudice to the defendant as they have sold the properties, and the defendants will be, the purchasers will be pointing out at the defendant. It is submitted that the court ought not to have allowed this application by including the self-acquired properties of the defendants as part of the suit scheduled properties, and the order impugn needs to be set aside. Next paragraph. Having heard the counsel on the side, producer material on record. An application is filed under Order 7, Rule 7, and Order 6, Rule 17 to amend the plaint and also to include certain properties as a suit scheduled properties. According to the plaintiff, they came to know that these properties are sold or are purchased from the joint family, from the income derived from the joint family property, and as such he has got a share in the same. The contention of the defendant that it is a self-acquired property. If that is so, that can be decided by the court, that can only be decided by the court during the course of the trial. As rightly observed by the court, at the stage of an application under Order 6, Rule 17, court cannot go into the merits of the matter and decide the rights of the parties. The court has to only look at whether the amendment is necessary in the facts and circumstances. And if the amendment is not allowed, what is the prejudice caused to the parties? These aspects were rightly considered by the court and rightly allowed the application. And this court finds no reasons to interfere. Accordingly,
Lordship may issue directions to dispose of the suit early.
Which year is the suit?
2017, my lord.
Which court?
Bengaluru Rural Court.
Yes, next.
Please.
Number 9. Harsha Kumar Gowda.
For the petitioner, my lord. My lord, the petitioners are the plaintiffs before the trial court, my lord. The suit is for the permanent injunction, my lord. My lord, I filed the suit for permanent injunction along with the IA, my lord. Sought for the temporary injunction, my lord. The emergent notice has been issued, my lord, against which I am before.
When the summons are returnable, Lord?
Summons are returnable, my lord, on 4/6/2026, my lord.
It must have been written by this time.
Yes, my lord, but they are taking the time, my lord. They have not filed the return statement. So, my lord.
Where is that order? The petitioner is agreed with the order dated 24/4/2026, dated by the Chief Civil Judge and JMFC Nelmangla, Bangalore Rural. Thereby, the court had issued summons to the defendants without considering the IA that is filed seeking ad interim injunction. Expert. Learned counsel for the petitioner submits that when an IA is filed seeking ad interim injunction, the court has to look at shall consider the application on the merits of it and cannot adjourn the matter. If the parties agreed by any order, he would get an opportunity to question the same. And the issuance of summons without considering the IA is bad. This court, he has relied on an order passed by a coordinate bench of this court. That order from Prabhu Ute, order dated so and so. In the light of the order passed by but this court so and so. This court is passing the following order. The order dated so and so is set aside. The trial court shall consider the application of the petitioner on the merits of it and pass appropriate orders within a period of 1 week from the date of receipt of the copy of the order.
Then number 10, Mohan K.
See, there's no notice is issued to the respondents because no adverse orders are passed against.
For the petitioner, my lords, for the death of petitioner husband, she has claimed compensation before the.
Which is who are the respondents?
Respondents are MESCOM, my lord.
MESCOM who appears for who is the signing counsel?
HV Devraj.
He appears for this also.
Yes, my lord.
So
Earlier also he has appeared in this.
So is directed to take notice on behalf of the respondent and counsel the petitioner shall serve the copy of the writ petition. List this matter in the first list tomorrow.
My lord, Monday, my lord.
Registry is directed.
Monday. I will serve kindly tomorrow.
That's what tomorrow I said.
Monday, please.
We want a Monday. Yes, Monday. He shall serve the copy of the writ petition on the council. Registry is directed to print the name of Mr. Devraj.
Cell number 11, Champanna.
For the petitioner,
petitioner is a plaintiff in a suit for partition, my lord. And also sought for declaration that alleged relinquished deed is not binding on the plaintiff. In Order 7 Rule 11 application, though application is really dismissed, court has directed to value the suit and pay for court fee. That is not correct. In Order 7 Rule 11 application, court cannot direct, though application is dismissed, my lord. Your lordship may kindly see the order in page 48. 47, page para 13, my lord. 47, in page 47, para 13. From the rival contention, it is observed that the plaintiff in the plaint has disputed the execution of release deed dated 16/8/2018, alleging that the said release deed has been created by the defendant number 2 to 4 by forging the signature of the plaintiff without the knowledge of is denied by the defendant. Hence, the question of execution release deed as alleged by the plaintiff and defendant has to be determined only after completion of the trial. Since the plaintiff has submitted.
On what ground you have filed the application under Order 7 Rule 11?
I am opposing that application. I am the plaintiff. Defendant has filed that application. For cause of action, for want of cause of action and barred by law.
No, as far as the court fee is concerned.
Court fee have paid.
No, the court says that is what to file fresh valuation slips for the relief of so and so.
Valuation slip is also filed. So court wanted to seek another relief for declaration and it is the right of the plaintiff to seek relief. Your lordship may kindly rightly have petitioned.
Notice to the respondents, petition.
In portion, second portion only I have not
That's right. Notice to the respondents.
Your lordship may kindly see, this is the problem. Every date of hearing, court is imposing 1,000 rupees cost. Your lordship, final order, your lordship may kindly see the second portion of the order. The plaintiff is directed to file fresh valuation slip, relief cancellation of registered deed, so and so, directed to pay the court fee by next date. This portion is only sought for, otherwise every date of hearing imposing cost, my lord.
Why you are not, for what it is imposing cost?
For not filing the valuation slip.
When was the order passed?
6/4, my lord.
Now already submits that in an application that's filed under Order 7 Rule 11, while they are rejecting the same, the court has passed the order directing the petitioner to file a valuation slip. Valuation?
Fresh valuation and pay the court fee.
Pay the court fees. It is submitted that the court has court cannot pass such an order while rejecting an application under Order 7 Rule 11, and it's for the plaintiff to court to seek the reliefs. Considering the submission, there shall be stay of all further proceedings pursuant to the order dated so and so.
Only that portion, my lord. Let the
notice the respondents. Petition is permitted to take out hand summons and file a memo to that effect by 16th of July, or else the stay granted by this court stands vacated.
Tell number 12. Ketan Kumar, petitioner.
Defendant's writ petition, my lord.
Yes.
Suit is one for specific performance of an agreement to sell. For a moment, my lord, your lordship may kindly peruse, my lord, the agreement for sale. My lord, please, my lord.
What is the idea?
It is about importing a document, my lord, GPA. On insufficiently stamped document, the court's order. Your lordship may kindly turn to my lord. It is about importing of GPA. Sale agreement may kindly be perused, my lord, at Annexure D for a moment.
No, we'll look at the order, then we'll go to that.
Yes, yes. Order, my lord, is at page number 18.
Yes.
Order on stamp duty of the GPA. The counsel for the defendant has filed IA number so and so under section. Before that, my lord, while my lord, we objected for marking of this GPA and said that it is impounded, they made an application for withdrawal of the document. They will take back the document. That application came to be rejected, holding that it is once they produce it, my lord, they can't take it back and stamp duty is payable. Thereafter, my lord, the court decided that order is, my lord, earlier order is, my lord, on 18th of September.
Before page.
Before page, previous page, 17. Page 18 onwards, court's order on impounding of GPA. The counsel for the defendant has filed IN under section 33 of Stamp Act, praying to impound the original GPA dated 18/1/2018. On perusal of the document, it is seen that it is executed on 18/1/2018, conferring of the powers of the GPA holder, that is the plaintiff, to convey the scheduled property. Article 41 of the schedule to the Karnataka Stamp Act deals with the power of attorney. 41E states that stamp duty is the same as a conveyance under section Article 21 on consideration on market value of the property, when given for consideration or coupled with interest and authorizing the attorney to sell any new property. In the case on hand, the document reveals that the GPA was executed by the defendant along with an agreement for sale in favor of the plaintiff with respect to the scheduled property. Therefore, the attorney was given coupled with interest. The proviso to Article 41 says that the duty paid on our agreement is adjustable towards the duty payable on power of attorneys if executed between the same parties. There is no dispute, my lord, that if it is paid in the agreement, it is adjustable. On this footing, my lord, in the case on hand, the parties to the GPA and the parties to the sale agreement are the same. The scheduled properties are also same. The court has already ordered the plaintiff to pay the deposit of 28,000 of the agreement for sale, and the plaintiff has paid 30,800. Therefore, applying the provision under 41E, the same is adjusted toward the stamp duty, so and so, so and so. So the court says the stamp duty payable on the GPA is adjustable toward the stamp duty paid on the agreement for sale. This is, my lord, the settled law. There is no dispute about it. Now, my lord, your lordship may kindly turn to Article 41E, my lord, for a moment.
About the amount.
No. In both, my lord, it is not paid. That is my submission. Court overlooks it. In the agreement for sale also.
It has to be paid. You please tell the court.
My lord, no, for sale agreement, my lord, 5% of the 30 lakhs is the consideration.
That is 30,000. How much is that? What is 5% of it?
5% of it will be come into 1.5 lakhs, my lord.
1.5 lakhs.
And 10 times penalty.
Where is that order? Earlier order?
Earlier order is also, my lord, the courts.
Not questioned.
That is also questioned in writ petition.
Where is that?
In 31244 of 2024.
Let's have both. The counsel is appearing in that.
Yes, in that he is appearing.
We'll have both so that we'll pass an order.
Yes, my lord. So
just along with
the matter is now posted, my lord. Both are, my lord, orders with error.
No, I'll have it tomorrow.
Tomorrow. Great.
Just along with
WP 31244.
So and so.
Yes.
Because now.
Yes.
We have to, if that order is
Correct,
not
correct.
set aside.
Yes.
We can't pass any order.
Yes. That is also, I'm having the copy.
Just along with so and so tomorrow.
31244 of 24.
Yes, next.
Number 13,
Appearing for petitioner minutes.
Bishop Raj.
Yes.
Lords, petitioners are defendant number 3 and 4. They are admittedly a transmission licensee granted powers under sections 164 of Electricity Act.
Petitioner.
Yes, petitioners who are defendant number 3 and 4. Now a suit comes to be filed before London Trial Court at Bantwal. This line is a 400 kV line which is going from Woodby to Kasaragod, ISTS, Interstate Transmission Line. Suit is filed for injunction on 12th of January 2026. 14th of January, an ex parte temporary injunction is granted. Subsequently, I enter appearance, I advance the matter, and I file my written statement along with.
What is that injunction granted? Let us see that order.
Yes, my lords. Injunction order can be filed, can be found at ink page 73. Order on IA number 3.
Can the civil court grant injunction?
No, that is what my submission is. They do not have powers under specific relief act.
Let's see 73.
Ink page 73.
Let's see the reasoning.
If I may read, I will read the last para directly. The present suit is filed by the plaintiff.
Plaintiff order from restraining the defendants, claiming to and so from anywhere forcibly drop 400K electric line.
Over and above the plain scheduled properties or in any other matter till disposal of the above suit in the interest of justice and equity. Peruse the plain governments of affidavits annexed to IA number 3 and also.
There be such an order.
I'm saying because we have, before the trial court, government has taken the stand of.
Same, they have adopted my.
We have adopted their written statement.
Written statement. This is, and see, irony is not that, my lords. Irony is not this, that stay has been granted.
Will first of all, we'll suspend this order.
I'm sorry, my lords.
We'll stay the operation of this order.
Please.
Let them come. Will issue notice.
See, I have filed a memo also along with my written statement wherein I have produced a judgment by Dharwar bench of this honorable court, which extracts the circular passed by honorable High Court that these matters have to be heard by designated special courts.
Special court is principal district
And
judge.
special court is principal district judge.
And that too, they
And
cannot.
despite that, it is heard in the month of March, posted for orders on 6th April, and from 6th April till
Which court is this?
this is my lord's principal civil judge Bantwal.
Bangalore.
What you can do is, where is that circular? You have the circular?
Yes, my lords, I will just show you.
Now give it to the court officer, the circular, court officer. This order at page 70.
That circular is at 104.
Here only.
It is extracted in the writ petition order of Dharwar bench. Page 104, ink page 104. And this Dharwar bench judgment is very clear that as soon as the trial court becomes aware of the fact this is an infrastructure related suit, it has to immediately transfer. And from 5 months, orders are not passed and simply the matter is getting adjourned for orders.
And also this order, page 70, take a printout of it and give it to the R&S. Yes. Please come. The petitioner is the Udupi Kasaragod Transmission Limited, which is the defendant number, only defendant.
3 and 4.
Defendant number 4.
3 and 4 minutes.
Defendant number 3 and 4 in this suit. The petitioner is laying a 400 kV transmission line.
Please.
400 kV transmission line. And the suit for injunction is filed. Seeking a suit for injunction is filed, seeking a direction restraining the defendants from laying the lines, transmission lines in the plaintiff's land. And along with the suit, they have filed IA number 2, seeking.
IA3 is the 3912. IA2 is to seek exemption to government notice.
IA number 2 is filed, seeking dispensation of statutory notice. I number 3 is filed.
Order
seeking
39.
Injunction. Injunction restraining them from forcibly drawing 400 kV electric line over and above the plain scheduled property. The court has granted injunction. While granting injunction, the court observes that after going through the material available on record at this stage, court is of the considered opinion that the plaintiff has made out a prima facie case for grant of an ad interim ex parte order of temporary injunction as prayed, so as to mitigate future complications. Further, the very purpose of granting injunction will be defeated by the delay. Considering the extreme urgency made by the plaintiff, the notice on I number 3 to the defendants as contemplated under Order 39/3 CPC is dispensed with. Next, Learned counsel appearing for the petitioner submits that petitioner has entered appearance on. Mr. Counsel.
Yes, madam. 24/2/2026.
24/2/2026.
And on the same date, I have filed my written statement, my memo of adoption for IA number 3 and a memo
He
to
has filed a petition, a written statement and an IA seeking to vacate the interim injunction that is granted. It is a grievance of the petitioner that in spite of repeated orders passed, in spite of repeated requests made by the petitioner, the said matter was not heard by the court so far. He has relied on the judgment passed by a Dharwad bench in, where is that order? Page?
Dharwar bench order, my lords, it's at ink page 104 is the circular.
But Dharwad bench order in arising out of WP number 102751 of 2024 in case of Sri Sarentika Renewables India Limited versus Sri Basappa dated 16 July 2024, wherein the court has referred to the circular dated 4/11/2020 issued by the High Court, wherein the principal city civil and session judge Bangalore City and orders the principal district and session judges in the state are directed that one specific day in a week shall be dedicated for the trial of suits pending before the existing designated special courts under section 20B of the Specific Relief Act on priority basis. It is submitted that only the special court has got jurisdiction to hear the suit, but what is this court?
This is principal senior civil judge.
The principal senior civil judge.
Principal senior civil judge.
The
Principal civil judge.
principal civil judge
And JMFC. Bantwal.
Bantwal has passed this order. This court has perused the order, the circular, the circular, the order passed by the civil judge, and also by way of injunction, the trial court has restrained the petitioners, defendants from laying the electricity line, which is in the larger interest of the public. In these circumstances, the order impugned, the operation of the order dated so and so is stayed until further orders. Notice to the respondent's petition is permitted to take out hand summons and file a memo to that effect. Huh? What is that? You are for respondent?
State, my lord.
All the respondents, sir.
One to
AG takes no, the
2 and 3, my lord.
2 and 3.
2 and 3.
AGA takes notice on behalf of
2 and 3, my lord.
2 and 3. Notice to first respondent.
Please.
My lords, I have one more submission. The trial court matter is tomorrow. If the order can be released online today, I can file it before the trial court tomorrow.
Today. Yes, next.
Please, grateful.
Serial number 4.
Previous matter, 12. The Lakshmi said there are connected matter tomorrow. Lakshmi, kindly say my lord, first list tomorrow.
I said first list.
I'm sorry. Grateful.
Serial number 14, Kishore Kumar. Petitioner.
Kindly pass over the matter.
Yesterday also passed over.
My lords.
It came up yesterday also.
Yes, my lords.
Yesterday also passed over.
No, my lords. It was heard and it was listed for today.
Serial number 15.
I think in all these order sheets, this passover should also be noted. Who asks everyday passover, that will adjourn it after January next year.
Serial
Yes.
number 15.
Lords, arguing
Prabhakar
counsel is in court
Kulkarni.
110, my lords. Kindly grant me a passover, my lords.
Did this file?
This is fresh matter.
Yes,
It's a
tomorrow.
fresh matter.
Oh, no, passover. Yes, next.
Serial number 16. 16. Yes,
Petitioner, my
Rajshekar.
lords. My lords, the suit is for partition and separate possession, my lords. The plaintiffs, the respondent 1 and 2 herein has filed the suit. Then along with the suit, they have filed IA number 1 and 2. IA number 2 is for under Order 39 Rule 1 and 2. Thereafter, on 10/11/2025, the trial court has granted ex parte ad interim order of temporary injunction against the defendants. I am petitioner, defendant number 1 in the
What's the injunction?
my lords,
Injunction date?
10/11/2025, my lords. I am petitioner, defendant number 1 in the suit, my lords. Thereafter, defendants entered the appearance and they have filed the written statement. Defendant number 1 filed the written statement on 24/11/2025 and defendant number 4 to 8 adopted the same, my lords. Objections were also filed and the matter was IA number 2 was also heard, my lords. And thereafter on 8/1/2026, it was posted for orders on IA number 2, my lords. IA number 2 and 3. Here we are challenging only IA number 2. IA number 3 is for amendment of application. From thereafter, my lords, the trial court has been repeatedly adjourning the matter, my lords. It has been adjourned for over 6 times. On 21/2026, 30/1/2026, 9/2/2026, 12/3/2026, 16/4/2026, and 11/6/2026. The next date is on 1/7/2026, 2026, my lords.
My lords, under 39 Rule 3A of CPC, it mandates for the trial court to dispose of the IA on temporary injunction within 30 days, my lords. Even if it is delayed, the trial court has to state reasons, my lords. My lords, kindly see the annexure A, my lords. In the order sheet, the trial court has not stated any reasons for the delay, my lords.
Please come. The present writ petition is filed seeking a direction to the second additional senior civil judge and CJ Mangalore to dispose of application filed by the petitioner under 39 Rule 3A dated 30/10, 31/10, 2025. It is a case of the plaintiff, it is a case of the petitioner that the IA was filed. IA was filed. You're saying, I think, what is this? Prayer, look at the prayer. You are the defendant in the suit.
My lords. Prayer directing the I number 2 filed by the plaintiff, my lords.
What is that filed by plaintiff?
For temporary injunction, my lords. I number 2 is under 39 Rule 1 and 2.
You are?
I am defendant number 1, my lords, in the suit.
Interim injunction is granted.
Yes, my lords. Like, the matter has been heard on I number 2 after appearance of the defendant, my lords, once again. The interim ex parte injunction has been granted.
No, you want your IA.
Orders
that
to be
is
passed,
filed,
my
huh?
lords. Orders to be passed by the trial courts, my lords.
On your application to vacate that order.
No, my lords. I have not filed to vacate the interim order. My lords, after they granted the interim injunction order, the defendants appeared and the matter was heard on IA number 2, my lords. After that, it has been posted for orders on IA number 2 and 3, my lords.
Where is IA number 2?
My lords.
IA number 2.
IA number 2 is at page number 37, my lords. The order on I number 2 is at page number 14.
I think something wrong with this page. What is the case number? 18928. Page number?
That's IA number 2 is at 37, page number 37. Orders on IA is at page number 14, my lords.
Page number 40?
Yes, my lords. 14. 14 is orders on IA number 2.
14.
Yes, 1-4. My lords, on page number 16 on 24/11/2025.
Yes. Please come. What did you write? seeking an interim injunction, and the court has granted injunction on 10/11/2025. Thereafter, all the defendants have entered appearance and filed their respective written statement and objections by 24/11/2025 and 8/1/2026.
Yes, my lord.
8/1/2026, and on one pretext or the other. Thereafter, I number 3 is filed by the plaintiff seeking amendment of the plaint, and the court, without passing any orders on I number 2, one after the other, the court is adjourning the matter. The learned counsel has drawn the attention of the court to the order sheet, wherein from 2020, the matter came up on 8/1/2026, 21/1/2026, 30/1/2026, 9/2/2026, 12/3/2026, 16/4/2026, 11/6/2026. And on every occasion, the court has extended the interim order and has failed to consider the objections to the IA number 2 and failed to consider the IA number 2. And it is submitted that whenever the court is not deciding deciding the IA, the court has to give reasons. And in this order, from the last several occasions, without any reason, the court is adjourning the matter by giving dates. The next paragraph. The Registrar Judicial is directed to call for a report from the concern. Why the IA, why the IA is kept pending from December, even after the defendants filed their objections and repeatedly seeking hearing on the said application. List this matter on 1st of July.
Cell number 17, Pramodar.
Not 1st, 2nd of July, in the first list. Yes.
Cell number 17, Pramodar.
No, we just have to understand sometimes what are they doing. Once we call for the report, they'll understand what is this 7-8 times, just like the TA extended. What is happening? We have to know. Which court is this? Huh? And this also, take a printout of that order sheet and ask RNS to come. Yes, next.
Second additional senior civil judge.
Second
additional senior civil judge.
Cell number 17, Pramodar.
For the petitioner, my lord. The application was rejected. Filed for seeking permission to file the return statement. By virtue of the Amendment Act, my lord, 120 days it has to be filed, my lord. On that basis, my application and along with the return statement has been rejected, my lord.
Counsel for the petitioner submits that the court has failed to take the return statement on record as the same was filed beyond 120 days. And in the light of the amendment, the same is dismissed. It is submitted that a coordinate bench of this court has stayed the operation of the amended act in the light of the said submission that numbers and are all there.
WP 9088 of 2000.
WP
9088 of 2026.
26. Give that copy.
I will furnish the copy. I don't
Not
have it.
necessary. WP
9088 of 2026.
dated.
Bar 26.
Dated, order date.
Dated, I will
You know,
check.
it is there. Ask so and so. It shall be stay of all further proceedings pursuant to the order dated so and so. Notice to the respondents. Petition shall serve the hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 16. If the memo is not filed, stay granted by this court. Stands vacated. Next 18.
Cell number 18,
Stay of further proceedings.
For granted.
18, Sharath S. Gowda.
Pass out, Your Lordship. Senior is held up in another court, Your Lordship.
Huh?
Senior is held up in another court, Your Lordship.
Karnataka Power Transmission.
1 to 3,
Devraj
H.V.
appeal.
Devraj.
Huh?
H.V. Devraj.
The petition is directed to serve the Mr. Devraju.
1 to 3, my lord. Respond 1
So
to 3.
is directed to take notice on behalf of,
R1 to 3, my lord.
1 minute,
R4, I will take notice. Page 4, my lord.
page.
4.
Mr. Devaraj is director take notice on behalf of respondents
To 3.
2 to 4. HCGP takes notice on behalf of respondent number 1. Land counsel for the petition saw the copy of the writ petition on the counsel for the
Better copy, my lord. In my paper book, they have wrong dimension.
Also have a copy.
copy of the readable copy of the writ petition on both the councils. Is this matter tomorrow in the first list? Yes, next.
19.
Order this cause list in that, I think. Yes,
Cell number 19. Ashmit Joyston.
What's under challenge is, my lords, attachment of movable warrant was issued in spite of attachment of immovable property, my lords. The immovable property which is already attached, my lords, is sufficient to meet the decree. What has happened is
the decretal amount.
decretal amount runs for 54 lakhs, my lords.
Mm.
Initially it is a cooperative societies award, my lords, that was passed. Your lordships can find the same at page 27.
Award dated.
Award dated 16/8/2021.
What is the amount?
My lords, as on that date, my lords, it is 75 lakhs 77,037 rupees. My property itself is 1.5 crores. My only grievance is that, my lords, the movable property is something that is not enough to meet the decree. But immovable property is sufficient. Now, if they move against the movable property, partially they have to move against immovable, my lords. So I'll be losing both. I do not mind the property being auctioned, and it was also attached as
Where is
auction.
that order? Let's see.
Impugn order is at, my lords, page number 20 onwards. Running page 29, my lords. 29 onwards, the order starts. Goes up till 24, my lords. 24 to 25. 24 to 25. Page number 24 to 25.
He is called out, decree holder is absent. It only said can take any steps against the judgment debtor to execute the award. Thereafter,
They have issued, my lords, at page 25, last line, issue AMW, that's attachment of movable warrant against judgment number 1 to 3.
then what did they do with regard to the movable property? No order is.
Nothing, no order. It has been attached, my lords. Award is at.
Already the movable property.
It has been attached. It is in possession of the respond number 1, my lords. I do not even have the possession of it. They have it.
Then counsel for the judgment debtor, when counsel referring to the judgment debtor, the award was passed on 16/8/2021. Later, the property of the petitioner is worth rupees 1.5 crores. And the decretal amount was 75 lakhs 77,000. The award amount is 75 lakhs 77,037 rupees. It is submitted that the property is in the custody of the respondents, and now the court has ordered attachment of mobiles. Even if the mobiles attached to the suit, the award cannot be satisfied. And the property is already, the immovable property is attached. The court ought not to have passed this order accordingly. Pass this order next for considering the submission of the land council, they should be stay of all further proceeding pursuant to the order dated. This order is dated 9/6/2026.
9/6/26.
9/6/2026. Notice to the respondents, handsome ones. Memo shall be filed by 16th of July or else the stay granted by this court stands vacated. Yes.
Grateful.
No, not necessary. Civil matter. Yes, next.
Say number 20.
I appear for the
Number
petitioner,
20.
my lords.
Yes.
My lords, the application under Order 26, Rule 9 for seeking appointment of a receiver, apologies, my lord, for the commissioner was rejected by the Honorable Trial Court, my lord.
What is the suit for?
The suit was filed by the respondent, my lords, for eviction. The contention of the petitioner was such, my lords, in the written statement that he had already handed over the possession of the property in the year of 2024 itself. If I may request, my lords, to kindly peruse.
According to you, you are not in possession of the
Not
property.
in possession of the property, my lords.
No, what is the IA, at what stage you have filed this IA?
This was after the closure of the evidence, my lord. Apart from which, if I may request my lords to kindly peruse Annexure B, which is the written statement, my lords, at para number 2, ink page number 20. Third line, my lords, from the top. At present, the defendants are not staying in the suit schedule property, nor the tenants of the plaintiffs. At present, there is no dual relationship between the plaintiffs and the defendants, have vacated the suit schedule property, and the suit for ejectment is not maintainable and liable to be dismissed with exemplary cost. Apart from which, my lords, the plaintiff have also refunded the security deposit of rupees 15 lakhs, my lords, to the petitioner, which is also admitted by them in the cross-examination. An application under Order 1, Rule 10 was filed by the people who are in possession over the property, my lords, which came to be dismissed by the Honorable Trial Court. Subsequently,
They
the
say that
petitioner.
they are in occupation of the association.
Yes, my lords. It's a third party, my lords. We do not know who is in possession of the property. It's a third party who is in possession of the property. They filed an application under Order 1, Rule 10, which came to be dismissed, my lords. Subsequently, an application under Order 26, Rule 9 was filed before the Honorable Trial Court, my lords, which I may request my lords to kindly peruse at Annexure D, my lords. At ink page number 35.
Yes.
It was for the purpose, my lords, to appoint a court commissioner to have a local inspection to the suit schedule premises to collect information from the persons or occupants who are presently occupied.
Want all this, it's for the plaintiff to prove.
The
whether you are
only
in possession
problem
of
is,
the
my
property
lords,
or not.
I understand, my lords. Issue has already been framed, which is issue number 6, my lords. If I may request, my lords, to kindly peruse the affidavit in the subsequent page at para number 3. I submit that this honorable court has been pleased to frame issue number 6. That is, whether the defendants prove that as they have vacated the suit schedule premises on 21/2/2024.
Thrust upon you.
Yes, my lords. That is the whole and sole reason why the application came to be filed before the Honorable
No,
Trial Court.
apart from seeking appointment of commissioner,
Please,
otherwise
madam.
also you can produce to show that you are saying that the 15 lakhs is refunded to you on so and so day.
Which is already admitted, my lords. Only problem is, my lords, there's no documentary proof given. They have admitted that they have returned back the 15 lakh rupees, my lords, as a security deposit to the petitioner. But unfortunately, my lords, there's no document to prove the same, my lords.
How they returned 15 lakhs?
I think by way of check or cash, I'm not sure, my lords. I'll have to get the information on that aspect, but which is an admitted fact, my lords. It's an admitted fact that they have returned back the security
How
deposit.
will they go and decide like who are staying in the premises?
That's precisely, my lords.
How he will go and, no, this application itself is very strange.
The only problem is, my lords, is
He'll
this.
go around and find out from the people whether you're staying in that or not, who else is staying.
Please, my lords. In fact, if they can make a report, my lords, saying that whether defendants were staying or not, that could happen. In fact, if I may request, my lords, to kindly peruse the order.
Come to the order.
Please, my lords. At ink page number 48, my lords, they call out an observation stating that an appointment of a commissioner cannot be rejected on the premise it amounts to a collection of an evidence, my lord. But the Honorable Trial Court goes in contra to the said observation passed by this Honorable Court, which is at ink page number 49, my lords.
Yes.
Last but 4 lines, my lords.
No, let's read that para 9 from the beginning.
Please, my lords.
In the case on hand.
Admittedly, the defendants were put in possession of the suit schedule premises as a lessee under agreement dated 3/3/2023. As per the version of the defendants, the plaintiffs have handed over the possession of the suit schedule premises to the defendants on 28/9/2023. From the said date, they were in possession and enjoyment of the suit schedule premises till 22/2024. They have vacated the suit schedule premises on 21/2/2024 and handed over the same to the plaintiffs. Though the defendants have handed over the vacant possession of the suit schedule premises to the plaintiffs, they have filed the present suit for wrongful gain. The learned counsel for the plaintiffs argued that the defendants have to independently prove that they have vacated the suit schedule premises and handed over the vacant possession to the plaintiffs. If the court commissioner is appointed for the local inspection,
If the suit is decreed, what will happen?
my lords, there,
Asking you, what
please,
will happen?
on two bases, my lord. One, that they require the suit schedule premises, which is not in possession of the defendants.
Decreed. Now
Yes,
what
my
will
lords.
happen? Now execution will be filed. What will happen?
They'll take delivery warrant to,
Which you are not prejudiced by that.
if that was
Because
the
you are
case, my
not-
lords,
You are not in possession of the property, and why are you fighting about it?
the only problem is, my lords, they have a secondary relief, which is seeking arrears of rent of 41 lakhs, which is basing upon the defendants or the petitioners staying in the premises, my lords. After 21/2/2024.
Yes, the burden is on them to prove.
Please, my lords. But there is an issue number 6, which is casted upon me, my lord. The burden is casted upon
First
me.
of all, first burden lies on them to prove that you are the tenant. Once
True,
they
my
discharge,
lords.
the next issue will come.
True, my
Whether
lords.
you prove that you have vacated the premises or not.
The only problem is this, my lords, in this
Even
aspect.
no, they also should ask for that. No, if in every suit, if these kind of applications are filed, saying that the locality people, you talk to everybody and, record a finding who is in possession of the property.
Please,
Then
my
the
lords.
courts are not required at all.
My lords, I'm not seeking for a locality person to be examined, my lords. If the court commissioner can actually go into the premises and just find out who is residing.
Please come.
If not, may I seek for a liberty to have additional documents, if at all, my lords, to prove issue number 6.
That we will not decide in this. You file an application.
In fact, what happens, my lord, if I file an application,
We'll see which order, which IA is this?
IA number 4, my lords.
The present petition is filed, agreed with the orders passed in IA number 4 in commercial OS number 831 of 2025, dated 9th June 2026.
May I make one submission at this stage? They have taken the premises not for personal residence. It is a service apartments. Therefore, if he were
So he
to,
won't be in possession of the property.
therefore, the person who has taken on lease cannot be in possession because it is a service apartment.
Yes.
By appointing the commissioner, how could he know?
No, anyway, I'm dismissing it.
Yes, my lord.
Yes.
But-
IA number. So and so in commercial OS number 831 of 2025. Dated 9 June 2026. The defendant is before this court. The respondent herein has filed a suit for eviction and for damages or.
Please, my lords. Arrears of rent and damages.
Arrears of rent and damages. After the evidence on behalf of both the parties concluded, the present IA came to be filed seeking appointment of an advocate court commissioner to prove the issue number 6 in the suit. That is whether the defendant has vacated the premises for local inspection to ascertain the persons who have been in possession of the suit scheduled property. That came to be dismissed by order impugned. While dismissing the application, the court has observed that
At ink page number 50, my lords.
the court has observed that it is specifically stated that the defendants have vacated the suit premises on 21/2/2024 and the plaintiffs have repaid the security deposit amount of rupees 15 lakh. Concerning the defense raised by the defendants, the court has framed the issue and casted burden on the defendants to prove that they have vacated the premises on 21/2/2024. If the defendants have vacated the suit scheduled premises on 21/2/2024 and plaintiffs have repaid the security deposit, the same can be proved by adducing a cogent evidence. As the plaintiff set out the suit scheduled property for service apartment, if the court commissioner appointed, he is not in a position to ascertain the fact that the defendants have vacated the suit scheduled premises and some other tenants that came into possession of the suit property. The court has further observed that the defendants have not made out a bona fide grounds to reopen the case and permit them to file the application for appointment of court commissioner. And they have failed to make out bona fide grounds for appointment of the court commissioner and accordingly dismiss the same. When counsel appearing for the petitioner defendant submits that it is a specific case of the defendant that the defendant is not in occupation of the property, and also an issue is framed casting the burden upon the defendant to prove that he has vacated the premises. In these circumstances, if an advocate, the court commissioner is appointed, because the court commissioner is appointed to inspect the premises, and he'll be able to record who is in occupation of the property. The court has failed to consider this aspect, and if the advocate commissioner is not appointed, that would cause a lot of hardship to the defendant. When counsel appearing for the respondent plaintiff submits that the apartment is given, that the premises is given for a service apartment, and the defendant will not be in possession of the property, and no useful purpose would be served by allowing this application. Next paragraph, and the court has rightly dismissed the petition. Next paragraph, having heard the counsels on either side for some material on record, the petition has filed this application to appoint the court commissioner to inspect the premises and to collect the evidence with regard to who is in possession of the property. According to the plaintiff, it's a service apartment, and the petitioner, the plaintiff, the defendant is not residing in the said premises. As that being a service apartment, even if the court commissioner is appointed, no useful purpose would be served. And in a suit, these kind of collection of evidence is not permissible, and the court had rightly dismissed the application. And this court finds no reason.
May I seek for liberty, my lords, to file any necessary application to.
No liberty is required because
My
this
lords,
is altogether different.
It should not preclude them, my lords. What happens under the Commercial Courts Act?
That is not the application at all.
I understand, my
Granting
lords.
liberty will not arise.
In fact, under the Commercial Courts Act, there's a case management hearing under Order 15A, my lords. If I've skipped the stage, then it becomes tough for me to file an application to produce any other documents, my lord.
If it is permissible for you, you will file application.
At least in accordance to law, my lords may kindly grant.
It's not, that is inappropriate. Because that is not the subject matter in the presented petition.
May I also make humble submission, my lords? Observation may not come in the way, my
Any
lords.
of the observations
Please, ma'am.
made by this court in this, for disposing of this item shall not be construed as an expression of this court, and the court shall decide the petition in accordance with law.
Please, much obliged. Please.
51, SK Mithun.
For the petitioner, my lord. My lord, suit for specific performance was filed, my lord. After the conclusion of evidence, I filed two applications, my lord. One is amendment application, the other one is application for appointment of handwriting expert to compare the LTM signatures. Both IS were rejected on 9/4/20.
What is the amendment you're seeking?
9/4/2026, my lord.
What is the amendment you're seeking?
Amendment application, we sought one declaration because they had terminated the agreement. So we sought declaration, the termination is invalid. On 9/4/2026.
And they have terminated.
My lord.
When they have terminated the agreement.
At that in 98, my lord. The agreement is of the 1996, my lord.
No, I'm saying, you said for seeking this amendment, when the cause of action arose for you.
After my lord, at the time of before filing the suit itself, my lord.
Then why did you? Why,
No,
what were you
my
doing?
grievance in this matter, my lord. Kindly see page number 132, my lord. Because there's no order being given to me. That is the reason I'm before this court, my lord. Kindly see page number 132. My both IS are rejected, my lord. It is by separate order. It is by separate order because it is mentioned both IA number 15 and
That order.
9/4/2026, my lord. It found at page number 132 of the order sheet.
130?
2.
No, the order pronounced in the open court, where is that order?
That is not there, my lord. That is the reason I'm before this court. They have not given the copy of the certified copy applied several times. In fact, I filed my personal effort. In fact, I brought to the knowledge of this court very next day. I filed adjournment application saying that the order is. My lord.
How can it be?
No, that is the reason.
What they are saying, if you ask them.
My lord, kindly see my adjournment application, which is filed next day. That is found at page number 136, my lord. I brought to the knowledge of the court saying that the separate orders are not found in the court file, and the court has did not considered that aspect in the order sheet and posted the matter for judgment. There is no fair hearing because I don't know what is the reason why it is rejected, both applications. Now it is posted for judgment, my lord, on 7/7/26.
Then counsel for the petitioner submits. But if once I call for, I will stay.
Yes, ma'am. I will file my
I'll stay the pronouncement of judgment. If it comes to the notice of the
Oh, my
court,
lord, that is the reason.
I'll call for the report.
Yes,
If
ma'am.
anything like what you're saying is what your client
Yes, madam.
has instructed you
Yes.
is not correct, I will impose exemplary costs.
Yes, ma'am. Because I
Counsel for the petitioner submits that the court has dismissed IA number 15 and 16 by order dated 9/4/2026, wherein the court pronounced the order in the open court, and it is mentioned that there is a separate order. From that day, the petitioner is asking for the copy of the order. So far, the order copy is not granted. And now, as a petition, this aspect was also brought to the notice of the court. And court, without furnishing the copy of the order, now the posted the matter for judgment. Considering the submission, there shall be a direction to the court not to pronounce the judgment. Next para. Registrar Judicial is directed to call for a report in this regard from the concern. This is matter on 6th of July.
Yes, because that is the reason I filed my personal, I went and requested the judgment. He said it will be furnished and it is not given, my lord.
6th of July.
22.
I'm appearing for the petitioner, my lord. This is a writ petition filed by the KPTCL challenging the award passed by the in Annexure D, my lord.
What is the amount?
It's a 34,000 rupees, my lord. We have paid already 1,89,000 rupees as per the DC order, my lord. In spite of that, again, they have awarded it is a double compensation.
you're not
I'll deposit the entire amount, my lord. I'll convince on the, I'll deposit the entire amount. Stay may be granted.
Then what is the stay when you deposit the entire amount?
And not to permit them to withdraw, my lord, because the same
It is
thing.
submitted that in spite of depositing the entire amount, again, the court has granted a compensation of rupees 34 lakh, 34.
No, my lord. The earlier, while drawing the high tension line, my lord, the DC will appear before the.
What I'm saying,
Yes,
after, as per the order of the DC, you have deposited.
1,89,000 rupees.
They have deposited 1,89,000 and.
And the same was withdrawn also.
And the same was withdrawn, and the respondents have approached the court, and without considering this aspect, court has granted 34,000. They should be, considering the submission, they shall be stay of all further proceedings on the condition that the petitioner shall deposit the amount granted by the court before this court.
Much obliged.
Within
Within a period of 4 weeks.
in a period of 4 weeks. Yes, 23.
Sale number 20, notice.
Notice to the respondents.
Sale number 23.
Appear for the petitioners in this
Take
matter.
up, my lord.
Your lordship, this is the writ petition by the plaintiffs, your lordship. The suit is for partition, separate possession, mandatory injunction and declaration, your lordship. We are here before this court for a rejection of my ex parte ad interim orders, your lordship. The brief facts of the case is that, your lordship.
Where is that? Come to that.
Please, your lordship. Annexure A, your lordship, at page number 23, your lordship. The orders is at page number 25, your lordship. The learned trial court judge has not assigned any reasonings and have
Yes,
rejected.
please come. The petition is before this court. Agreed with the order dated. Date of the order?
Date of the order is dated 19/6/2026.
Whereby the court has failed to consider the IA number 2.
IA number 1.
IA number 1 filed by the plaintiff seeking ad interim injunction and issued suit summons returnable by 21/7/2026. Then counsel for the petitioner submits that same like in the earlier order. In the earlier order, same the judgment and all. So within 1 week from the date of receipt of the copy of the.
Your lordship, stay of
No stay.
status. The reason is that, your
The
lordship.
court will decide it within 1 week. I will not grant any interim order.
But
before
your
the
lordship,
court.
the order is that the notice has been dispensed now and the notice has been dispensed to 21/7, your lordship.
I said within 1 week from the date of order, you can, you can make an application to the, you can seek requirement of the case.
And may that be maintained with the registry, your lordship, because may the registry be directed to seek
All
reports.
that is not required. You go to the court and show this order. Yes.
Much obliged, your lordship.
Yes.
24. Uday Shankar R. Manjeshwar. For petitioner,
For the petitioner, my lord, suit for specific performance. I appear for defendant number 9 in the matter, who's the bona fide purchaser. Suit for specific performance. I appear for defendant number 9. He's the bona fide purchaser. What happened in this case, my lord, is the application under Order 6, Rule 17, seeking amendment was dismissed. Previously, defendant number 9 was represented by one counsel. When he was represented by that counsel, a written statement came to be filed on 9/7/2018. Subsequently, that counsel retired and a new counsel came on record. When the new counsel came on record, he was unaware that a written statement was already filed. So he files a second written statement on 22/9/2019. The entire issues, trial, etc. proceeds on the basis of this second written statement itself. Plaintiff also accedes to the same. Subsequently, at the stage of defense evidence, it was found that two written statements are on record. Because two written statements are on record, both cannot continue to be on record. So the counsel for the defendant number 9, that is the petitioner's counsel, files a memo seeking withdrawal of the second written statement because it was incorrectly filed. This is the written statement filed on
But the entire suit went on basing on the
second written statement itself. Now, when I withdrew that second written statement, what I did was on the very next date, I filed an application for amendment because the second written statement and the first written statement were not identical because it was filed by two different counsels. The only inclusion sought in that amendment application was to include paragraphs which were mentioned in my second written statement. Learned Trial Court has dismissed that application.
So continue with the second written statement.
Yes, my lords, but a memo came to be filed saying the second written statement has to be not pressed. Inadvertently, that memo came to be filed, but at the facts which are sought to be introduced are not new or fresh facts. These facts were always on record. Suit was filed in the year 2018, my lords. First written statement was filed on 9/7/2000.
What is the respondent's petition permitted to take out handsomely and file a memo to that effect by 7th of July? If the memo is filed on 7th, list this matter on 8th.
May I request interim stay, my lords. My lords, because 7th July, the matter is posted before the Honorable Trial Court. It is posted for cross of DW1.
That day, the matter will be listed here also.
My lords, may I please request a stay till that time?
No, it's not a case for stay. These kind of latches on your part and you ask to say suits to be stayed. No. Yes, next.
then number 25, Santosh BM.
My lord, in the year 2018, my lord, an agreement was entered
What
in
is a suit for?
suit for, my lord, is permanent injunction.
You are the,
I am the defendant.
what is the IA?
IA, my lord, is 39 rule 192.
What happened to that?
My lord, that has been allowed.
Appeal?
Appeal, my lord, is has confirmed.
Come to the appeal. Appeal order.
Please.
Para 17.
On perusal of the grounds furnished by the appellant has not filed any copy of the agreement of sale before this court. In the absence of the document, court is unable to come to the conclusion that the vendor of the plaintiff had entered into agreement of sale with him on so and so. The plaintiff has furnished copy of the plaintiff in OS number so and so. It appears that the plaintiff has filed suit for specific performance of contract. In this writ petition also we have filed. In fact, in OS also before the trial court also we have filed the copy of.
Read further.
The plaintiff has furnished copy of the plaintiff in OSM. It appears that the plaintiff has filed suit for specific performance of contract against the plaintiff and case Nanjuna Gowda. On perusal of the plaint, it appears that defendant has not stated nature of the agreement in this plaint. But on perusal of the trial court order, it appears that defendant has furnished copy of the sale agreement before the trial court, but he fails to furnish the same before this court. On perusal of the sale deed dated so and so, it sale deed dated so and so. That sale deed, my lord, is in favor of.
You have filed a suit for specific performance.
Please, my lord. That is my.
Which year is that?
My lord, suit for. In chronologically, I'll first, my lord, is agreement of sale in the year 2018. Thereafter, my lord, 19/2/21. a sale deed was executed in favor of the plaintiff, my lord. Plaintiff herein. My lord, thereafter, my lord, I file a suit for specific performance. Within 3 days, the 3 days after execution of the sale deed, my lord, I file a suit for specific performance. In that, my lord, I seek for nullification of the sale deed. My lord, thereafter, my lord, in the year 2022, my lord, after 1 year, he files a suit for permanent injunction. The plaintiff, my lord.
In your suit, what are the IS filed and what are the interim orders?
No, in my suit, my lord, I am not. That is not the subject matter of this.
No, it is. It is not your case that you are in possession of the property, or is it?
No, I am in possession. In the pursuant to the agreement of sale, I am in possession. I have also produced the agreement of sale.
Yes.
My lord, in spite of that being the position, my lord, the trial court, my lord, grants temporary.
No, that is what I'm asking. What is the evidence before the court to show that by virtue of the agreement of sale that is executed in your favor, by virtue of that, even the possession was also delivered to you?
I have produced the agreement of sale, my lord. Annexure.
That is what the court says. That is not there.
Annexure G, my lord. No, even the court says that it was produced before the trial court.
In this appeal, defendant has not furnished para 18. Line number 3. In this appeal, defendant has not furnished any cogent document to show that possession has been delivered to him.
My lord, now I produced before you.
How can you produce here?
No, that was also produced before the trial court, my lord.
But the court records it.
My
No, the issue is whether you have placed it or not placed it.
lord, before the trial court, my lord, I have placed it.
Appellate court, you have not placed it.
Appellate court, my lord.
Then trial court, what is the finding of the trial court? Let's see.
No, the appellate court itself says that it is produced before the trial court.
Where it says?
Para 17, my lord. Four lines from the bottom. But on perusal of the trial court order, it appears that the defendant has furnished copy of sale agreement before the trial court, but he fails to furnish the same before this court.
Let's see the trial court order. How did the trial court appreciate that?
Page 32, my lord.
Yes.
On the other hand, the defendant produces the copy of one sale agreement dated so and so, and the plain copy of OS number so and so, photograph and one receipt same are disclosed that the defendant has been filed suit for specific performance of contract.
Where is that suit agreement?
What?
Where is that agreement?
Where is?
Agreement of sale.
Agreement of sale is annexure G, my lord.
Page number?
Page number 53, 52 is the agreement and 53 is the relevant portion.
What it says?
He says, ಇಂದಿನಿಂದಲೂ ನೀವೇ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿದ್ದು I have been in cultivation. That is what it is.
Read it completely.
It is in Kannada.
That I understand. You read and translate.
My lord, ದೂರವಾದ್ದರಿಂದ ಸಹ ಇಂದಿನಿಂದಲೂ ನೀವೇ ವ್ಯವಸಾಯ ಮಾಡುತ್ತಿದ್ದು. In the sense,
cultivating the land.
The vendor of the plaintiff says that I am cultivating the land.
Read further.
No, that is the relevant portion.
So it says because you are cultivating the land, now I am executing the agreement of sale.
Sorry, madam.
You are cultivating the land.
Please.
Now I want to sell this property in your favor.
Please.
Where did he say? Further you read.
No, so I am selling this property for 2,30,000. That is.
So by virtue of this, you say that possession is given to you. How can it be?
I am in possession. I am cultivating the land. It is an agriculture land. I am in cultivation of the land. By virtue of this, temporary injunction.
no, it amounts to.
He has filed execution petition.
No. If somebody has leased out a agriculture land, you are doing the whatever you by virtue of the leasehold rights of the agriculture land.
No, I have challenged this sale deed also. It is under challenge in my specific performance suit. That is filed 1 year prior to his suit.
The whole basis to claim injunction for you or to deny the injunction to the plaintiff is you are in possession of the property.
Please.
Mere saying in the agreement of sale that you are cultivating the land, that doesn't mean that by way of agreement of sale, possession is delivered to you.
No, I am cultivating.
No, if a tenant is in possession of the property, that means by agreement of sale, possession is delivered to him.
No, I am cultivating. I have not been evicted by any means.
We'll see. Notice to the respondents. Petition is permitted to put hand summons and file a memo to that effect.
My lord, execution. My humble submission, my lord.
Memo is filed. List is matter on. Let other side come. I can't decide this.
My lord.
We'll not pass any that way. Two courts have concurrently held against you.
My lord, 30th.
Yes. How can you file a memo by 30th?
My lord.
You have to file a memo by serving the hand summons.
I'll do that.
Hand summons on the council appearing with the respondent before the trial court. If the memo is filed by 29th, list the matter on 30th.
Grateful. Execution, my lord, is filed. And they are also seeking for police protection.
Hand summons ಇದು 36 ಅಲ್ವಾ if 29th hand summons One week. ಅದು ಫಾರ್ಮ್ಯಾಟ್ ನಿಮಗೆ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಆಯ್ತು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಹೇಳ್ಕೊಳ್ಳಿ ಅದೇ ಈಗ ಒಂದು ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ನೋಟಿಸ್ ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸರ್ ಇದು ಅದೆಲ್ಲ ಫೈಲ್ ಕೊಟ್ಬಿಡಪ್ಪ ಸರ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ ಸರ್ ನಾಳೆ 25 ಅಲ್ವಾ? ನಲ್ವತ್ತು ಮ್ಯಾಟರ್ ಇದೆ ಡೇಟ್ ಆಲ್ರೆಡಿ. ಇದು ಆ್ಯಡ್ ಅಪ್ ಆಗುತ್ತಲ್ಲ. ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು ಕ್ಯಾಚಪ್ ಆರ್ಡ್ರು ಮಾಡಿಫಿಕೇಶನ್ಸ್ ಎಲ್ಲ ಇರುತ್ತೆ. ಅದು ಕನ್ಸರ್ನ್ ಅವ್ರಿಗೆ ಹೋಗ್ಬಿಟ್ಟಿರುತ್ತೆ, ನಾವು ಹೇಳ್ತೀವಲ್ವ ತಗೊಂಡು
No mention. Call the list.
Number 1, serial number 26 for orders matter. Prashant PN for petitioner.
Memo is the notice to R1 returned as refused amount to deemed service of notice. In respect of R2 returned as unclaimed amounts to deemed service of notice.
Even the copy is served and the advocates appearing on the loan.
Then counsel for the petition submits that even the copy is served and the counsel for the, and you have filed a memo?
Yes, on 5/1/26.
A memo is filed in that regard on
26.
5/1/26. Yes.
The suit for partition, where the defendants before the lower court. Defendant number 1 is the grandfather. Defendant number 2 is the grandmother. Defendant number 3 and 4 are the sons. Defendant number 5 is the agreement holder. First scheduled property was purchased in the name of grandfather. Second scheduled property is purchased in joint names of grandfather and grandmother. Now the minor sons files a suit for partition during the lifetime of these grandparents, claiming to be ancestral properties.
So grandparents are alive?
Alive, my lord. Rejection of client application was filed. The courts hold that it's a mixed question of fact and law to be addressed. Annexure A is the order, my lord. The relevant portion is at page 19, my lord, para 9. Page 19, para 9, my lord. A suit can be rejected if from the statements in the client itself it is clear that it is barred by law. If the legal bar requires examination of evidence.
Where is your application?
Plus application annexure C, my lords. Page 32, my lords. That for the reasons.
Who are you? You are a purchaser.
No, my lords. I am the grandfather and grandmother, my lords. For the reasons shown to the accompanying affidavit, the defendants 1 to 4 applicants must say that please reject the claim filed with the plaintiff as there is no cause of action, and also the suit itself is barred by laws. Order to put an end to sham, bogus, irresponsible litigation, it is required to reject the client by following the dictum so and so. I filed affidavit at page 33, my lords. A detailed affidavit file is filed.
At page 34.
Please, my lords.
You say what are the reliefs, then you say since the suit scheduled properties are the self-acquired properties of myself and my wife, therefore the suit filed by the minor plaintiff in respect of a self-acquired property is not maintainable. It is not something which the court can decide at the time of order 7 ruling.
If it is, my lords, to be ancestral properties.
No, that is a question of fact and law.
My lords, there are other properties. If I have one ancestral property or one joint family property and I have 2 scheduled properties of self-acquired property, it's a question of.
No, according to them, it is ancestral property.
No, my lords, it should be, if it is an ancestral property of 3 generations, grandfather, great grandfather property, they're not.
When was these properties were purchased?
Lords, in the year 2000 and 2012.
2000?
2000, my lords, day 2000. On 7/9/2000. Another is 29/3/2012. I produced the sale deeds. It's not, my lords, no RTC is saying that it is my 3 generations property, or to say the joint family property, 1 ancestral property was there and 2 properties are subsequently purchased. It is strike a case under 8 and 14, my lords. Section 8 applies to 1 property, 14 applies to the property of a lady. And to say that it is ancestral, it should be of 3 generations, my lord. Even to say joint family, I agree, my lord. One property holds, the grandparents hold one property, and 2 properties are added subsequently. Then it becomes joint family property, my lords. Now I purchased. I have one property I have, my lords, given because of my necessity, and subsequently this there is a follow-up.
But come to the plaint. Did they say about all these things?
Please, my lords. The plaint is at annexure B, my lords.
Page number?
Page number 14, my lord. 14,
14 is the order.
I'm sorry, my lord. Annexure B, page 23, my lord. Page 23. Relevant portion, my lord. Para 4, my lords. Para 4, married, my lords. The client submits the usual item number 1 is purchased in the name of second defendant on 7/9/2000. The suit schedule item number 2.
Who are first, third, and fourth?
Was 3 and 4 are the my children, my lords. 5 is the agreement holder. One property I have, my lords, entered into an agreement. Defendant number 5 is the agreement holder. 3 and 4 are my sons. 1 and 2 is the father and mother. So straight case of 8 and 14, my lords. To come under 6, my lords, they have to plead, saying that it is ancestral and joint family property.
Then counsel for the present writ petition is filed. Agreed with the order. Dated 15th February 2025. In I number 2, NOS number 5305 of 2024 by the 11th Edition City Civil and Session Judge, Bangalore City. The petitioner, defendant number?
1 and 2, my lords.
1 and 2 is before this court. Then counsel appearing for the petitioner submits that the plaintiff is the grandson of
1 and 2.
1 is no more.
Well, both are there. Both are.
1 and 2, and 3, 4, 5 are how related to?
3 and 4 are my sons, the sons of the 1 and 2.
And the father of Jagdish.
Defendant number
And
is the
fourth,
father, my lord.
fourth defendant is the father. Third and fifth defendant are the uncle.
3 is uncle.
Huh?
3 is uncle.
4 is uncle.
3 is uncle. 5 is
So, and defendant number 3 is uncle of the plaintiff. And fifth defendant is the purchaser from
1 and 2.
From 1 and 2. It is a case of the plaintiff that the suit schedule properties or the self-acquired properties. No, where is that?
Para 5, my lords. Para 5.
Plain page number?
Para 5, page 26. 4 and 5, my lords. Relevant.
It is a
4 and
case
5.
of the plaintiff that the suit schedule item number 1 is purchased in the name of second defendant on 7/9/2000. The suit schedule item number 2 purchased in the name of defendant number 1 and 2 on 29/3/2022, 2012. These are the only properties.
Only properties, my lord.
The first, third, and fourth defendants have also contributed the funds from their earnings to purchase the suit scheduled properties. And then the properties are enjoyed by defendant 1 to 4 as joint family properties. It's a case that the second defendant has executed a sale agreement in favor of fifth defendant on 29/4/2024. And as such, the same is not binding on the plaintiff and sought for a relief partition. In that, the defendant 1 and 2 I filed an IA under Order 7 to 11 seeking rejection of the plaint on the ground that in the entire plaint, they have not stated what was if there is any joint family property, whether the same was, whatever the funds that are derived from that, they have purchased these properties, except stating that the other defendants have contributed. Nothing else has been stated. Even in the averments itself, there is no pleading with regard to the joint status of the parties, in that the property is a joint family property. When they have, as the, hence is a case that the suit for partition is not maintainable. The trial court, the trial court, by order impugned, had dismissed the IA. The court observes that the plaintiff has claimed a share in the suit property as a co-partner by birth under the Hindu Succession Act. The plaintiff has also raised concern about a sale agreement executed by defendant number 1 and 2 in favor of defendant number 5, which may affect his case. These allegations indicate a prima facie cause of action since the plaintiff has made out a claim that requires adjudication and the suit cannot be rejected under Order 7, Rule 11. It is also observed that when the suit is barred by law, when it is a case of the defendant that the suit is barred by law, the defendants claim that they have not specifically mentioned any clear legal provision that bars the suit. The plaintiff has relied on the judgment in Vineet Sharma's case, where the Honorable Supreme Court recognized that a son becomes a co-partner by birth. This indicates that the plaintiff has an arguable case. The issue, whether the suit properties are ancestral or self-properties, is a mixed question of law and fact, which requires evidence, and the same cannot be considered in an application under Order 7 to 11. Next, Land Counsel appearing for the petition submits that the plaintiff has nowhere stated that a particular properties or the joint family properties, and or by selling away from the income derived from the sets of properties, the suit schedule properties are purchased by the defendants. Even according to them, these properties are purchased in the year 2000 and 2012 in the name of defendant number 1 and in the name of defendant number 1 and 2. When basing on these issues, when specific contentions are raised by the defendant seeking rejection of the claim, the court has failed to consider the same and rejected the application without appreciating the facts as well as the law. Having got the counsel for the petition, there is a material on record. The grandson is aged about 10 years and is seeking partition, stating that the suit scheduled properties are the joint family properties. This is seeking partition, saying that those properties are purchased by the contribution from defendant number 1, 3, and 4. As rightly submitted by the Land Counsel, in the entire pleadings, there is no abandonment with regard to the joint family properties, and admittedly these properties were purchased in 2000, 2012. When the plaintiff has raised a specific ground with regard to on how the rejection of the plaint has to be, on what ground, the court has failed to address the said ground and in a routine manner. That is a question of fact and law, or it has to be decided during the course of the trial and dismiss the IA. In this case, if unless and until the plaintiff from the plaint averments and the documents that are filed along with the plaint, if it's not if the defendant makes out a case that it's a case for rejection of plaint, the court has to consider the same. In this case, The court has failed to consider the application that is filed by the petitioner in the proper perspective. Accordingly, the order impugned dated so and so is set aside. The matter is remanded back to the trial court to consider the same in accordance with law as expeditiously as possible after his contentions. Your annex para, though notices the court has held that on so and so notice to respondent held sufficient. No wakalat is filed on it.
Cell number 27, Ashwini, for petitioner.
This is a suit for eviction and I'm appearing for the tenant here. So, my lords, the registry has raised an issue regarding the number of days of delay in filing the appeal. According to me, it's 51 days, and I'll show how I'm calculating that, Your Honor.
Did you state so before the? Where did you say that it is 51 days here?
My lords, I've filed an application for continuation of delay as well, and I have mentioned that it's 51 days of delay. But
What is the office objection?
my lords,
Delay days to be stated correctly in IA for CD, affidavit, and limitation para.
correct. After that, I have stated it as 51. They have calculated it as 249 days of delay. My lords, I was placed ex parte in this impugned judgment. I have been impugned proceedings. Now, my lords, my entire contention is that I have never received the suit summons. My lords, if I might just point out to a few, I have annexed the acknowledgement card that was received by the court.
That the court will consider, but you have to count it from that day.
My lords, but my entire application is that.
Court will consider that.
Please, my
You have
lords.
to argue before the court, but you have to state the delay from that day only.
Please, my lords, I can.
Office objections to be complied with. Yes, next.
My lords, it can be listed for hearing, my lords,
If
because.
office objections are complied with, list this matter on 6th of July.
Cell number 28, AG Sadashivaya.
Please, my lord, I represent the petitioner before this court. The office objection, my lord, there is a mistake in the crept in the judgment itself, my lord. My lord,
Yes.
my lord, there is a mistake in the judgments itself, my lord. Last, kindly see, the original suit is of me, is 339 of 24. My lord, in the top of the judgment, my lord, it is mentioned as 296 of 24.
No, but I see it as 339 at page number 16.
True, my lord, but my lord, 296 is also mentioned, my lord. In the top of
What
the.
is this?
It's just.
Where is the plaint?
Plaint has been placed before this honorable court. My lord, that page 27, my lord.
It all reflects 339.
Yes, my lord.
Office objection with regard to the suit number is overruled. Yes, next.
My lord, the other, my lord, arraying the parties, my lord. The
Non-compliance of objections for third time.
true, my lord. Therefore, my lord, I wanted to submit to the court itself, my lord. In spite of requesting the office, my lord, they have not considered the same. Let me kindly appreciate, my lord, the first petitioner before this in the petition itself, my lord, is no more. My lord, second, the one Satish and Sujat are the legal heirs of the first appellant. And the
Now,
second, yes, my lord.
whatever is the cause title, you
Yes,
have to carry the cause title as it is. Whatever other things you want to say, file it by way of an affidavit. Office objections to be complied with.
Please.
Yes.
Cell number 29, Suram Isi, petitioner. 29.
Morning, they asked for time in this.
30.
Yes, 30.
Cell number 31. 30.
You called 29. 30.
29.
I appear for the petitioner, my lords.
Yes.
My lords, Annexure A is the impugned order.
You took 30, instead of 29, 30 is adjourned. They'll call for the file. Office objections to be complied with.
No, there is a mistake in the impugned order, my lords, with respect to the date. Lords, date is shown as 8th April 2025. In fact, this order was passed in 2026, my lords. Your lordship sees the last page of the order.
Signature it is there.
Signature is there, my lords.
In that, below the signature, the date is there.
Date is there, 26 is there, my lords. And
What is objection?
I've also got the copy
Office
corrected,
objection
my lords, so.
With regard to the date is overruled. Yes.
My lords, 7 Rule 11, my lords, petition filed by the defendant number 10 has been rejected, my lords.
File is not there, it seems.
File is not there, pass on by.
By mistake, they've sent 29 is adjourned, they've sent 30.
Cell number 31.
This matter tomorrow in the first place.
Tomorrow, first.
Yes,
Obliged.
31.
Cell number 31. Pushya TJ. Cell number 31.
For the respondent, my lords.
You file vacate petition.
Yes, my lords.
Non-rectification of office objections.
It is on.
IA number
last
1 of
sub-
24. Huh?
Copy has been served, my lords.
Then counsel for the respondent submits that the office objections on, they have served the copy on the respondent. There is no representation on behalf of the petitioner. List this matter in the month of September.
My lords, kindly, there is,
I'm not extending the interim order.
please, my lords.
Yes, next.
Cell number 32. Madhu CS. 32.
Appearing on behalf of the petitioner, my lord. My lord, on 28/10/2024, the matter was last time listed for orders, which was ordered that office objections should be complied within 2 weeks, failing of which matter shall stand disposed without referring to the bench. According to the order, the office objections were duly complied, my lord, within a stipulated period, but after further verification, office raised another objection that a neat copy of cost title has to be furnished. That even after 2 weeks, the matter should
IA
contain
for CD in filing not filed. Condone delay.
condonation of delay.
That is the office objection.
I have it with me. My lord, file got misplaced, my lord, by the pending branch.
No, that file it before the registry. The land counsel for the petitioner submits that. They have the copy of the, they're ready with the IA for condonation of delay. The same shall be filed before the registry.
Yes.
Yes, next.
Cell number 33.
Appear for petitioner. Suit for partition. And the suit is filed by,
Issuing of PF to issue notice to respondent for first time.
no, we have served the copy. And the matter is settled out of the court. In the mediation before the family court, there were several cases and counter cases between the parties. And my lord, the petitioner is a father, and the other two different.
Nothing to be heard in this writ petition.
My lord, my request to consider the memo dated 6/4/2026.
Look at it. Memo.
My lord, may kindly consider page 18, please. My lord.
I'll just say, it is your submission that already there is a settlement between the parties before the court, in which case,
52 of 2025.
in the light of it, you do not want to pursue this matter.
My lord, now the kindly consider.
I will not consider any of it unless the respondents are here.
My lord, I have served the copy. My lord, they are not cooperating with the withdrawal of the case. That is my case, my lord. My lord, may kindly for a moment, my lord. Page 23.
Where is the memo you have filed?
On dated 8/9/2025.
Where is it, see?
Eight, 9. This honorable court has directed to file the notice copy, my lord. I had order dated 28 or 25. Accordingly, we have served it to the trial court
Respondents?
on 3 respondents. Only one, my lord. Sorry, madam. Only one respondent. That is the daughter-in-law of the petitioner. She has filed on the properties of self-acquired and the compromise is entered.
To whom you have taken notice?
Council, madam.
What is the council name?
This honorable court has ordered dated 28.
What is the name of the council? What is his name?
On behalf of Bhagwan, madam.
Where do you get it?
Madam. I filed the presentation copy, madam.
It is stated that as per the orders passed by the court, the petitioner served the hand summons on the counsel appearing to the respondent before the trial court, and he has filed a memo to that effect before this court. The memo is taken on record and notice to respondent is held sufficient. Yes. What is this memo?
Now, my lord, can consider page 22, para 13, please, my lord.
Page 22.
22, please, in the memo, please.
Hmm.
And this is a joint petition filed before the matrimonial court. It is submitted that it is agreed by both the parties on payment of agreed amount of 13 lakhs.
Where are you reading?
Page 22, para 13, please, madam. In the memo, please.
The memo, page 22, para 13.
Yes, please. It is submitted that it is agreed by the both parties on payment of agreed amount of 13 lakhs and receipt of the same. Both the parties shall withdraw the pending cases mentioned in the above and shall cooperate to each other to resolve all the issues leading to peaceful settlement and closure of the cases. Further, both the parties undertakes and agrees and abide to close all the cases with the presence of and the requirement as the cases demand. In furtherance to same, if either party do not cooperate of the closure of the case, which is between the parties, it is further undertaken that presence of the parties are dispensed with me of the settlement dated 15/11/2025 in criminal matters so and so, and no party shall have any grievance. Now this condition is.
This writ petition arises from which order?
My lord, we have challenged the proceedings before the. We have challenged the proceedings of the partition suit because the property under question is the self-acquired property of the petitioner, who is the father-in-law of the respondent, daughter-in-law. During his employment, he has purchased the property, my lord.
So what is that you are expecting the court to pass an order now?
Pardon? Now, my request is to.
Your suit is there.
Yes, ma'am.
As per this, once the suit goes, automatically this petition will also go.
They are not willing to withdraw their suit, my lord. They have filed the petition suit.
How your purpose will be served by withdrawing this?
No. My first request is to squash the proceedings before the trial court.
How can it be? First of all, your suit should go.
My lord, even there also they are not cooperating. They should withdraw the petition as per.
I'll not pass any order of that nature.
Respondent notice here to be held sufficient, please.
Yes, I've already held that. This
Please,
is matter after 4 weeks. Yes.
Cell number 34.
What are these two IAs?
Chandrasekhar Babu.
IA number 5 and 6 are one and the same, my lord. So
What are the
annexure K, your lordship kindly have it.
What are the IAs?
IA is for to attachment of fixed deposits, my lords.
Attachment of?
Attachment of fixed deposits. The crux of the case is that
No, there are two IAs. What are those two IAs? I'm asking.
both the IAs, IA number 5 and 6 are for attachment of fixed deposit of the society.
Why there are two IAs for that?
Due to technical mistake, my lord, the IA number 5, the honorable court directed me to file IN number 6 rectifying the, therefore, that has been done.
Counts for the petitioners of his staff. Though there are, the order is only one, but by, as there was a mistake in one IA, you had to file two IAs, another IA, and hence the writ petition is maintained. Accordingly, consent submission is taken on record and office objections are overruled. Yes.
Last, kindly look at, I think page number 96 minutes.
What is the order impaired? Where is it?
The 96 minute, page number 96. IN number, my reading minutes. IN number 5 and 6 filed by the DHR under order 21 rule 42 of CPC and under order 21 rule.
Your IA for an attachment is rejected.
Yes, Ministers.
Notice to respondents.
Interim order, my lord, in view of the fact that your lordship kindly look at.
No, your application is rejected. Why should there be an interim order in that?
No, what happened, execution proceedings, my lords, what had happened during the pendency of the execution proceedings, the learned judge has passed the order exceeding the limits, my lord. Your next para, your lordship kindly look at in page number 96, my lords, what had happened, I will read these. However, it is made it clear that the JDR is hereby directed to refund the amount 28,000 to be paid by the DHR at the time of his membership to the society, along with interest of 12%. My plea before the Honorable Court, judgment and degree was passed to give site, my lord. Allotment of site is the question for the consideration of the judgment and degree, my lord. Exceeding the limits, my lord, the learned judge has passed the order saying that by without interfering the exceeding the this thing, he has passed the order to pay the amount, my lord, to refund the amount. That is not the, in view of the Supreme Court decision, my lord, I have produced it before the Honorable Court. In page number, annexure Q, my lord, it clearly states, my lord, wherever caption C, my lord, in page number 132, annexure Q, my lord.
Not the judgment.
Yeah,
Come to the impugned order again.
Come to the in page number 96, my lord, your lordship. IN number 5 and 6 filed by the DHR under the 21 rule 42 of CPC and under order 21 rule 61 of CPC are hereby rejected. However, it is made it clear that the judgment JDR is hereby directed to refund an amount of rupees 28,000 to be paid by the DHR at the time of his membership to the society, along with the interest of 12% per annum. The execution court, my lord, judgment and degree was passed only in respect of payment of
Page number?
page number 90. Decree, my lords, annexure C in page number 43.
Impugned order is page number?
Which 97, my lords. 96 and 97. That's what I read, my lords. Hmm. 96 and 97. 96 is the operative portion. Decree only 40. 43 page. 43. Connection C.
Where is the award?
In page number 43, annexure C, my lords. Operative portion is at 43 minutes. ಎದುರು ಅರ್ಜಿದಾರರು ಸಹಕಾರ ಸಂಘ ಭೂಪಸಂದ್ರ ಬಡಾವಣೆಯಲ್ಲಿ ತಕರಾರಿಲ್ಲದೆ ಒಂದು ನಿವೇಶನವನ್ನು ಹಂಚಿಕೆ ಮಾಡಿ ಕೊಡುವುದು ಮಾಡಿ ಆದೇಶಿಸಿದೆ. The respondents are directed to give allotment of site in the Bhupsandra where they have agreed earlier during the year 1984 minutes. In the year 1984,
So the order is to allot the site.
Yes.
Then what is this fixed deposit attachment?
No, what had happened, the allotment of site was not given, my lords. Subsequently, when we made execution proceedings, they say that we have not formed the layout at all. The fact remains that I have produced document to substantiate. There were layouts formed in Anekal as well as Bhupsandra in other places, my lords. Sarjapur also.
I understand. When the order is to allot you a site,
Yes, ma'am.
then why you are seeking attachment of the fixed deposit?
That is the,
The attachment of fixed deposit, an
Attachment
amount
of
of rupees
for this
87
reason.
lakh 1,916.
Because in view of the fact that the respondents unable to give the site and say that
How much you have
we
paid?
have not 28,000 minutes.
For 28,000, they have to give you 87 lakhs worth.
No, 1984 minutes. The then prevailing rate was it was 70 rupees per square yard minutes. It is there. They have given confirmation letter and Hanchike Patra, everything minutes. But subsequently, what had happened now, the lower court has passed the order to give site.
No, on what basis this 87 lakhs shall be, a fixed deposit shall be, there shall be a warrant of attachment.
That is the reason behind that is that, my lords, the respondents are not coming forward to give site. In the execution proceedings,
How did you determine this 87 lakhs to be attached?
no, my site is to be given or else the attachment of fixed deposit is to be.
How is it permissible? How is it permissible? If they are not attaching, giving the site, you will say 87 lakhs rupees fixed deposit shall be attached.
No, the present rate of this is more than 1 crore.
Where from all this we get it?
What
You yourself have determined.
in Bhupsandra, the
Notice
Bhupsandra.
the respondents.
My lord, what happens, 30th is the case, my lord. Supreme Court decision is there.
We will consider the Supreme Court judgment once a respondent appears.
Annexure key, your lordship kindly have a look at for a moment, my lord, sir.
First of all, your application itself is not maintainable. Forget about what the court did.
No, that the reason behind that is that they are unable to give private site and also they are saying that sites are not available, we have not formed the layout. That is the reason, my lord, sir.
Once the respondent
No,
enters appearance.
in view of the fact that, no, if they deposit the amount, the very purpose of the writ petition will be infructuous.
Case is pending here. We will say that it is bad, it is, then that will be.
May we permitted to take hand summons?
Yes, hand summons. I shall file a memo to that effect. Once a memo is filed, is the matter. Yes, next.
Number 35, Chaitanya, for petitioner.
My lords, one submission. Serial number 33, interim order to be extended. Serial number 33, interim order to be extended.
Look at it if it is there, extra.
There.
Yes, 35.
35,
For the petitioner in this matter, my lord. My lord, the petitioners are the defendant in the suit.
This memo of conversion.
My lord, instead of filing the commercial appeal, we had preferred the
The
writ
memo
petition.
is filed seeking conversion of this writ petition. As this arises out of from the commercial court. The petition has to file a commercial appeal. Instead of that, the writ petition is filed accordingly. Accordingly, the petition is this petition is disposed of, giving liberty to the petitioner to convert this into a commercial appeal. And the petitioner shall also comply with the office objections. Yes, within 2 weeks from the date of receipt of the copy.
36.
Grateful.
Petitioner, Counselor.
Petitioner, my lord, before the execution get, my lord, the
What
petitioner has
about
filed.
notice to R1 and R3?
Yes, my lord, the parties, my lord, the summons has been served on the council
I have
Where is
filed a
that?
memo for that effect, my lord.
Where is that?
Yes, ma'am. Yesterday I have filed, my lord.
This court has permitted the petitioner to take out the hand summons. And as per the order passed by the court, the petitioner has taken hand summons of the counsel appearing for the respondent and filed a memo before this court stating that he has served the notices on them on 22/6/2026.
Interim order, my lord, because now arrest warrant has issued against the petitioner, my lord. In spite of bringing a notice of this writ petition is pending and also issued the notice, my lord, a trial court issued the arrest warrant.
Is held sufficient. Where is the order?
Further proceedings may be taken.
Where is the order?
Orders,
Have
my
to
lord.
see the order.
No, my
How will the
last date of hearing, my lord. No, my lord,
stay?
rejection order. I offered the application for rejection of the fresh execution petition, my lord. Earlier, my lord, they had filed the execution case in the year 2010.
Come
They,
to the order.
order, my
Where
lord.
is order?
Order, my lord, page number annexure E, relevant page number 35, page number 35, my lord. Order on my IA, my lord.
Let's see, what is it?
This application filed by the JDR under section, under rule 46 rules so and so, praying for a dismiss of the petition as not maintainable.
When was the order?
That is the order is on 3/3/25, my lord.
No, the award.
Yes, my lord.
Award.
Award order, my lord, 2009, my lord. Annexure B, annexure A may be condition.
So 2009 award.
Yes, my lord.
20.
They offered the execution during the 2009.
And that is pending till now.
Now, my lord, earlier execution is dismissed on 31/7/2010, my lord. That is annexure C, my lord. They themselves mentioned in the execution petition, present execution petition. The last execution petition filed 161 of 2009 filed, but dismissed on 31/7/2010 for not taking steps on the not taking stage. Thereafter, my lord, they offered the fresh this execution petition in the 2019, my lord, after elapsing more than 9 years.
How much amount you have to pay?
The award amount is, my lord, 3 lakhs. Award amount, my lord. 1 lakh. Total award amount 3 lakhs. 3,99,000, my lord.
You have not paid anything.
Yes, my lord, I have paid, my lord.
How much you have paid?
Till today, my lord, maybe 2 lakh, up to 2 lakhs. I don't know exact number, my lord.
Award of the year 2009.
Yes, my lord.
Now, how much would be the interest?
My lord, my lord. Earlier, my lord, the ex parte decree, my lord, ex parte award and judgment. They offered the execution petition in 2010. This is dismissed. Thereafter, my lord, without.
If you want stay, you deposit some amount, then I'll consider.
Yes, my lord, please, my lord.
How much?
Till today, my lord, I will deposit, and they are come forward for
pay
settlement, my lord. They have come forward for settlement for 2 lakhs. I already for more than 1.5 lakhs. Now, my lord, at the instigation of other advocate, my lord, they are demanding that amount, my lord.
Well, how much you're going to pay?
Maybe, my lord, 25,000.
25,000.
Yes, my lord. Already for deposit more than 1.5 lakh.
Amount itself, what is the award amount? You said 3,99,000.
3 lakh, nearly 4 lakhs, my lord. Already deposited some amount, my lord.
As if you have done great help to the degree holder. You have paid 2 lakhs.
Yes, my lord, already
Pay
paid.
another 1.5 lakh, then we will see. Otherwise, I will not interfere.
50,000, my lord, because my lord, he has a poor person, my lord.
What poor person? You have a judgment. There is a judgment.
No, my lord, that is ex parte judgment. Ex parte award.
What are you supposed to do? Are you not supposed to
No,
question?
my lord, the provision is mandatory provision, my lord. They have to seek the restoration of the earlier execution. Without, they are not permitted to file the fresh.
Have you preferred any appeal against that award?
No, I have not prepared, my lord. Because, my lord, that was on the ex parte award, my lord. When the second notice, my lord, we came to know that earlier the execution petition filed by them is dismissed. They are not restored.
If it is an ex parte award, have you questioned that ex
No,
parte?
my lord, I have not question. I have.
So you are bound to pay that. You have an obligation
Bound to pay, my lord, because, my lord,
Please don't
execution
come
case.
with all these technicalities.
Yes,
If at all the technicalities arise, we'll see. But you have to pay about minimum 1 lakh, then only I'll grant.
I will deposit, my lord. I will deposit 1 lakh.
Let answer for the petitioner submits that the court has passed the impugned order. has issued a arrest warrant. It is submitted that the earlier execution that is filed was dismissed for default. And without filing any application to restore the same. And after the delay, they have come up with this petition, which is not maintainable. It is submitted that the award amount is 3,99,000 and petition has already paid an amount of rupees 2 lakhs,
Nearly 2 lakhs, nearly.
paid nearly 2 lakhs. Next one. Considering the submission of the land counsel of the petitioner, this court deems it appropriate to stay the proceedings on the condition of to stay the proceedings stated, to stay all further proceedings pursuant to the order dated 3/3/2025 on the condition that the petitioner shall deposit an amount of rupees 4 weeks, an amount of rupees 1 lakh within 4 weeks from today. Today is for
24th.
By 24th of July, if the amount is not paid, the respondents are at liberty to execute the order.
Amount is not deposited, madam. Deposited.
Deposit. Deposit before this court.
Before this honor court.
Huh?
Before the trial court, madam.
You want to deposit there or here?
There,
Wherever
madam.
huh?
There.
Before the trial court, before the executing court. Yes, next. Notice to the respondents.
Cell number 37.
No, notice already served. Notice held sufficient.
Insufficient.
Appearing for the
Cell number
petitioner.
37, Mallikarjunaya case.
Appearing for the petitioner, my lords. By oversight, we filed under WP, my lordship. Instead of RSA, kindly permit to file a RSA.
A memo is filed saying conversion of a writ petition into a convert the writ petition into RSA. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to convert this writ petition into a RSA, and WP is disposed of for statistical purposes. They should do it within 2 weeks. Yes, next.
Cell number 38.
Malords, I filed a memo, Malords, on 22nd. So
I
I hand
undertake-
summons, Malords, on the council appearing for the respondent before the trial.
You appear for all the respondents.
I undertake
Sole
to
respondent,
take,
ma'am.
file the
So-and-so-
wakalat, my
so-and-so
lord.
submits that.
Kindly taken up on Monday, we'll file the wakalat
Submits
in
that.
the
They
meantime.
have instructions to file wakalat. List this matter on
On Monday you can.
Monday.
Malords, interim order may be extended.
Interim order, if our interim order is there.
Please, Malords.
List this matter on 1st of July. Interim order earlier granted is extended. Yes, next.
Much
Cell number 39.
Peace objection, my lord. There are three IAs, my lord. IA number 13, 14, 15, my lord.
What are those IAs?
One IA is for advancing the proceeding from argument stage to examine PW1. Another IA, my lord, to examine PW1. And third one, my lord, to produce one document, my lord. All the three IAs are by common order, my lord. They are interconnected. Therefore, the common order has, so I have paid 3 court fee also.
It's not about court fees. It is
Yes,
about how connected
common
they are.
order has been passed, therefore I have filed.
Submitted that the office objections, the officers raised objection with regard to the 3 IAs, questioning the orders passed in 3 IAs in one writ petition. When council submits that, they're all raising out of the common order. And the office objection is overruled. Yes.
My lord, IA number 13, my lord, annexure D, my lord. My lord, this is the suit for recovery, my lord. Recovery of 3 lakh from the dependent, my lord. So the evidence of the plaintiff is over, my lord. Even the dependents also, when the case has been posted for argument stage, my lord. This, my lord, plaintiff has filed this IA to advance proceeding from argument stage to evidence, my lord, of the PW1. And second, my lord, pre-chief examination of.
Come to the affidavit, why you want all this?
That is because not in the evidence of DW1.
Let's see in the, from your affidavit.
Annexure D, that is in Kannada, my lord.
What did you say?
Annexure D, my lord.
Page number?
Please, Annexure D is the, IA number 13, my lord.
What
So,
did you say?
the region, my lord, that is in Kannada, region, my lord, DW1 in her evidence, she has stated that her husband, actually, he has taken the money, he has issued a check, he died, therefore the proceedings have been initiated against the wife, dependent number 1. So, dependent number 1, her husband, used to sign only in Kannada. But he used to say even in English also. That's why there is one doubt.
When was the evidence concluded of the defendant?
Evidence was concluded, my lord. But dates not available here, my lord. Order sheet entire
Come
not.
to the order impure.
My lord, the page 46, the operative portion of the ordinance, regions. I mean 9, paragraph 9, page 46, my lord.
Yes.
Suit is filed in the year 2017, 9 years old case. Even though the plaintiff has already been led evidence, court marked exhibits P1 to P4 after taking number of adjournment. Plaintiff kept silence till the completion of evidence from the side of defendants. The plaintiff has come with the present applicant seeking permission to reopen the stage and recall PW1 to adduce evidence and get marked documents as exhibits in her side. The case had been posting for plaintiff argument. Plaintiff counsel himself took a date to canvass arguments from the last two hearing dates.
What are those documents you want to mark?
That is, my lord, one sale deed executed, not is produced. I mean, executed, registered document before sub-registrar office, which was produced by the husband of the dependent number 1 before the Vijaya Bank for the purpose of taking a loan. That document I have produced. There, it is showing that he has also signed in English. That's my, even in English also, he used to sign page 33. Signature I am producing. I mean, the document.
How come you have that document?
Because on 7, my lord, I obtained, my lord, on 7/1/2026, my lord. I obtained document from sub-registrar office, my lord. So I came to know that that document, from the document, my lord.
Document he executed in favor of Canara Bank is given to you by the
No,
registrar.
Vijaya Bank, my lord.
That's what is given to you.
In, yes. No, it was filed along with, my lord, this particular year, IA number 15, my lord.
Oh, that's true, I understand.
Yes, yes.
How it is in your possession, that document?
No, I came to know, my lord, so I applied it. So I got it.
You applied and they gave that document which you have to an unconnected person.
Yes, madam. Yes, because I have said the plaintiff has recently obtained a certified copy of document from sub-registrar office on 7 and 2026,
This
madam.
is very strange. I can understand.
Yes, madam.
Defendant producing the document which is by her.
He has,
But plaintiff produces a document
that is one.
executed by defendant's husband in respect of a bank.
Yes, with, that was given to the Vijaya Bank, my lord. So
Good
that's
see.
why, my lord, so on 7/1/2026,
The respondents.
my lord, on 29, my lord, the case has been posted for argument on main matter, my lord. Otherwise, my lord, it will become fractious.
Let this matter on petition shall take out handsomens and shall file a memo. If the memo is filed on 30th of June, list the matter on 1st July.
No, the 29th, my lord, the date has been given for argument.
Arguments, you are not going to conclude it. Anyhow, you have successfully dragged the matter.
Till number 40.
Query for the petitioners.
Yes.
Lord, the registry has raised office objections pertaining to maintainability in this matter. This is a writ petition arising out of the family court order, ad interim ex parte order that has been passed against me not to marry while the case is being heard.
Oh, it has to be GMFC.
My lord, this is GMFC itself that I filed, writ petition. It is an interim order passed.
Oh, it is GMCPC, what you have filed.
My lord?
You have filed GMCPC.
No, my lord, GMFC.
It's listed as GMCPC before the court.
But if the petition may be looked into, my lord, GMFC have filed it as.
Age of petitioner to be stated. WP may not be maintainable against the order dated post WP before the court for orders. This is a matter arising out of the family court. Registry is directed to list this matter as WPFC before the concerned court. The other objections and the submissions will be looked into by the court.
Much obliged.
Till number 41. Till number 41.
My lord,
Petitioner.
My lord, I'm for the petitioners here, and the matter is
A memo is filed seeking dispensation of notice to R4 and R6. Memo is taken on record and dispensed with the risk of appellant petitioner. What about the other respondents? Who appear for the respondent?
Three, sir. All the other respondents are served.
Where is the counsel? You have an interim order?
Ramu came
interim
for
order is there
Robert
for dated 19th March 2025.
After that, it is not extended.
It is not extended, my lord, but it was adjourned. Matter was not listed. Once or twice it was.
Not so many times.
Yes, my lord.
They are never extended.
My lord, may kindly consider this because or put up the matter for hearing after extending the interim order.
No representation on behalf of the respondent. Counsel for the petitioner is present. This is matter finally on 9th of July. If on that day also, if there is no representation on behalf of the respondents, the matter will be heard on the merits of it. Yes.
Number 42.
My lord.
Appearing for the petitioner in this matter, my lords.
P.F. Kumar.
I have filed this application for bringing in LRs of deceased respondent number 2 and 3, my lords.
Notice is ordered
Notice has to be ordered, my lords.
in I number 1, 2, 3, 4, 5, 6.
6.
On all these IS notice to the respondents. Then what is this 8 memo dated? Already on record as whose LRs are on record?
My lords,
8 and 11.
A memo dated 11/6/2026 is filed stating that the LRs of deceased R4 are already on record as R5 to R8
R8, yes, my lords.
and R11. The memo is taken on record. The petitioner shall carry the necessary amendment to the cost item.
My lords, and also I may be permitted to take hand summons to LRs of deceased respondent number 2 and
No, let notice. Yes.
Cell number 43.
That's 43. I appear for the petitioner.
Yes.
That's the counsel on record. It's his wedding minutes. May I request the matter to be taken up next week?
This is the respondent 2 to 6 are filed the suit for partition. Expert degree.
Is seeking adjournment.
Any date next week. I'm not asking for it.
Because of the stay granted.
What is the reason for this for adjournment?
Milords, it's his wedding. It's the counsel on record.
This is matter on 27th of July.
Please, interim order may kindly
number-
be.
Interim order earlier granted is extended.
Cell
Yes,
number
Please,
44.
I'm grateful.
Charity S. Shetty for petitioner.
Appearing for petitioners, my lords. My lords, the arguing counsel is blessed with a baby, my lords. So she couldn't
In counsel.
come before the court from last few months, my lords.
My
lords, it's
And she couldn't make a process, my lords.
No, you have to take. When will you take the steps?
My lords, in a short date, my lords.
The respondent number 2 died in the year 2024.
We'll give him 1
Intense.
year time. After the baby is
Yes,
1
ma'am.
year old, then we'll be done.
Yes, my lords. Interim order may be extended.
Because that impugned order is that
This
they
is
had.
matter on in the month of August. By that time, the steps shall be taken in respect of the deceased respondent. Interim order earlier granted is extended.
My lords may say finally because it's a
Much
small
obliged.
obligations.
Hearing for the
A
petitioner.
date may be given, my lords, in the August, my lord.
Listed on 12th of August.
Obligations.
Appearing for the petitioners, my lord. The
35.
respondent number 15 is a subsequent purchaser, my lord. He was deceased, my lord. He was residing in Andhra Pradesh, Krishna district, my lord. I made an effort to secure the LRs of the respondent number 15. Meanwhile, I'm filing a memo to restrict my relief.
Office objections for paper publication. What about paper publication?
Kindly allow the, in rest of the respondent, kindly allow the application, my lord.
This,
I restrict my rights to against the respondent number 15, my lord. He was a subsequent purchaser of the part of the scheduled property.
It is stated that notice to respondent 15 is not necessary as the petitioner is giving up his the relief against respondent number 15 and is intended to proceed against the remaining respondent. Accordingly, memo is taken on record and the notice to 15 is dispensed with. Then what about the others?
I will take the paper publication against the
Rectification of
rest of
office
the.
objection, that you do it.
And it is a PF, my lord. Without an order, I cannot pay the PF.
No, it says for paper publication, because without a court order, you have,
Yeah, yeah.
you have filed the paper publication.
Yes, my lord.
The petitioner shall take out notice by way of substituted service in respect of, what happened to the earlier notices?
They were not yet been received, my
How
lord.
many times?
2 times, my lord. Meanwhile, I taken the hand summons also, my lord, but they were refused, my lord.
The petition is permitted to take out hand summons on the, no, the petition is permitted to take out, is permitted to file an, to carry out the take out notice by way of substituted service in respect of R1, R2, R7, R8, R13, R18, and R20. You shall come up with an appropriate application. Come up with the application.
I already filed an application, my
No,
lord.
you are saying, and after the application without an order, you have,
No, my lord. They raised the objection to pay the PF, my lord. That's all, my lord.
but you say, what was it? That's why I said you pay the process.
Now I will pay.
Do it.
Yes, my lord.
The petitioner shall comply with the office objections within a week. Yes.
Much obliged.
Cell number 46. Cell number 46.
For the respondent, K waiter. Copy is also not served. K waiter copy is also not.
Interim order is there.
No, ma'am.
This is no representation on behalf of the petitioner. This is matter in the month of September. It's 47.
Cell number 47. SP Mukkanappa.
Today itself, I took steps.
In respect of R10 and R12, as per the postal share, it is unclaimed amounts to deemed service of this notice. In respect of respondents R2, R6, R13, 14, the petitioner shall pay the process within 2 days or else
Today itself, I have already taken.
in the during the course of the day, or else there is an interim order. Stay granted by this court stands vacated. Interim order earlier granted is extended.
48. Dhananjay Kumar. Cell number 48. Dhananjay
Hearing
Kumar.
for the petitioner, Your Lordship. Your Lordship, due to oversight, we have filed this writ petition. I may be permitted to convert the petition to civil revision petition, Your Lordship.
Order 7 rule 11.
Yes, Your Lordship.
Huh? What is this?
The matter has been posted for maintainability, Your Lordship.
Miscellaneous.
They have challenged the miss case, my lord.
Civil miscellaneous case, Your Lordship. I may be permitted.
The office has raised objection with regard to maintainability. Can counsel for the petitioner submits that they were permitted to withdraw the petition with the liberty to file an appropriate petition accordingly.
Your Lordship,
petition is-
for conversion, I may be.
You want conversion?
Yes, Your Lordship.
Into a
Civil revision petition. Civil
CRP. The petitioner filed a memo seeking to convert this petition into a civil revision petition. Accordingly, memo is taken on. Petitioner permitted to convert this petition into CRP within a period of 2 weeks from the date of receipt of the copy of the order. Disposed for statistical purposes. Is 49.
Number 49.
Much
SK
obliged, Your
Mithun.
Lordship.
49. SK Mithun.
Petitioner, my lord. My lord, I have filed an affidavit regarding the payments. What is the due amount? Your Lordship had directed me to file the affidavit. I filed it. In furtherance, my lord, the difference amount between both parties.
Let's see the affidavit first.
My lord, I'm filing one difference to show the difference amount why they are claiming more, my lord. I'm filing one memo of calculation also.
First of all, we'll look at your.
Yes, ma'am.
Where is that?
It is filed on 16 June 2026, my lord.
16 June. Sixth or 16?
16.
Yes, 16.
16.
Yes.
My My lord, in para number 3, I have mentioned what is the amount due payable.
Execution petition is seeking recovery of 26 crores.
Yes, ma'am. That is the execution petition, what is there.
However, in the application produced as Annexure K, the respondent has alleged that he is liable to pay rupees 31 crores.
Yes, ma'am.
Which
Along
is
with
so-
the application, the latest calculation given by them is, my lord, at page number 146 of the petition, it is 30 crores 6 lakhs 46,000 or they have filed there, and in the application, that is the amount mentioned, my lord. That, my lord, my learned friend has filed objections to the affidavit filed by me.
So according to you, it is 27 lakh 48.
My lord,
27
exact amount according to me it is 27 crores.
48 lakhs.
No, it is little high because now I calculated till 23rd June yesterday. 27 crores 71 lakhs.
According to them, it is
27 crores 71 lakhs
31
29,000.
lakh, 31 crore 20 lakhs.
According to them 3120. According to me it is 27 71 29 224.
Lords, can I just pass on this memo of calculation, Lords?
Yes.
May I please, my lords? Lords, if your lordships is having the statement of objections filed by them, they have made some calculations in page number 6.
Lord, I meant to file objections to this affidavit, which they have.
Not that.
I'll
I'm referring to the objections filed by them.
Where is
Only,
that? Dated?
Lords, 8/6/2026, that's the date when they appear to have filed it.
Post that affidavit, there's another affidavit that has been filed for which the objection statement is also ready. I'll just pass it on, Lord. I'll just.
Lords, I'm not on that. I'm not on that at all. Lords, they have filed a statement of objections. They have given a calculation. I'm only pointing out from their statement of objections that whatever they have said in paragraph number 14 as the decree amount payable is.
No, I think that's not on record.
Set.
Your objections earlier filed.
8/6/2026, please, Lord.
Yes, 8/6.
Lordships may kindly take page number 6.
Yes.
Lords, in that there is a tabulated column at page number 6.
Yes.
Decree stroke award amount. Lordship gets it, Lords.
Decree?
Decree stroke award amount, serial number 1 in that table. The amount is 19 crores 5 lakhs 20,187.
At page number 6, I'm looking at.
6, paragraph number 14, Lords. There, in the second column, in the third column, 19 lakhs 5,000 20,187 is mentioned. I'm sorry, 19 crores. Your Lordship is not. Page number.
Not, yes, 19 crores is mentioned.
Yes.
19
Now, Lordships may kindly take page number 12, 1, 2 in the same statement of objections.
Yes.
Lords, the award amount is 18 crores 92 lakhs 20,187.
Yes.
Now, the amount mentioned by them as 19 crores 5 lakhs 20,187 along with the interest which was awarded. Now, entry number 2, interest on so and so. They have calculated it as 11 crores 16 lakhs 80,000. If it is calculated for 18 crores 92 lakhs 20,187, it becomes 9 crores 14 lakhs 49,690.
So interest according to them is 11 crores.
So that is because they are calculating it on 19 crores 5 lakhs, which should have been calculated on 18 crores 92 lakhs. Number one. Two, my lords, lords may kindly turn to the next page.
Yes.
Future payment of electricity charges is not a part of the decree. We have paid this nonetheless. We have produced documents to show this 92 lakhs is already paid. But I am only standing guard to say that this is not the decretal amount. It's not a part of the decree. Then next, 4, item number 4. Notice fee and expenses of the arbitrator, 4A, is part of the award. B and C is not part of the award, which they have added by themselves. And again,
So in execution, how can you add?
Lords,
all
I'll explain.
Lords,
Award,
can I just persuade to say this, Lords? I don't want to stand on this. Calculation, let it be done, no difficulty. If the calculation is to be done, if any money is payable, I'll get it paid. But the ingenuity with which it is presented, Lords, I take a very serious exception to it. It's an execution proceedings. Lords, what we said is, I stand even on the merits of the matter. This honorable court, when they wanted to protect their interest after I filed the appeal under section 34, said that 5 apartments is sufficient for the purpose of satisfaction of his decree. And remaining, I am entitled to deal with it. They took the matter to the Supreme Court. Supreme Court confirmed that order. Then they again come back before the executing court and seek for attachment of all the apartments in excess of 5 apartments. So when I argued this matter, I only said that all these facts were already before the court. Court should attach the property which is sufficient to recover the decretal amount. There is no necessity for the attachment to go beyond the decretal amount. And this honorable court had already recorded that this is sufficient, and the Supreme Court confirmed the same. Now, when I came before the court, this is the submission so far as merits is concerned, that they can't attach a property anything more than that. Because this submission, what I submitted was, I understand and realize that I have suffered a decree. I am bound to pay this money. Now, these 5 apartments were meant for this purpose, even as recorded by the learned single judge of this honorable court, which is confirmed by the Supreme Court. What I said is, upfront, I'll pay 5 crores. 1 minute. On that day, the submission which I made was, upfront, I'll pay 5 crores. Then I've given a schedule when I'm going to make the payments and how I'm going to close this case. If after payment of the admitted amount, now I say, I have filed a memo of calculation, that according to me, the calculation, because in mathematics, there cannot be something like 3 plus 3 will become either 5 or it will become 7. It should be 6 only. So there is no way that the calculations will go wrong. So whatever be the calculation, the attachment may be restricted to 5 apartments. And I have already stated, Millards, that your lordship is permitting us to sell one of the apartment and then 2 of the apartments. How we are going to make the payments? Notice all these properties are already intact, and the other properties will remain with me. Notice if this is the statement made, he comes and says, no, you will have to agree to the figure which we are giving. That's essentially the manner in which the objection statement is filed. He boosts the figure by 3 crores, 3.5 crore rupees, including certain components which is not part of the decree and does not even stick to the decretal amount. He enhances the decretal amount, saying that it is not 1892, but it is 1902. Notice now, whatever is there on record, lordships may permit me to undertake the kind of sale which I am doing. When I made a statement that I am offering 5 crores, our client could accumulate another 2.5 crores. Upfront, I am paying, today I am paying 7.5 crores. Out of about 27 crores, which according to us is due. And I'll give an undertaking, that 2 of the apartments, over and above the apartments which I'm...
What's the award pass?
Notice the award, 6/7/2023, and the Supreme Court, 28th of April 2026, the Supreme Court dismissed the SLP. Till this time, my lords, this understanding was there of the learned single judge. Can I just take your lordships to that order, my lords, of the learned single judge? Lords, at page 125, along with the writ petition papers. At page 131, paragraph number 9, your lordships may kindly take. Some reasons are assigned, my lords, as to why 5 apartments is more than sufficient. Now it will be much, the value of the properties have increased. It will be much lesser. I may not go even up to the 5 apartments. Can I just read it, my lords, para 9? So and so for the petition and instruction submits that the impugned order passed with the trial court may be set aside, application I2 may be disposed of, directing response to hand over the keys in relation to 5 residential apartments, excluding flat bearing number 301 measuring 2893 square feet, 3023850, 5012910, flat number 5023863. It is submitted that the sale deed dated 7/2/23 executed by the respondent in relation to the flat bearing number 1001 measuring 2950 square feet was for a sale consideration of 4 crores 33 lakhs 80,171, and consequently and proportionately 4 residential apartments measuring overall 13,516 square feet would fetch more than 25 crores, which was sufficient to satisfy the claim of the respondent, including the arbitral award passed in its favor. It is therefore submitted that the impugned order be set aside, I number 2 be disposed of. So and so respondent submits that apart from the fact that trial court does not record any finding regards the valuation of the apartments in respect of which directions are sought for, the sale deeds in relation to the properties already sold by the response, including providing of additional facilities, amenities, etc., are not contained in the order found in the apartments mentioned by the petition. Consequently, 4 apartments offered by the petition would not be sufficient to satisfy the claim of the respondent if he succeeds. It is therefore submitted that there is no merit. On a perusal of the undisputed material on record, it will be indicated that petitioners already deposited 1 crore 65 lakh 65,000 before the arbitral tribunal, which continues to be in deposit till today. Even as per the calculation submitted by the respondent herein as per the arbitral award, petitioner would be liable to pay a sum of rupees 22 crores 89 lakhs as on 10/2/2024. In this context, the perusal of the sale deed dated 17/2/23 in respect of flat number so and so will indicate the same was excluded a sum of rupees 4 crore 33 lakhs in relation to the apartments. Well, so I just pause here for a moment. This calculation what they had given on 10/2/2024, I intend to place it on record. This is calculated up to 10/2/2024. What they need to do is only calculate the interest from 10/2/2024 till date, which comes to about 5 crores. I just indicate that. Next. It is also significant to note that flat number so and so 2910 square feet and 2893 square feet respectively are amongst the flats offered by the petition in addition to flat number 302 and 502, which obviously fetch much higher value than 4 crore 33 lakhs referred to supra. Under these circumstances, the cumulative effect of the entire material on record would lead to unmistakable conclusion that 4 residential apartments offered by the petitioner in the memo dated so and so coupled with 165 already deposited would be sufficient to safeguard the interest of the respondent, even assuming AS is ultimately dismissed by the trial court. Consequently, it cannot be said that no prejudice would be caused to the respondent. If directions are issued to him in respect of 5 residential apartments, respondent would be entitled to retain the case in respect of 301, 302, 501, 502 and 702. Respondent would be entitled to the keys to retain the keys in respect of 301 so and so. In addition thereto, petitioner would hand over the keys of 502 to the respondent towards security of the amount claimed by the respondent. The respondent is directed to hand over the keys in respect of 1202, 1301, 1302, 1501 and 1502. Now, these are the keys which is required to be handed over to us. They have handed over to us pursuant to this. Now, this we have filed along with our affidavit dated 16th June 2026 was challenged before the Supreme Court. This order, my lords, of the learned single judge. Supreme Court dismissed the SLP, saying that the court does not want to interfere in this order. Now, with this on hand, they again go back to the executing court. Now, your lords may kindly take page 135. At page 137, they again do the same thing. 19 crores, 5 lakhs, 20,000.
What was the order impugned before
That's
the court?
order impugned before the?
The order which you are reading at page number
Lords,
125.
there, if your lords were to see, my lords, at page number 125, there was a direction which was sought for handing over the keys.
To hand over the keys of the residential.
Yes, it was rejected. That was allowed. So these apartments 1202, 1301, 1302, 1501, 1502 are with me. It will be with me. I can give an undertaking that I'm not going to create any encumbrance or third party rights in respect of these properties. Now, if your lords were to come to my affidavit minutes,
When is it filed?
it's
16.
Now within quotation.
16/6 affidavit.
Now,
Affidavit
ABCD.
filed on 16/6 by the petitioner, please.
Lords, this is an affidavit.
Yes, yes. 16/6 itself.
Yes. ಅದಲ್ಲ ರೀ ನಾವು ಯಾವಾಗ ಕಟ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದು ಇದ್ರಲ್ಲೇನಾ? Lords, in this, if your lords were to see, commencing from page number, paragraph number 9. Lords, we have produced one of the sale deeds, which is recently executed by this respondent decree holder, para 9. I submit that as per the sale deeds executed by the respondent in respect of similar flats during the previous year, sale consideration is 16,844 per square feet. On that basis, the value of the aforesaid 5 flats is approximately 29 crores 27 lakhs 31,876, even during the previous year. I further submit that the present market value of the said flat is approximately 20,000 per square feet. The aggregate value of flat numbers 301, 302, 501, 502 and 5702 is approximately 34 crores 75 lakhs 80,000, which is substantially higher than the amount claimed in the execution. I submit that the order dated so and so, my lords, I have just stated the same thing. Then can I persuade your lords, may kindly come to paragraph number 11. I submit that this honorable court may therefore be pleased to modify the impugned order produced at Annex A and give the attachment in respect of the remaining flats. That the remaining flats I have given those details, as well as the residential house bearing number 212 situated at the 3rd stage, 2nd block, Judges Colony, Basveshwar Nagar, Bangalore. No, it's not only the apartments. My residential house is also attached. But the 5 apartments itself is more than 35 crores as it things stands. Then, without prejudice to my rights and contentions and in order to demonstrate my bona fides, I undertake to deposit a sum of rupees 7.5 crores before this honorable court on or before 16/6. Upon depositing 7.5 crores, I pray that this honorable court may modify the impugned order at Annex A, release the attachment in respect of 501 and 502 and direct the respondent to hand over the possession thereof to me. I submit that I have identified the prospective purchases for the aforesaid flats. In order to facilitate the proposed sale, respondent cooperate by producing and making available the original title documents for inspection by prospective buyers and their bankers or financial institutions and legal counsel. I further undertake to deposit an additional sum of rupees 10 crores on or before 16/7/2026. Upon such deposit, I respectfully pray that this honorable court may please modify the order to release the attachment in respect of flat 702, and if he hands it over, further sum of rupees 5 crores will be deposited on or before 28/2026. Notes, everything will be paid on or before 15/9/2026. To bring one property to sale, proclamation, and to comply with all these requirements will take 6 months. I am saying, my lords, that within this period I will. Lords may put me on terms. And I am making a statement, my lord, so far as the other apartments which your lordship is releasing from the apartment is subject to an undertaking that I am not going to sell any of these apartments till these execution proceedings are closed.
No, the court records that he has to recover an amount to a tune of 30 crores 6 lakhs 46,085.
I am making a statement, my lords. Now, this entire 30 crores, I am saying that on or before 15/9, I am going to pay this.
This is 10th April 2026 is the order.
Yes.
So you are going to pay this entire amount when?
Lords, on or before 15/9/2026. Lords, now what happened when we filed this affidavit? Lords, they wanted to file objections to this. Then they filed their objections giving their own calculation. This calculation can be kept at the end, my lords. Let them take the money first, whatever is coming. At least as a prudent person who is holding a decree, that's the first thing which I will do. I will collect the money, whatever is required to come first. On 15/9, we will decide how much is the due. If there is any due, definitely we will have to pay it.
Please, my lords. I am not coming in the way of they paying me money. I would be more than happy to accept it because I am here to recover the money. I would be more than happy to take the money. I am not coming in the way. All that I was wanting to say is, let us come to the number clearly so that there is no ambiguity at the end. That is all I was trying to please, my lords.
What we do is,
Lords,
it's good for you that you get the money first, and then we are not determining anything. This is the amount.
Please, my
So
lords.
as of now, they say this, how much? 30 crores for 30 crores 6 lakhs 46,085.
Lords, according to our memo of calculation, my lords, the amount payable comes to 27 crores 71 lakhs 29,224.
At least we have to consider as it is stated by the court.
My lords, that's the reason why I said, Arithmetics, there is no way that anybody can commit a mistake. I therefore brought it to your lordship's notice that they have put an amount which is higher than the award amount for the purpose of calculation of the interest and claiming the principal amount. As against 1892, they put it as 19.5. And then they loaded the interest on that 19.5, which is enhanced by 2 crores. They loaded it by another 92 lakhs for the electricity payment charges, which actually we have paid, but it's not a part of the decree. Two more components is another 35-40 lakh rupees, which is that legal expenses and the stamp duty, which cannot be a part, because award very specifically says what is that which is entitled to be recovered, not costs. When it comes to cost,
So the difference of amount is 4 crores between your
4
calculation.
crore 33 lakhs.
3
4 crore 33 lakhs is the difference amount, please.
No, 3.4 crores.
No, no. My lords, 27 crores 48 lakhs 73,589 is what totally they've agreed to pay.
No, there are about, the keys are with you, or of
Keys are
5
with them.
properties.
Keys are with them.
No, 5 properties.
Only 5 flats, which was
5 properties are the keys are with them, which is subjected to attachment. Now those 5 flats I have to sell. Now I am offering 7.5 crores demand drafts. I am carrying it in my hands. Lordships may release only 2 apartments. I have mentioned in my affidavit. Your lordships will see the bona fides. 10 crores will again come to their account.
How much each apartment costs?
Pardon me, lords.
What is how much each apartment, what is the rate?
Lords, it is roughly about 5 to 5.5 crores, lords. Roughly about 5 to 5.5 crores in the first 2 apartments. Lords, 20,000 rupees is the running rate there. Now,
No, there are 4 or 6 apartments.
5 apartments are there. Total extent of the square feet.
If you see, whatever, if you take as per your calculation, it's coming to only 20 crores.
Lords, 35 crores it comes, lords. Each apartment is in different dimensions.
No.
Per
There are
square
2
feet,
dimensions.
lords,
2 dimensions.
there are different dimensions. Each apartment, if it is calculated in terms of 20,000 rupees per square feet for all the 5 apartments cumulatively, it comes to 35 crores.
No,
I have given the calculation.
Now you want 2 apartments to be released.
Yes, I will give.
If you sell those 2 apartments, how much you'll get?
Lords, I'll get about 12 or 13 crores. But I am already got some window financing so that I can show my bona fides. The first thing which came up from your lordships is as to I should show the bona fides. So I've arranged for some window financing, lords, so that I can give them 2-3
For
crores.
paying 7.5.
7.5 I am paying.
Next.
10 I will pay it within 1 month.
How much?
10 crores. Lords,
Thereafter, another 2 apartments have to be
another
released.
2 apartments. Lords, then I'm asking for release of only 1 apartment thereafter.
So totally you're going to sell 3 apartments.
Lords, no, I will sell all the apartments as long as the decree is not satisfied. The reason why I have given this is that let the court may also have confidence in me that I am not asking for release of entire apartments.
What I'm saying.
Give me
So
on an
now-
installment basis. I will sell 1 by 1 and give the money.
Now, now you want to sell 2 apartments.
Yes.
2 apartments have to be released, you will sell.
Yes.
You will pay 10 lakhs by
10 crores,
10 crores by
within 1 month.
1 month from today.
Milords, a lot from the date of the order, because they will have to, there is one hitch, Milords, in this. They are having the original documents and the keys, the inspection. So your lordships may fix a date for that, Milords, from that date 1 month. It may be another 2-3 days also, like Monday or Tuesday.
Let's take, it is on 29.
Yes,
So 29 means by 29th of July,
we will pay 10 crores.
then.
Then
after-
I am seeking release of only 1 apartment, Milords.
Then we will list that matter on July.
On
10th.
that day, your lordships may list the matter. We will deposit this 10 crores. Then your lordships may pass further orders.
Yes.
Milords, as per the affidavit that has been filed, they want to lift the stay order in respect of the remaining flats, apart from these 5 flats.
That is subject to my Milords, what is meant by attachment under Order 21, Rule 54? Attachment means there will be an embargo on me to sell the property. I am giving an undertaking that I will not sell the property till such time the decree is satisfied. Milords, what more can I do, Milords? I am giving 7.5 crores.
If that's the case, if the attachment warrant is enforced, what will happen?
Milords, now what happens is I will not be in a position to let out the property, or the people who are already in possession of the property because their keys were handed over. They will be put in some stress. Milords, I am giving an undertaking. I will not sell the property till the decree is satisfied.
Attached now. by
Milords,
virtue
that
of this
is,
order?
if your lordships were to
12
see,
flats. 12
12.
flats.
Milords, 12 flats and a residential house.
Milords, residential house, we didn't even go for the attachment, please, Milords. Though there is an order, we have
There
not
is
even
an
gone
order
for
of
the
attachment.
attachment. We understand, we didn't even go.
Anyhow, a
Please,
word is passed in the year 23.
Please,
We are in 26. Till
Please,
now, you
please.
couldn't realize any amount.
No.
Now, only we are talking about something a month, July.
Well,
July, what is
absolutely.
it?
In days,
The
my
time
lords.
schedule should not be a
29.
challenge at all, please, my lords. All that I'm saying is, 2 flats which they would want it, may be released, should not be an issue. The other releases, let the payments come in, slowly they can be released, please, my lords. Not an issue.
Lords, an attachment cannot be
Even otherwise
kept
they are
beyond.
undertaking- even
Lords,
otherwise
an
they are undertaking
attachment
that they will
cannot
not
be
be
kept
selling.
beyond the value of the decree.
Lords, this pressure is only
that is
brought
the-
them here to get me money is recovered, please, my lords. If this pressure is gone, I would be taken for a ride, please, my lords. If they are undertaking, let the attachment continue, please, my lords.
I fully
All that I
acknowledge,
would
my
say.
lords.
No. what we do-
Execution is
no,
not
no,
all about pressure. It's all about enforcement of a
for
decree.
releasing these two properties.
Please,
No,
my
these are the flats which are under attachment which he wants to sell.
Yes.
Yes.
My lords, 5 apartments, which the learned single judge refers to, those are the apartments which we have kept to satisfy the decree. That is the statement.
Apart
which-
from that, other apartments.
Another
are
7
attached.
apartments are there. I am giving an undertaking before this honorable court. I will not sell.
No, you have these 5 apartments that will satisfy.
Lords, more
the
than
amount.
35 crores I am recovering in this.
What is apprehension?
Not about the apprehension, please, my lords. The value what they have arrived at, I do not want your lordships to get into all of that now. If I take the valuation today, this doesn't really match with what they are saying. It actually increases. In fact, my lords, the
Anyhow, they are quoting their own rates. Ultimately, that's for your benefit.
So, my lords, what happens is the order of attaching 5 flats was of the year 2024. And at that point in time, the decretal amount which was recoverable was around 22 crores. Today we are at 32. And 2 years time has been passed by. At that point in time itself, 5 flats was sufficient. By now, my lords, it's quite obvious that it should be 7 plus 1 or 8 at least.
I can assure
Keeping the
this
buffer
much,
in
my
hand.
lords, that
Out of 12, my lords,
14,000
at least 8 is minimum required. But my lords, I am allowing them to sell
No,
the
attached is 6 or 7.
well,
my lords,
5 plus
my lords,
7.
5 plus 7 plus residential
5 was
house.
earlier. 2 I am releasing, my lords. 2 I am releasing. It will come down, my lords, now to 10. The attachment will come down by 10.
If that is the stand, my lords, I will take an order on the merits of the matter. Solid, I'll take an order on the merits. There can't be an attachment beyond the decretal value. They have sold the property in 2024 for
The value has to
18,000.
be determined.
I'll-
It is not been
I'll-
determined.
Lords, they have sold the property at 18,500 rupees the previous year. In 2025, they have sold an apartment at
Correct.
18,500. Let's just kindly see page number
Which I have sold is a
165.
model apartment which has all the amenities and the price of which is very different. In fact, I can produce their own sale date which says that it is even more lesser than what I have sold for, which is in the month of December 2025. Millards, if I get into the valuation now, it will be another round of discussion, Millards, what is the actual valuation? And we'll be going away from the,
No, that attachment with regard to the residential property, that can be raised.
My lords, I am saying that I am not going to sell these 7 apartments because I am already offering these 5 apartments for sale. In the event the sale of these 5 apartments pursuant to the orders of your lordships does not fetch the,
Where is that? Did you say so in the affidavit?
yes, my lords.
Millards, if I can propose one
That-
more,
that-
one more wide.
My lords, that's the reason why I said, my lords,
Here, what is
if
the-
execution is not a pressure tactic, I really fail to understand, my lords. If the execution has to be pursued, it should be pursued in a manner known to law.
Millards,
Your lordship said that you will have to show your bona fides. I am here before your
Let's
lordships.
hear what he says.
Please.
Millards, 1701, 1702, 1801, 3 flats, Millards, are in the custody of the tenants. I've told. I'm ready to forego those 3 apartments immediately, please, Millards.
What is that? 17?
1701, 1702, 1801.
1, 2,
1701, 1702, 1801, please, Millards.
Mm.
These 3 flats are in the custody of the tenants.
Mm.
I will immediately release them, please, Millards. I have no difficulty about it. Apart from that, 2 more flats they are asking for, which is in attachment of this honorable court. Even that can be released, please, Millards. Put together, they get about 5 flats.
What are those 2 flats?
But they have to tell the numbers which they
Yes,
want.
yes, Mr. Nippon.
Lords, we have indicated, my lords, the 501 and 502.
So about 5 flats they get, please, Millards,
Out of 12.
out of them.
And now,
On a payment of about 7.5 crores. The remaining 2 flats will be released. 1 flat will be released. Millards, another 10.
I
10
have
crore
a very
payment.
serious objection to this, my lords. Even if it is required, lords, I am making a statement. I am not going to sell the property. I'll file an affidavit. I'll not sell the property. My lords, this assurance should be good enough because it is assuring that the decretal amount will be secured. Why should they insist of, it is, as he said, my lords, they want to do this as a pressure tactic.
No,
Execution.
no, absolutely
No,
not.
that's essentially what I understood from this.
Absolutely not.
Now, My lords, they have sold these apartments.
I am
The
here to
learned
only
single
recover
judge
my
takes care of the fact, my lords, in the previous round, the learned single judge refers to the sale deed executed by them to come to the valuation of the property in 2023 at these 5 apartments at 23 crore rupees or 24 crore rupees. That's what is observed by the learned single judge. Lords, now the property values have increased substantially, definitely more than the interest which has been awarded by the arbitrator. We are confident to say that one apartment will still be left with me out of these 5 apartments when I pay this entire money.
Comes to the respondent. Now, what was, according to you, what was the price they sold it in 2025?
Lords, page 165 minutes. I produced the sale deed.
How much? What was the price?
4 crores 90 lakhs.
That could be, we can take it as a base price.
If even this is taken as a base price, my lords, I will,
29 crores.
even if this is taken as a base price, I'll achieve 29 crores from 5 apartments.
My lords, 12/12/2025, December 12th, 2025, which is very latestly sold. 3 crore 50 lakhs is the value at which the flat, my lords, measuring, yes, 1 second, measurement of this flat, yeah. 2,910 square feet of the flat.
2050.
2,910 square feet flat has been sold at the price of 3 crore 50 lakhs. And the price comes down to our, my lords, to 12,000 per square feet. 12,050.
And how, like, there are about 5 flats now.
Please, my
The
lords.
extent of the flat is
My lords, in
different.
that 5,
16,000
2 gets
square
released,
feet, my lords.
my lords, in that 5, 2 gets released immediately now.
16,000 square feet.
So it's 15,000, all the 5 to put together,
It's
Please,
about
my lords.
16,000 square
Yes, please,
feet.
my lords.
16,000. So 16,000 into, what did you say?
12,000.
My lords, it is not my sale deed. I don't think it's,
Just see, let's just say.
my lords, my lords, the apartments there, my lord, this is next to Ramakrishna Ashram, which is one of the most,
12,000, what
my
did you
lords,
say?
not less than 20,000, my lords. If they are having apartments at 12,000, I am ready to purchase straight away.
Yes. Is it
No, me,
12,000?
I myself personally, I will take it.
12,000?
No, I am very interested.
12,000.
I am ready to take it.
12050 is the price at which the latest sale deed has been placed, my lords.
Not by me. This undervalued sale deeds will have its story.
Where is it? We have not provided this.
Not less than 20,000 rupees square feet today. There is no way that area will get anything less than 20,000. This is the corner property, my lords, next to Ramakrishna Ashram, one of the most prime localities of this city.
No,
Most.
We'll balance the interest of both the parties. Let there be, like, out of now, attachment is in respect of 7.
All right, my lords. Lords may keep it for 7, 5 let them release,
That's
and
what, my
then
lords,
subject to
I'm
that,
ready,
your lords.
I'm ready to go for 5, I've said, please, my lords. 3 tenanted and 2 other ones, and 5 gets released immediately. Rest of the amount, let them keep paying. I'll keep on, my lords, for releasing all of their property.
Let's come to this affidavit final where they have stated.
And
There the dates will vary, my lords, because when they filed the affidavit, they did not take this offer. So the dates has passed.
We are suppose, which affidavit I have to look at?
Lords may kindly have a look at the affidavit dated 16/6/26.
My lords, formal objections to this 16/6 of affidavit, I'll place it on records, please, my lords. This has my calculation memo. Let that be on record, please, my lords.
Then a senior counsel appearing for the, then counsel appearing for the petitioner, representing
ಯಾವ್ದು
the
ಇನ್ನೆರಡು
counsel.
apartment ಯಾವ್ದು numbers?
An affidavit
Other than 5, another 2 apartments in the, which 2 apartments,
Stating
tell
the-
me. Yes.
My lords, one small correction with the flat numbers, 1801, 1802, 1701.
1 minute, 18,
01, 1802, 1701. 1702.
1701, 1802, 1801 and 2.
No, my lords. 1702, 1801, 1802. Apart from this, 2 other flats, whatever the numbers they would want, I would.
No, they said it's 501 and 502.
Please, my lords.
An affidavit is filed before the court. Dated
20 and 2001, 2021. I'm sorry, my lords, just to the, lords may continue the attachment in respect of the apartments which was subject matter of the earlier proceedings. That is apartment numbers. Can I just tell the apartment numbers, my lords? That is apartment numbers, right? Lots 301, 302, 501, 502 and 702. 5 apartments.
This is with regard earlier order, which is.
Earlier
confirmed.
order. Lots in that your lots is indulgence is sought for in respect of 501 and 502.
502.
In addition to this, lots let the attachment may continue in respect of 2001 and 2101, which is 6,005. 2001 and 2101. These are 6,500 square feet each, which are put together. Sorry, put together. These are duplex apartments. So these are bigger apartments. So 2001 and 2101, it can continue.
Actually,
For the other properties, it can be released.
It is only one single flat and it is measuring 5,108 square feet. If I take your lordships through the orders of the impugned order at page number 24, 2001 and 2101 put together is one single flat. It is not a separate flat. It's a single flat having 2 numbers because it's a duplex. And my lords, it is 5108. In all, put together as one single measurement. It doesn't have 51081 and 5108 of two separate
Total
flats.
put together only the.
Put together one single flat, please.
Sorry, my lords, I stand corrected. 5,108 square feet. Almost, it's a duplex. It's the biggest apartment. This itself is about 12.5 crores. This apartment. If I sell it today, I will sell it at 12.5 crores.
Those are the flats given to the landowner and the developer. Developer is already residing there. He's yet to come in. That's all. That is not to be sold at all by any of the parties.
Anyhow, let's forget about it. So
No, I
what
can
they
sell
say is, what about this one, 1702, 1801 and 1802, they say there are tenants in that.
Yes,
So let
17
the attachment warrant be lifted in respect of this. You don't want?
Let's let it be lifted. My lords. I am only saying that in addition to 5 apartments, the attachment may continue in respect of 2001 and 2101. So that the total value, even according to their value, if it is calculated at
Come to the impugned order, what are the numbers? There are so many numbers.
impugned order, my lords, there is
24, please,
absolutely no reasonings assigned.
Impugned order, page number 24 of the petition copy, please, my lords.
It mentions about.
No,
The table is there.
lords,
The table is there.
impugned order doesn't say anything about it. It only extracts the table of the annexure which is produced by them. And of course, I am not disputing the contents of this
says-
measurements.
No, ultimately, in respect of all these 12 apartments, there is a attachment now.
Yes. Now 5 your lordships is
According to you,
confirming.
only except 201, 2001 and 2101.
Yes.
In respect of all other apartments, it has to be lifted.
No, 5 and 2001 and 2010 in respect of all other apartments, your lordships may lift the attachment. I am only saying, my lords, that out of this 12, your lordships will be lifting it.
Totally, we say, I say what he accepted and I also suggested,
Lots.
total 7. Total 7. In that, this 1701, 1702, 1801, you are having the tenants.
Yes,
So that would be lifted.
very well, my
3.
lords.
And 2 will, and anyhow, you are saying 201, 2001 and 2101.
That is 5,100 square feet. That itself is sufficient, my lords. Even calculated at 12 lakh rupees, 12,000 rupees also, it is sufficient to
No, anyhow,
capture the remaining amount.
No, 1, 2, that 3 we will raise. And if you want to keep it, you keep it until some other number. Then that we will lift the attachment.
ಅದಲ್ಲ ರೀ 5 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅದನ್ನ ನೀವು ಮಾರಾಟ ಮಾಡ್ತೀರಿ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಈಗ ಒಟ್ಟು 12 ಪ್ರಾಪರ್ಟಿ 7 ಇದೆಯಲ್ಲ 7 ಪೈಕಿ 1501 ಆಯ್ತು ಲಾಟ್ಸ್ ಅದರ್ ದನ್ 1501 so your lordships may pass an order in respect of 1301 and this 2001 and 2101. That will be 2910 and 5108. It will be very substantial.
So
6 and 12.
6, 12.
The lordships is continuing the attachment. In addition to the other 5 apartments.
501
And you
and
2 we are
502
releasing
rupees.
it.
501, 502, it is only a conditional order, my lords. Your lordships is releasing it now by virtue of this order, as a result of which the apartments will be sold and I'll pay the money. So essentially, the attachment will continue for 7 apartments, out of which 2 your lordships is releasing. Out of 7, 2 your lordships is releasing.
No, that's not the one. Now, 1701, 1702, 1801, we are anyhow releasing it.
That is true, my
We are
lords.
lifting it. Three
That is true.
are out of it now.
Yes,
And two, by virtue of this order, another two. It comes to five.
true, my lords.
Then what about the remaining one?
Lords, that's the reason why I said, now, if 2 are released, 7.5 I am giving, 10 I will give them. So 17.5, which is more than 50% of the amount, which is as per their execution claim itself, is satisfied by releasing of only 2 apartments. So I will be paying them more than 50% of what they have sought for in the execution. Then next, when the matter comes up next, your lordships may decide. But as things stands, with just 2 apartments, your lordships may take note of this, that more than 50% of what they are asking for in the execution is getting paid.
No, where is the house property in that?
Lords, that
Lords,
is in
previous
Basaveshwar
page-
Nagar,
Previous page.
Annexure
23.
1.
Page number 23 it is there.
That is,
Page number 23 of the impugned order, page number 23.
so
Previous-
essentially, my lords, attachment will continue for 301, 302, 702, and 1301, and 2001 and 2101. So it will continue, still continue.
301, 302?
301, 302,
Hmm.
then then 702,
702, yes.
yes, and then 1301,
1301, yes.
and 2001 and 2101.
So 1, 2, 3, 4, 5. 5
5 will still be there with them. After paying
it
another.
really amounts to 6
Yes.
because that's too.
I was wanting 2 more, please.
Lords, is it a case, case
that's-
of wanting some? I really fail to understand. My lords.
Okay.
Let them give the valuation. I'll give the valuation.
Discussion was that-
Your lordships may
discussion was
appoint a
that they wanted
valuator
me-
for it.
No,
What is this?
no, 6 apartments. We will raise this attachment in respect of the remaining. Now it is in, number is 12.
12 out of 12, 7 they're wanting to lift the attachment.
Hmm.
I was
6.
Lords, your
Seven,
lordships
seven.
may not lift it unconditionally.
7.
I am making a statement. Your lordships may not lift it unconditionally. Lordships may lift this attachment subject to the condition that I undertake that I will not sell this apartment till the decree is satisfied.
Yes, please come. Agreed with the order passed in execution number 25302 of 2024, dated 10th April 2026. The judgment retard is before this court. By order impugned, the court had
ಯಾವ್ದು ಯಾವ್ದನ್ನ?
501, allowed the IA filed with DHR under order 21 rule 41, 2 and 43 and 54,
All right.
read with 151 CPC. And
My
an
apologies,
order
there is
of-
one correction in this, my lords. 501, 502 and 1501. 3 apartments we are selling.
No, that is later.
Lords, we are
Lords,
selling
they
it,
said
my
2
lords.
apartments
No,
to
no,
be sold.
3
Now
we are
3
selling.
Lords, I'd request then one thing. 15 crores, let them deposit, please. What?
After giving 10 crores. No, then that's not required. my lords. It is, he wants this permission after paying 10 crores. So that can be passed, an order passed after this.
What did you write? Allowed the IA and passed an order of attachment in respect of 12 apartments in apartment complex known as Siddha Shekha Marcus. When a senior counsel appearing for the petitioner submits that
Why did you take the DD? in the name of the court?
the petitioner has come up with an affidavit stating that if apartment
Then last time
501
I
and 502 are released and within 1 month, as on today, they are ready to pay. They are ready with the DD for an amount of rupees 7.5 crores. 7.5.
7.5 crores. So there is,
7.5 crores.
what they have done is they have taken the demand draft because last occasion your lordship said deposit. So they have taken the demand draft. I am assuring my learned friend, tomorrow morning, we will change the DD and hand it over to him at least by noon. That assurance, my learned friend may have it. I'll get it, the DD is changed and hand it over.
7.5 crores.
Yeah.
And it is submitted that if this 501, in respect to 501 and 502, if the attachment is raised within 1 month from the date of receipt of the copy of the order, they'll be paying an amount of rupees 10 crores. And thereafter, if another apartment, that is 50,
Lords, 1501.
thereafter, if 1501 is if the attachment,
Second
that,
round,
amount-
ಯಾರು-
that,
ಯಾವ್ದು ಮಾರಾಟ ಮಾಡ್ತಾರೆ?
that flat is released, they will be paying. They'll be paying another amount of,
But as per the affidavit, another amount of 5 crores
10 crores. 10 crores.
within, no, 5 crores. First is 10 crores. Then we are going to make a payment of another 5 crores within 1 month thereafter.
within 1 month.
No,
from
my lords, I was
thereafter.
told 10 crores.
It is there in the affidavit, para 16. And within 1 month thereafter, the entire amount will be closed. Because if I have shown my bona fides by depositing 10 crores plus 5 crores plus 7.5 crores, it's about 22.5 crores. Then your lords may release whatever is required.
28.5 crores is their admitted amount, please, my lords. 28.5 crores is their admitted amount. I am at 32.
I'm not on the figures.
Difference is about 2 to 3 crores, please, my lords. What I'm saying is let them make it 10 crores. They're anyway alienating the properties now.
What we do is, that's a submission. Now the order would be.
Please, my lords.
On, by that date, once they pay you the 10 crores, then we will pass another
Please, my
order.
lords.
Our,
Not
my lords,
passing any
selling
order
an
by-
apartment is not so easy. We are giving the apartments. It is not so easy to sell an apartment and give the money. I am undertaking this, that I am going to do it within 1 month and paying it. Why are they getting so unreasonable at this stage?
After another apartment, that is 1501 is released, they'll pay 5 crores. And within 1 month thereafter, whatever is the outstanding amount, as there is a dispute between the petitioner and the respondent with regard to the amount payable, whatever is the amount determined by the court, they will be paying the same. And the entire amount will be cleared by, you said?
My lords, now it stands revised because within 1 month thereafter, after the determination, within 1 month, we'll clear the entire dues.
That would be on the last, after.
Yes, that will be the last order, my lords.
And it will be paid within 1 month from the date of determination by this court. It is submitted that apartment number 1702, 1801 and 1802, 1802 and what is the other apartments?
Lords, 1701.
1801, 1802, 1702.
02 are in
3
the
flats.
occupation of the tenants, as the petitioner is assuring to pay the amount and file an undertaking. The attachment these properties, with regard to these properties, the attachment order may be lifted as far as these flats are concerned. Concerned. Accordingly, this court is passing the following order. The petitioner, the petitioner has handed over DDs for an amount of rupees 7.5 crores and 7.5 crores. And if there is,
Tomorrow they are handing it over to me in the morning.
and that they will hand over the amount of 7.5 crores by tomorrow afternoon.
Please.
Number 2, the attachment is lifted with regard to the residential house. Where is it?
Basveshwar Nagar.
Number 202, third stage, second block, Judges Colony, Basveshwar Nagar, Bangalore. Then number 2, the attachment in respect of 301, 302, 702. No, that's not the number, I think. The attachment in respect to 1701, 1802, 1801, 501, 502.
No.
Correct. Is it to be
17,
raised?
one second.
It is to be raised.
1702, 1801, 1802.
1801, 1802 and 501 and 502.
Please.
In respect of this, the attachment is,
Correct,
in
please,
respect
Manoj.
of this
Correct.
is listed. List this matter on when? 10th of, no, I said it is
29 July.
29 July. List this matter on 29 July. Basing on the payment of 10 crores, the further orders will be passed.
Lords, just one indulgence, my lords. They have to hand over the keys of 501 and 502 when we hand over the demand draft to them tomorrow.
Please.
Tomorrow, immediately after the demand draft is received with the respondents, with regard to the apartments where the attachment is lifted and the residential house also, the keys have to be handed over to them.
Residential house, they are not having.
They don't have the keys.
Start to the apartment,
Yes.
the keys have to be
Apartment
handed
number
over.
501,
501 and 502.
Yes, only.
501 and 502.
And the other three flats where the attachment is lifted, the tenants are continuing to stay. Therefore,
As in respect of the other 1702, 1801, 1802, the tenants are already continuing. List is matter on that day.
Just one
they're-
more
they're
indulgence.
undertaking that they're not be alienating those tenanted
It is
flats.
also,
That is also
in
made.
his submissions, it is also.
Lords, now your lordships is continuing. This is an undertaking which I said. If your lordships is restricting only in respect of 5 apartments. Now 3 apartments, I really felt 9 apartments are there, my lords. 9 apartments is worth about 70 crores, 75 crores. For recovering 30 crores.
What, you pay 10 crores, that day we will release another.
Very well, my lords, I have no difficulty. But one more indulgence, my lords. Of course, my learned friend is here. Para 14 of my affidavit. Lords, this, if your lords, we have already identified the prospective purchasers. In order to facilitate the proposed sale transactions, respondent may cooperate by producing and making available the original title documents for inspection for prospective builders or banking institutions, because
Yes.
this.
Certainly, please. That is no difficulty about
The
it.
respondent shall
Sale is sale.
cooperate
Everything will
whenever the
cooperate, please,
sale
Lords, as far as
transaction takes
501 and
place.
2 is concerned.
Please.
Respondent shall cooperate with the same.
Very well.
Please, Lords, please.
So grateful.
Grateful, please.
Next. Huh? I'll call the passos.
Passover matters. Sale number 14. List number 1, sale number 14, Passover matters.
Petitioner.
Kishore Kumar.
Yes.
Yesterday's matter.
Will it take time? Tomorrow?
Can it very well.
Tomorrow in the first list. Yes.
Sale number 15.
I've been directed to pay stamp duty. That's the issue. What's my respectful submission is, if your lordship will see the order, there are really no reasons in the order. The nature and substance of the agreement is not seen. The order, my lords,
Come to the impugned order.
lords. The impugned order, your lordship will kindly find at page 31, reasons start at page 37. 3 agreements have been impounded by the Honorable
File
Commercial.
number 7, filed by defendant number 4,
Please.
1 to 4 is allowed. Original document to the district registrar for calculation of payment of duty and penalty, or the plaintiff.
Lords, my respectful submission is they were not liable to be impounded, 1, because I'll show the agreements are not liable. 2, Lords, I also argued that in view of there is one judgment of our Honorable High Court that the person who is liable to actually bear must be ordered to pay. In this case, it's the defendant who has filed the application. Therefore, this order should have been passed against the defendant who filed the application. That is also not done.
What is that?
Lords, under the Stamp Act, my lords, under section 43.
No. If the defendant files an application, he will pay the.
Lords, please. Lords, I'll substantiate how that is. Lords, under the Stamp Act,
No, you are the plaintiff in the suit.
I am the plaintiff.
Certain documents are filed, according to them, the deficit is stamped and it has to be impounded.
Please,
He will file an application.
Please,
In that case, he will file he will
Lords,
pay the
under
money.
section 30 of the Karnataka Stamp Act, the person who is liable to pay is prescribed. Section 43 says that once that the person who is liable to pay will be made to pay by a court in an order for costs. Therefore, my lords, even if I pay today, the court will have to adjudicate who is ultimately liable and in a costs order make him pay. Now, my lords, on this basis,
For that can be decided. Now,
in one judgment,
what is like how those documents need
Please.
not be
my
impounded.
lords, it has been termed as an agreement of sale. The Honorable Court has come to the conclusion.
Let's see, where is the discussion with regard to the
Please,
document?
my lords, the discussion really commences, my lords, at para 13 at page 42. As per clause 1.4 shows that the defendants have delivered the goods. Clause 1.5 shows possession of goods are with the plaintiff. Clause 1.7 of the agreement shows since the plaintiff has the possession of goods, the correspondent's right to sell them in case of default by defendant. The transaction under side agreement dated so and so are agreements relating to sale of movable property in which possession is agreed to be delivered without executing conveyance and thus falls under 5G1 of the Stamp Act. In view of the same, side agreement dated so and so would attract stamp duty of so and so each. The stamp duty payable so and so each. However, plaintiff not paid and therefore defendant prays to allow. Therefore, although it's
a suit for
lots, it's suit for recovery of money. If I may narrate in
the side agreement.
lots, if I may narrate as to what transpired, which is found in the plaint. The defendant is the purchaser of cashew kernels, raw cashew nut, which comes in kernel form. They come from Africa. There was one entity who is not a party to the suit called Ecom Trading UK, who was the seller. When the goods were on sale mid-seas, there was some difference of opinion. Therefore, when the goods came here, they were not paid for by the defendants. Because they were not paid for, an affiliate company who is the plaintiff in this suit and the defendant enter into what are called side agreements, under which the affiliate says, till you pay my parent or till you pay my sister concern, I will hold the custody of the goods. My respectful submission is that is all that was done in the agreement. Because in these side agreements, in 90 days time, consideration was to flow from the defendant to the UK entity. And because they were allowed to get the cashew released even without payment, they provided some security cashew to me, the Indian entity. Therefore, it was termed as a security bond. Therefore, the side agreements are not agreements for sale.
So which provision of the Stamp Act?
Not 40, Article 47, but your lordship may kindly see the definition. Your lordship may kindly see the definition of bond under 2AB and Roman number 3.
Article 47, sir.
Ma'am, first 2AB. The definition 2AB Roman 3. I'm at Article 47. Bond includes any instrument whereby a person obliges himself to pay money to another on condition that the obligation
To the schedule.
Lords, first your lordship may kindly see the definition of what is a bond. In that
Defined under section?
section 2, my lords.
Yes.
AB.
Yes.
2AB, my lords, bond includes. So it's an open
One
I'm sorry. March 47 and keep.
Have a Bail Act. This all.
I have an extra set, my lords. May I just?
Yes.
But bond includes.
Yes. Yes.
I am relying, my lords, more particularly on Roman 3. Any instrument so attested where a person obliges himself to deliver grain or other agricultural produce to another. In fact, the agreement describes it as a bond also. When they purchase the stamp paper, the parties had, my lords, they were add item that it has to be termed as a bond. My respectful submission, my lords, is bond is defined in now Article 12. But my respectful submission is it falls in the subcategory of security bond under 47. Bond, your lordship will please find in Article 12.
Yes.
Bond defined by section 21A not being otherwise provided for by this act or by the Karnataka Court Fees and Suit Valuations Act. Then, my lords, there are two categories. After the two categories, your lordship will please see it says see administration bond number 2, bottomry bond 13, customs bond and security bond number 47. My case, my lords, is that that this agreement falls under the category of Article 47, which is a security bond.
Yes.
Article 47, security bond. Executed by way of security for the due execution of an office or to account for money or other property received by virtue thereof, or execution by a surety to secure the due performance of a contract. And B, in any other case, 500. My case, my lords, is that when he got the cashew released, he gave me some cashew, and from the agreement, my lords, I can show that. He gave me some cashew.
So under which provision the court has asked you to pay the court?
Court has asked me to pay under 5(1)(g), 5G, Article 5G. Lords, they are flagged, my lords, your lordship. 5G, which says sale of movable property.
Movable property.
Yes, my lords. If relating to sale of movable property, 5G. Because cashew, my lords, is movable property, the Honorable Court has come to the conclusion that I have to pay stamp duty as per sale of movable property. And my lords, the Honorable Court says because possession is given, it has to be at 3% of market value of the property, which is high.
What you want? You want
Lords, I am only asking for stay of this order. This is a old suit.
When counsel appearing for the petitioner submits that, the petitioner has to pay the stamp duty as per article. Is it article 40?
No, it's 47.
Article 47, whereas the court has directed the petitioner to pay the stamp duty as per article 5G.
5G.
5G of the Stamp Act. It is submitted that the court has failed to consider the submission that are raised on behalf of the petitioner. Consider the same. They shall be stay of all further proceedings pursuant to the order dated so and so. Notice to the respondents and a memo shall be filed to that effect by 16th of July, or else the writ petition stands, the stay granted to this court stands vacated.
Grateful.
My lord, serial number.
One mention, my lord.
Ask me further.
My lord, serial number 15, the first list, my lord. Very next matter, may be taken up tomorrow, my lord.
Will come.
Please, tomorrow.
All the matters in first list will again repeat tomorrow. In other second list, whatever the dates you want, please tell the court officer. If any matter is coming tomorrow before the lower courts and all, you can make a mention tomorrow. We'll take it up at the end of the list.
Please, if I may mention.
Interim order, all interim orders will be extended.
Okay, madam. Second list serial number 2 second list serial number 3.
ಸರ್ ನಿಮಗೆ ನಾಳೆಗೆ
ಅದು second list
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ನಾಳೆಗೆ ಬೇಕಾಗಿರೋ ಮ್ಯಾಟರ್ ಮಾತ್ರ
serial number 10.
ಸೀರಿಯಲ್ ನಂಬರ್ 38. ಸೀರಿಯಲ್ ನಂಬರ್ 38 ನೋಡಿ ನಾಳೆಗೆ.
ನಿಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೇಟ್ ನಾಳೆ ಇದೆಯಾ ಸರ್? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೇಟ್ಸ್ ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿ ಕೇಳಿಸ್ಕೊಂಡ್ರಲ್ವಾ?
ನಂದು ನಾಳೆಗಿದೆ ಕೇಸ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 38 ನಾಳೆಗಿದೆ ನೋಡಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನಾಳೆಗಿದೆ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ನಾಳೆಗಿದೆ ಮೇಡಮ್. ಮೇಡಮ್ ದಯವಿಟ್ಟು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ. Court officer? Madam, serial number 7, second list ಅಲ್ಲಿ.
No. ಸರಿ. Bye.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಯಾವ ಡೇಟ್ ಕೊಟ್ರಿ?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? They're unmuted the court one, sir. Submission ಮಾಡ್ತಾ ಇದೀನಿ.
Sir, list 1, serial number 58, ಯಾರಾರ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರ ಸರ್? ಸರ್,
ಲಿಸ್ಟ್ 1 ಎಲ್ಲ ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಇದ್ರೆ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ವೇರೆವರ್ ನಾಟ್ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್.
ಓಕೆ ಓಕೆ, ಯಾರು ಏನು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್?
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಲಿಸ್ಟ್ 1.
Madam, serial number 7.
50?
58 list 1 serial number 58 madam.
I will repeat it tomorrow.
Okay, thank you.
Madam, serial number 7 second list ಅಲ್ಲಿ.
32 list number 2.
Serial number 7 madam.
32 ಯಾವಾಗ? 32 ಆಗಿದೆಯಲ್ಲ 25 6ಕ್ಕೆ ನಾಳೆಗೆನೆ.
ಲಿಸ್ಟ್ 2 serial number 20.
ಹೇಳಿ ಮೇಡಮ್ ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಯಾವ್ದು ಸೀರಿಯಲ್ ಹೇಳಿ?
Serial number 7 madam. ನಾಳೆ
ಏನ್
ಇದೆ
ಬೇಕು
ಟ್ರಯಲ್
ಹೇಳಿ?
ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನಾಳೆಗಿದೆ ಟ್ರಯಲ್
ಅಲ್ಲ
ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅದು ನಿಮ್ದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಸ್ ಯಾವತ್ತಿದೆಯಪ್ಪ?
ನಾಳೆ ಇದೆ.
ನಾಳೆ ಅಂತ 7 25 6 ಬರ್ಕೊಳ್ಳಿ.
Madam, list number 2, serial number 3.
12 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Madam, list number 2,
ಸರ್
serial
ಎಲ್ಲ
number 3.
ಡೇಟ್ಸ್ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ಸಂಜೆ ಸ್ಟೇಟಸ್ ನೋಡ್ಕೊಂಬಿಡಿಪ್ಪ. ನಾಳೆ
Madam, ಅದಕ್ಕೆ 3 list number
ನಾಳೆ
2.
ಬೇಡ, ಸೀರಿಯಲ್ ನಂಬರ್ 12 ನಾಳೆ ಬೇಡ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ನಾಳೆಗೆ ಬೇಡ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅಲ್ಲಿ 37 ಗೆ ತಗೊಂಡಿದ್ದಾರೆ ಡೇಟ್ ಆಲ್ರೆಡಿ. ಸಂಬಡಿ ಹ್ಯಾಸ್ ಸಬ್ಮಿಟೆಡ್ ಅಂಡ್ ಟೇಕನ್ ದ ಡೇಟ್.
Serial number 3, list 2.
ಹೇಳಿ ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಮಲ್ಲಿ ನಿಮ್ ಜೂನಿಯರ್ಸ್ ಯಾರು ಒಬ್ರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಥವಾ ಡೇಟ್ಸ್ ತಗೊಂಡಾದ್ಮೇಲೆ ನೀವು ಎಲ್ಲಾರು ಒಬ್ಬೊಬ್ರು ಡೇಟ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಯಾರ್ ಡೇಟ್ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ. ಸೀರಿಯಲ್
Madam,
ನಂಬರ್
list
12
number 2, list number 2, serial number 3. Madam, list number 2, serial number 3.
ಅದು 27ಕ್ಕೆ ಸರ್.
Thank you, madam.
ಇವ್ರೆ ನೀವ್ ಹೇಳಿ ನಿಮ್ಗಿಂತ ಬೇಗ ಬಂದಿರೋ ಕೇಸಸ್ ಎಲ್ಲ ದೇ ಆರ್ ವೇಟಿಂಗ್ ಇನ್ ದ ಲಿಸ್ಟ್. ಐ ಕಾಂಟ್ ಅಟೆಂಡ್ ದ ಯುವರ್ ಕೇಸ್ ಟು ದೇರ್ ಕೇಸಸ್ ಇರೋ ಲಿಸ್ಟ್ ನಿಮ್ಗೆ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ ಇವ್ರೆ. ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ ಕೇಸ್ ನಾಳೆ ಇದೆಯಾ ನಾಡಿದ್ಯಾ ಅವತ್ತಿಗೆ ಹೇಳಿ, ಅವತ್ತು ನೆಕ್ಸ್ಟ್ ಡೇಗೆ ಕೊಡ್ತೀವಿ ನಾವು ಡೇಟ್ ಕೊಡ್ತೀವಿ. 14ಗೆ ಅದೇ 20 or 21st ಅದೇನಾಗುತ್ತೆ ನಾನು ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಸಂಜೆ ಸ್ಟೇಟಸ್ ನೋಡ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆ ಏನಾದ್ರು ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಅಥವಾ ಏನಾದ್ರು ಬೇರೆ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇತ್ತು ಅಂತಂದ್ರೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರ ಕೇಸ್ ಬಂದಾಗ. ಯಾವ್ದು ಯಾವ್ದಪ್ಪ? 1 ನಿಮಿಷ 24
ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಲಾಸ್ಟ್ ಮೇಡಮ್ ನಮ್ಗೆ ಏನಾಗಿದೆ, ನಮ್ಮ ತಂದೆಗೆ ಹಾರ್ಟ್ ಸರ್ಜರಿ ಆಗಿದೆ.
ಇವ್ರೆ ಇದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ, ಮೆಮೊ ಮೂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ. ವಿ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಟು 21st. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವ್ರೆ, ಅದೇ ಡೇಟ್ ಆಗಿದೆ, ಅದು ಆಯ್ತು. ಏನ್ ಹೇಳಿ ಇಬ್ರು ಡಿಸೈಡ್ ಮಾಡ್ಬಿಟ್ಟು ಬೇಗ ಹೇಳ್ಬೇಕು. ಡೋಂಟ್ ಕನ್ಫ್ಯೂಸ್ ದ ಕೋರ್ಟ್. ಯಾವ್ದು? ಆಯ್ತು 14 ಜುಲೈ. ಇಲ್ಲ ಅದೆಲ್ಲ ಒಂದು ಲಿಸ್ಟ್ ಚೇಂಜ್ ಮಾಡಕ್ ಬರಲ್ಲ. 20 ಏನ್ ಬೇಕು ಹೇಳಿ ಇವ್ರೆ. 15 ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದೆ. ಯಾರು ಹಾಕಿರೋದು ಇದು? 15/7 ಡೇಟ್ ಇಲ್ಲ ಇವ್ರೆ, ಆಲ್ರೆಡಿ ಅದೆಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿದೆ. ನೀವು ಹೇಳಿದ್ರಿ ಅಂತ ನಾವು ಒಂದೇ ದಿನ ರಶ್ ಅಪ್ ಮಾಡಕ್ ಆಗಲ್ಲ. 27 ತಗೊಳ್ಳಿ. 27 ಯಾವ್ದಪ್ಪ 20 ಇರಲ್ಲ ಅಲ್ವೇನೋ? 27 38 25 6 ಸರ್. ಇಲ್ಲ ಸರ್ ನಾಳೆಗೆಲ್ಲ 70 71 ಇದೆ ಸರ್. ಇಸ್ ದೇರ್ ನಾಳೆಗೆ.
ಲಿಸ್ಟ್ 2 ಲಿ 1
ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಬರ್ತಾನೆ. ಡೇಟ್ಸ್ ಕೊಟ್ಬಿಡೋಣ ಇದು. ನಿನ್ನೆ ಕೊಟ್ಟಲ್ಲ 27 ಆಗಿದೆ ಅಲ್ವಾ? ಒಂದು ನಿಮಿಷ ಇದು 27ಕ್ಕೆ ಎಷ್ಟು ಮಾಡ್ತಿದ್ದಾರೆ? ಜುಲೈ 20 ಅಲ್ಲ? ಇನ್ನೊಂದು 10 ಕೊಡ್ಬೋದು. ಹೇಳಿ ಸರ್. 20 27 2 27
ಇದು ಆಗೋಗಿದೆಯಾ?
ಇದು ಆಗೋಗಿದೆ. 27 ಇರೋದ್ ಮಾತ್ರ ಬರ್ಕೊಂಡು ಹೋಗಮ್ಮ, ಅವ್ರು ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ 4 25 6 5 27 6 27 7 27 7 ನಾಳೆಗೆ 8 27 9 27 10 ನಾಳೆಗೆ 10 ನಾಳೆಗೆ ಆಯ್ತಾ? ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಇನ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 25/6 ಬೆಳಗ್ಗೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳಿದಾರಲ್ವಾ ಸರ್? ನೋಡಿ ಲಿಸ್ಟ್ ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11 PB ಆಗಿದೆ. ಟುಮಾರೋ ಇನ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹೋಗಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಅದೇನೆ ಅದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅಂತ ಆಗಿದೆ. ಆಮೇಲೆ 12 3 7 12 3 7 13 25 6 ಆಮೇಲೆ 14 27 15 27 30 18 16 ಇಲ್ಲ. ಅದೇ ಅವ್ರಿಗಾಗಿದೆ ಬ್ಲಾಂಕ್ ಬಿಟ್ಬಿಡು ನೀನ್ ಬರ್ಕೊಳ್ಳೆ ಬೇಡ ಏನುವೆ. ಇದು 27 ಇದೆಲ್ಲ ಆಯ್ತಾ? ಇದೇನು 5 25 6 16 18 25 6 ಇವ್ರಿಗೇನೆ TSಗೆ. ಆಮೇಲೆ 19 27 ಆಯ್ತಾ? ಸಾಕಷ್ಟು 27 ಆಯ್ತಲ್ಲ. 21 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅದು ಇವ್ರಿಗಾಗಿದೆ PBಗೆ ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ 22ನೇ ತಾರೀಕು ಇವತ್ತು 12 ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಲ್ವಾ? 22 7ಕ್ಕೆ 21 ಕೊಡು. ನೆಕ್ಸ್ಟ್ 22 23 ಎಲ್ಲ 21 7 ಇದು 24 ಬೆಳಗ್ಗೆನೆ ಅಧ್ಯಯನ ಆಗಿದೆಯಾ ಸರ್? 24 ಇಲ್ಲ ಈಗ ತಾನೆ 14/7 ಇವತ್ತು ತಗೊಂಡಿದ್ದಾರೆ. ಬೆಳಗ್ಗೆ PBಗಾಗಿರೋದು 11. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 21 ಮತ್ತೆ 34 ಇದೆಲ್ಲ 14 7 ಬರ್ತದೆ. ಇದು 21 7 ಆಮೇಲೆ 21 7 ಅಡ್ಮಿಷನ್ ಇದೆಲ್ಲ 36 25 6 36
62
21 7 21 7 21 7 ನೆಕ್ಸ್ಟ್ 32 25 ಆಗುತ್ತೆ.
ನಾಳೆಗೆ ಬೇಡ ಅಂದ್ರೆ
21 7 ನಾಳೆ ಬೆಳಗ್ಗೆ 10:10ವರೆಗೆ ಬಂದಾಗ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು ಬೇಡ ಅಂತ 35
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
21
ನಾಳೆ
7
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಗೆ ಬರುತ್ತೆ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬರುತ್ತಾ?
37 21 7 36 36
ಡೇಟ್ ಬೇಡ ಅಂತ ನಾಳೆ ಕೇಳ್ಬೇಕು. ಅದು ಇವತ್ತೇ ಮಂಡೇ ಪೋಸ್ಟ್ ಮಾಡ್ತೀನಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
37 21 7ಗೆ 38 ನಾಳೆಗೆ.
ಹೌದಾ? ಥ್ಯಾಂಕ್ ಯು.
37 ನಾಳೆಗೆ ಆಯ್ತಾ? 38 ನಾಳೆಗೆ 37 ನಾಳೆಗೆ 39 40 22 7 22 7 ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರು 22
ಈಗ ಇವ್ರದ್ದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದ್ಯಾವ್ದಿಲ್ಲ ಗೊತ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 63 ಒಂದಿಲ್ಲ ಕಾಟೋಡಿ
ಬೇರೆನೆಲ್ಲ
ಎಲ್ಲ ಆಸ್ ಇಟ್ ಇಸ್ ರಿಪೀಟ್.
63 ಒಂದಿಲ್ಲ
63 ಒಂದಿಲ್ಲ. ಆಮೇಲೆ ಇನ್ನೂ ಒಂದಿಲ್ಲ. ಇದು 88 89 ಇಲ್ಲ. ಟಾಪ್ ಆಫ್ ಲಿಸ್ಟ್ ಹೊರಟೋಗಿದೆ ಫೈಲು ಅವ್ರಿಗಿಲ್ಲ. PBಗೆ ಇವೆ 88 89 ಇವ್ರಿಗಾಗಿಲ್ಲ. ಫೈಲ್ ಹೊರಟೋಗಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ.
ಅಲ್ವಾ? ಇನ್ನೆಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ನಾಳೆಗೆನೆ.
ನಾಳೆಗೆ ಇವಳನ್ನ ಕರೀರಿ ಬಾ. ಇವಳನ್ನ ಲಲಿತ ಅವ್ನ ಸರಿಯಪ್ಪ. ಹೌದು ಅವತ್ತು ಏನಪ್ಪ ಹ್ಮ್ RES ನಮಗ್ ಬರಲ್ವಲ್ಲ.
CTC ಫೈಲ್ ಪೆಟಿಷನ್ RES ಅಂತ ಇದೆ. ಪೇಪರ್ ಅಲ್ಲಿ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಇದು ಒಂದು IA ಪ್ಲೇಸ್ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ವಿ. ಆಯ್ತು ನಾಳೆ ಒಂದು
ಏನ್ ತಂದು ಕೊಡ್ತಾರಂತೆ? ಅಲ್ಲ GM RES ಅಂತ ಇದೆ ಬರೋದೇ ಇಲ್ವಲ್ಲ ನಮ್ಗೆ.
ಅದು ಮಿಸ್ ಆಗಿತ್ತು.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ 5972.
ಮತ್ತೆ ಇದೆ ಅಂತದ್ದು ಲಾಯರ್
5972.
ಬ್ರಾಂಚ್ ಅವರು ಸ್ಕೂಟಿ ಮಾಡ್ತಾರೆ ಎಕ್ಸಾಮಿನೇಷನ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಂತ KEB ಅಂತ ಇದ್ದ ನೀವು ಅದನ್ನೆಲ್ಲ ಕರೆಕ್ಷನ್ ಅದೇ ನಮ್ಮಲ್ಲಿ ಕೇಸ್ ಅಪ್ಕಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ ಅದನ್ನ.
ಅದು ಸ್ಕೂಟಿ ಅವರು ಮಾಡ್ತಾರೆ.
ಮಾಡ್ಬೇಕು ಅವರು ಸ್ಕೂಟಿ ಅವರು.
ಅದಕ್ಕೆ ಮಿಸ್ ಆಗಿದ್ದು ಆಗಿಬಿಟ್ಟಿದೆ. ಹೀಗಾಗಿ ಸ್ವಲ್ಪ ಕೇಳಿದೀವಿ ಅಡುಗೆ ಕೇಳಿದೀವಿ. ಫೋನ್ ಮಾಡ್ತಾರೆ.
ಅಲೋ ಇದ್ರೆ
ರಿಟ್ ಪಿಟಿಷನ್
ಲಾಯರ್ ಬರ್ದಿರ್ತಾರಲ್ಲ ಆ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ನ ಕಾಟ್ಬಿಟ್ಟಿದೀಯಪ್ಪ ನೀವು. ಅದ್ಯಾವ್ದಿರುತ್ತೆ ಅವ್ರು ಏನೋ ಮಾಡ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಇವಾಗ ಇಲ್ಲಿ ಪೋಸ್ಟಿಂಗ್ಸ್ ಅಲ್ಲೆಲ್ಲ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿ ಅವರು
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 11
ಮೊನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು ಅದೇ ತರ
11
ಆರ್ಡರ್ ಈಗ ಇವತ್ತು ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಆ ತರ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್
ನಾವಲ್ಲ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ರಲ್ಲಿ
ಯಾರು ಮಾಡಿದಾರ ಗೊತ್ತಿಲ್ಲ. ನೀವು ನೋಡ್ಕೋಬೇಕು ಅದನ್ನೆಲ್ಲ. ಇವಾಗ
ನಾಳೆ ಬೆಳಗ್ಗೆಗಾ ಓಕೆ
why this registry is doing this ಅಂತ ಇಲ್ಲಿ ನೋಡಿ. ಇದು GM KEB ಅಂತೆ ಈ ಫೈಲ್ ಮೇಲೆ ಅವರು GM RES ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಫೈಲ್ ಮಾಡೋರೆ. ಅಲ್ಲಿ ಒಂದು FR ನಂಬರ್ ಕೊಡ್ತಾರೆ ಅವರು. ಅಟ್ಲೀಸ್ಟ್ ಅದು ಮ್ಯಾಟರ್ ಇದಾದಾಗ ನಿಮ್ ಕೇಸ್ ವರ್ಕರ್ಸ್ಗೆ ಹೇಳಿ. ನಾವೆಲ್ಲ ಮಾಡ್ತಾ ಇದ್ವಲ್ವಾ ಸ್ಕೂಟ್ನಿನಲ್ಲಿ ಇದ್ದಾಗ ಮಿಸ್ಟೇಕ್ಸ್ ಇದ್ರೆ ಅದೆಲ್ಲ ಅವ್ರಿಗೆ ನೋಡಿ. ಈಗ ಅವ್ರಿಗೆ ಕನ್ಫ್ಯೂಷನ್ ಹಾಕ್ಬಿಟ್ಟಿದಾರಂತೆ. ಅದು GM RES ಅಂತ ಇದೆ ಅವರು ಫೈಲ್ ತೆಗೆದು RES ಹಾಕಿದ್ದಾರೆ. ಇವಾಗ ನಮ್ಮ ಮುಂದೆ ಡೇಟ್ ಇದೆ ನಾಳೆಗೆ ಪೋಸ್ಟ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಸರ್ಚ್ ಔಟ್ ಆಗ್ತಾ ಇಲ್ಲ. ಈ ತರ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ಸ್ ಆಗುತ್ತೆ ನೋಡಿ. ಆಮೇಲೆ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ನಿಮ್ದು ಕೇಸ್ ವರ್ಕರ್ಸ್ಗೆ ಸ್ಟ್ರಿಕ್ಟ್ ಆಗಿ ಹೇಳಿ ಎಲ್ಲೆಲ್ಲಿ ಅದೆಲ್ಲ ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕು ಅದೆಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಸ್ಕೂಟ್ನಿನಲ್ಲಿ. ನೀವು ಹೆಂಗೆ ನೀವು ಬರೀ ಸ್ಕೂಟ್ನಿ ಮಾಡಿ ನಿಮ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ನ ಎಕ್ಸಾಮಿನೇಷನ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟು ಪೆಟಿಷನ್ ಅಲ್ಲಿ IN ಅಲ್ಲಿ ಅವ್ರು ಏನೇನ್ ಬರ್ಕೊಂಡಿರ್ತಾರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಅದನ್ನೇ ಹಂಗೆ ಬಿಟ್ಬಿಡ್ತಾ ಇದ್ದೀರಲ್ಲ. ಹೇಳಿಪ್ಪ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ನೋಡಿ ಏನೋ ಕಾಂಪ್ಲಿಕೇಶನ್. ಮತ್ತೆ ಈಗ ಜುಡಿಷಿಯಲ್ ಎಲ್ಲ ಮೊನ್ನೆ ಮೀಟಿಂಗ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ತಾರೆ ನಮ್ಗೆಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲಾನು ರೆಫರ್ ಮಾಡಿ ನಮ್ಗೆ ಅಂತ. ಈಗ ಆ ತರ ಇತ್ತು ಅಂದ್ರೆ ನಾವು ಜುಡಿಷಿಯಲ್ ರೆಫರ್ ಮಾಡ್ಬೇಕಾಯ್ತದೆ. ಈ ತರ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ಸ್ ಆಯ್ತು ಅಂದ್ರೆ ಅದರ್ವೈಸ್ ಅವರು ಹೇಳಿದ್ರು ಈಗ ನೀವು ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ ಇಫ್ ಯು ಆರ್ ನಾಟ್ ಸೀಯಿಂಗ್ ಪ್ರಾಪರ್ಲಿ ಅಂತಂದ್ರೆ ನಾವು ನಿಮ್ ಮೇಲೆ ಆಕ್ಷನ್ ಇನಿಷಿಯೇಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳವ್ರೆ. ಗೊತ್ತಾಯ್ತಾ? ಈ ತರ ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇರೋವಾಗ ಹುಷಾರು. ಜುಡಿಷಿಯಲ್ ಇವಾಗ ಬಂದಿರೋ ಜುಡಿಷಿಯಲ್ ತುಂಬಾ ಸ್ಟ್ರಿಕ್ಟ್ ಇದ್ದಾರೆ. ಬಿ ಕೇರ್ಫುಲ್. ಅಲ್ಲಪ್ಪ ಇವಾಗ ನಮ್ಮ ಮೇಡಮ್ ನಾಳೆ ಒಂದಿನ ಅಂದ್ರೆ 2ನೇ ತಾರೀಕು ಸಿಟ್ಟಿಂಗಿಲ್ಲ. ನೀವು 2ನೇ ತಾರೀಕು ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಬೇರೆಯವ್ರ ಮುಂದೆ ಹೋದ್ರೆ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಲಿಲ್ಲ ಅಂತಾರೆ. ಏನ್ ಮಾಡ್ತೀರಾ ಲಾಯರ್ನ ಕೇಳ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆಗೆ ಏನ್ IAS ಸರ್ಚ್ ಆಗ್ತಿಲ್ಲ.
ಅದು ಇನ್ಕ್ಲೂಡಿಂಗ್ ಆಗಿದೆ.
ಲಿಸ್ಟ್ ಬರ್ತದೆ ಮೇಡಮ್. ಅದು ಸುಮ್ಮನೆ ಹಾಕ್ಬಿಡುತ್ತೆ. ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಇರುತ್ತಂತೆ. ಲಿಸ್ಟ್ 2 ಬರುತ್ತೇನಪ್ಪ ಹಾಕ್ಬಿಡು ಸುಮ್ಮನೆ. ನೋಡಿ ಒಂದ್ಸರಿ ಆರ್ಡರ್ ಏನಾದ್ರು ಲಿಸ್ಟ್ 1 ನಲ್ಲಿ ಇದೆಯಾ ಅಂತ ಒಂದ್ಸರಿ ನೋಡಿ ಮೇಡಮ್ ಹೇಳಿದಾರ ಅಂತ ನೋಡಿ. ಎಲ್ಲ ರಿಪೀಟ್ ಅಲ್ಲ ಸರ್. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ರಿಪೀಟ್ ಅಪ್ಪ. ಬೇರೆದೆಲ್ಲಾನು ಹೋಗುತ್ತೆ. ಹೌದೌದು ನಾಳೆ ಬರ್ತದೆ.
ಬಟ್ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು
ಏನಂತ ಇದೆ
ಇನ್ಕ್ಲೂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಟು ಬಿ ಫೈಲ್ಡ್
ವಿತಿನ್ 1 ವೀಕ್ ಅಂತ ಅವ್ರು ಹೇಳಿದಾರಲ್ವಾ. ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡೋರು ಅವರು. ಎಲ್ಲೋಯ್ತು ಅಪ್ಲಿಕೇಶನ್
19/6 ಗೆ ಅದೇ ಟ್ರೇಸ್ ಔಟ್ ಆಗ್ತಿದೆ.
ಎಲ್ಲಿ ಟ್ರೇಸ್ ಔಟ್ ಆಗ್ತಿಲ್ಲ. ರಿಸೀವ್ ಮಾಡಿದ್ದೀರಾ ನೀವು ಫೈಲಿಂಗ್ ಕೌಂಟ್ರಿಂದ? ಯಾರು ರಿಸೀವ್ ಮಾಡೋದು?
ನಾನೇ ರಿಸೀವ್ ಮಾಡೋದು ಬಟ್ ರಿಸೀವ್ ಆಗಿಲ್ಲ ಫೈಲಿಂಗ್ ಕೌಂಟ್ರಿಂದ.
ಮತ್ತೆ RES ಕಳಿಸ್ಬಿಟ್ರೆ ನಾವು ನೋಡು.
ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ತೀವಿ ನಾವು. ನಾನೇ ಹೋಗ್ಬಿಟ್ಟು ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಅಲ್ಲಿ ರಿಸೀವ್ ಆಗಿಲ್ಲ.
ಅಪ್ಲಿಕೇಶನ್ ಒಟ್ನಲ್ಲಿ ಫೈಲ್ಡ್
ಆಗಿದೆ.
ಅಡ್ವೊಕೇಟ್ ನ ಕಾಪಿ ತರಿಸ್ಕೊಡಿ.
ಹೇಳಿದ್ರಿ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೀವಿ. ಆಯ್ತು ಇವತ್ತು ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟು
ಈಗ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಲಿಸ್ಟ್ 2 ಬರುತ್ತಲ್ವಾ ಲಿಸ್ಟ್ 2 ಬರುತ್ತಂತೆ ಕಳಿಸ್ಬಿಡು. ಯಾಕಂದ್ರೆ ನಾಳೆ ನಮ್ಮ ಮೇಡಮ್ ನಾಳೆ ಬರ್ತೀನಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 29 ಆಮೇಲೆ ಅವ್ರು ಏನಾದ್ರು ಮೆಮೋ ಮಾಡ್ಕೊಂಡು ಅದರ್ ಸೈಡ್ ಬೇರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋದಾಗ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ವೈ ನಾಟ್ ಲಿಸ್ಟೆಡ್ ಅಂದ್ರೆ ವಾಟ್ ವಿಲ್ ಯು ಆನ್ಸರ್ ಟು ಲಿಸ್ಟಿಂಗ್. ನಾನು ಹೇಳ್ತೀನಿ ನಾಳೆ ಬಂದಾಗ ಅಕಸ್ಮಾತ್ ಅದು ಅಪ್ಲಿಕೇಶನ್ ರಾಂಗ್ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಆಗಿದೆ ಆ KEB ನಲ್ಲಿ ಕೇಳಿ. KEB ನಲ್ಲಿ ಕೇಳಿ.
ನಮ್ದೇ
ನಿಮ್ದೇ KEB ನಿಮ್ಮಲ್ಲೂ ರಿಸೀವ್ ಆಗಿಲ್ಲ. ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಕೇಳಿ ಯಾರು ಕಳಿಸಿದ್ದಾರೆ
ಹೇಳಿದ್ವಿ ಬಟ್ ಅವರು ಸರ್ಚ್ ಮಾಡ್ತಾರೆ.
ಸರ್.
ಆಯ್ತು, ನೀನ್ ಅದನ್ನೇ ಬಂದ್ ಹೇಳು, ನಾನು ಹೇಳ್ತೀನಿ ಅಪ್ಲಿಕೇಶನ್ ಸಚೌಟ್ ಆಗಿಲ್ಲ ಅಂತ. ಹೋಗಿ ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಡು, ಮಿಸ್ ಮಾಡ್ಬಿಡ. ಸೀರಿಯಲ್ ನಂಬರ್ 50 ನಾಳೆ. ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 50ರಿಂದ
ಲಿಸ್ಟ್ ನಂಬರ್ 2
ನಾಳೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 25 5
ಪೂರ್ತಿ ನಾಳೆಗಾ? 57ರಿಂದ 60. ಎಷ್ಟು?
ವಿಜಿ ಭಾನುಪ್ರಕಾಶ್.
25/6.
ಹಾ, ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 57ರಿಂದ 60 ನಾಳೆ. ಅದು ನಾಳೆ. 61ರಿಂದ 61, 62. 63 ಕಾಟ್ ಹೊಡಿಯಪ್ಪ. 64, 65 ನಾಳೆ. 66ರಿಂದ 70. 66ರಿಂದ 70 ನಾಳೆನಾ? 71ರಿಂದ 77. ಎಲ್ಲ ಲಿಸ್ಟ್ ಬನ್ನ. ಇದೆಲ್ಲ ಲಿಸ್ಟ್ ಬಂದೆ. 71ರಿಂದ 77. 77. ಆಮೇಲೆ 78ರಿಂದ 82. 82 ಮತ್ತೆ 82ರಿಂದ 87. 82ರಿಂದ 83ರಿಂದ 87 ನಾಳೆ. 80 ಇವೆರಡಿಲ್ಲ. ಇವೆರಡಿಲ್ವಾ? 88. ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ 25 ಸೀರಿಯಲ್ ನಂಬರ್ 4. 4 ಸೀರಿಯಲ್ ನಂಬರ್ 10. ಸೀರಿಯಲ್ ನಂಬರ್ 7. 7 7 ಇದು 7. 7 ಸೀರಿಯಲ್ ನಂಬರ್ 13. ಸೀರಿಯಲ್ ನಂಬರ್ 18. ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಆಯ್ತಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 28. 32. 34. 38 ಎಲ್ಲ ನಾಳೆ. ಇದು ಲಿಸ್ಟ್ 2ಲೇನಾ? ಲಿಸ್ಟ್ 2ನಲ್ಲೇ ಆಸ್ ಇಟ್ ಈಸ್ ಲಿಸ್ಟ್ 2. 2ನೇನಾ? 2 ಅದು ಒಂದು. ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ. ಲಿಸ್ಟ್ 2ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 34. ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ ಅದು ಬ್ರಾಂಚ್ ಹೋಗಿದೆ ಫೈಲು, ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. 34 ಸೀರಿಯಲ್ ನಂಬರ್ 34. 34, 21. 34, 21. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 11. ಎಲ್ಲ ಲಿಸ್ಟ್ 2ನೇನಾ? ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 1 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ, ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. ಇದು ಲಿಸ್ಟ್ 1 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ, ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. ಇದು ಬ್ರಾಂಚ್ ಹೋಗಿದೆ ಫೈಲ್ಸ್, ಇದನ್ನ ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು ಇದನ್ನ. ಆಯ್ತಾ? ಇನ್ನು ಇದ್ರೊಳಗಡೆ ಡೇಟ್ ಗಿವನ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. ನಾನು ಏನ್ ರಿಪೀಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟು ಮಾತ್ರ ಫೈಲ್ ನಮ್ ಕಡೆ ಇದೆ, ಅದ್ರಲ್ಲಿ ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ದಲ್ಲ ಇರೋ ಫೈಲು. ಈಗ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಫೈಲು, ರಿಪೀಟ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಫೈಲು, ಅದು ಹಂಗೆ ರಿಪೀಟ್ ಹಾಕೊಂಡು ಲಿಸ್ಟ್ 1 ಲಿಸ್ಟ್ 1ಗೆ ಹಾಕಿದೀನಿ, ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 2ಗೆ ಹಾಕಿದೀನಿ. ಅಂತಿ ಟಾಪ್ ಇದು ಮೇಡಮ್ ಹೇಳಿದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 88 ಇದೆಯಲ್ಲ ಇವತ್ತು, ಅದನ್ನ ನಾಳೆಗೆ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಆಗಿದೆ ನೋಡಿ. ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಅದು ಹೇಳಿಲ್ಲ. ಅದು ಅದೇ ಅವರು ಅಲ್ಲಿ ಹೇಳಿದ್ರಂತ ಅವ್ರಿಗೆ ಹೇಳಿಲ್ಲ. ನನಗೆ ಹೇಳಿದ್ರು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ. ನಾನು ಒಂದು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮಿಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದೆ. ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಲಿಸ್ಟ್ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಲಿಸ್ಟ್ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತವ್ರೆ ಅಂತ ಬರುತ್ತೆ. ಅದು ಇದೆ ಅಂತೆ. ನಾಳೆ ಹೇಳಿಲ್ಲ, ಇದು ನಾಳೆಗೆ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ನೋಡಿ. ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಹರ್ ಅಂತ ಹೇಳಿದ್ರು, ಅದೇ ಮೋಸ್ಟ್ ಅಲ್ಲಿ ಟಾಪ್ ಹಾಕಿ ಅಂತ. ಅವ್ರು ನೀವು ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. ಇದು ಟಾಪ್ ನಾಳೆಗ ಇದು ವೆರಿಫೈ ಮಾಡ್ಕೋಬೇಕು, ಫೈಲ್ ಹೋಗಿರುತ್ತೆ. ಈಗ ರಿಪೀಟ್ ಕೊಟ್ಟಿರೋದು ಅಷ್ಟು ಫೈಲ್ ಬಿಟ್ಟು ಬೇರೆ ಏನ್ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅದೆಲ್ಲ. ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ ಇನ್ನೊಂದು 19ನೇ ತಾರೀಕಲ್ಲಿ ಮೆಮೊ ಮಾಡಿದ್ದಾರೆ, ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್. ಆದ್ರೂ ಅದನ್ನ ಕಳಿಸ್ಬೇಕು ಅಂತ. ಇದ್ರಲ್ಲಿ ನೋಡ್ಬೇಕಾ 49 ಏನೇನೋ ಬರ್ತಿದಾರೆ. 29/7 ಅಂತ ಬರ್ದವ್ರೆ. DR ರವಿಶಂಕರ್ ಅಷ್ಟೇನಾ? 49 ಒಂದು ಮ್ಯಾಟರ್ 19ನೇ ತಾರೀಕು ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಕೋರ್ಟ್ ಮುಂದೆ. ಅದು ಮೇಡಮ್ ಡೇಟ್ ಇವತ್ತು ಮೂವ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಇವತ್ತು. ಅಂದ್ರೆ ಆಲ್ರೆಡಿ ಅದರಲ್ಲಿ ಡೇಟ್ ಬಂದ್ಬಿಟ್ಟಿದೆ. ಡೇಟ್ ಬಂದಿರೋದನ್ನ ಮತ್ತೆ ಅವರು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡು ಯಾವತ್ತೂ ಸರ್ ಅದು ಹೇಳಿದ್ದು ಬೆಳಗ್ಗೆ ಒಂದು ಮೆಮೊ ಕೊಟ್ರಲ್ಲ ಅದೇ ಅಡ್ವೊಕೇಟ್ ಮೆಮೊ ಕೊಟ್ಟು ನೋಡಿ ಅರ್ಜೆಂಟ್ 21 ಕೊಟ್ಟೋಗಿದೆ ಅಂತ. ಯಾವ್ದಿದು ಇದರಲ್ಲಿ WP 17815 ಸರ್ ಅದು ಬೀನ್ಸ್ ಕೊಟ್ಟು ಅನ್ಸುತ್ತೆ ಒನ್ FR WP FR ಇನ್ನೊಂದು CRP ಅದು ಒಂದ್ ನಿಮಿಷ ಹಂಗೆ ಹೇಳಿ ಸರ್ ಅದು ಯಾವಾಗ ಮಿಸ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದವರು ಈಗ ಕೊಟ್ಟಿದ್ದೀರಾ ಓಕೆ ಸರ್
CRP 209 ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಬಿಡಿ ಅದೇನೆ
ಸರ್
ಅಲ್ಲ ಅನ್ಸುತ್ತೆ ಸರ್ 18 ಸರ್ ಇದು ಬೀನ್ಸ್ ಬುಕ್ ಅಂತ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾ ಇಲ್ಲ ಮೇಡಮ್ ತಗೊಂಡೋಗ್ಲಾ ಹೋಗ್ಲಾ ನಾನು ನೀವು ಹೋಗಿ ನಾನು ನೋಡ್ತೀನಿ ಅದು ಕರೆಕ್ಟ್ ಸರ್ CRP
Sir, listed to serial number 38.
21st July ಅಂತ SMCಗೆ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ಅವ್ರು ಅಲ್ವಾ ಬೆಳಗ್ಗೆ ತೆಗ್ದೆ ಅದು ಲಿಸ್ಟು ಯಾವ್ದ್ರಲ್ಲೋ ಇದೆ ಇದೆ ಬಿಡಿ CRP 299 ಅಲ್ವಾ
Sir, listed to serial number 38. ಯಾವಾಗ
209 ಅಮ್ಮ 299 ಅಲ್ಲ
209
listed to serial number 38.
List to 38 ನಾಳೆ ಬರುತ್ತಲ್ಲ
ನಾಳೆಗೆನಾ
ಇದು 21/7 ಡೇಟ್ ಹೊರಟೋಗಿದ್ದು 21/7 ಅದನ್ನ ಬೆಳಗ್ಗೆ ಮೆಮೊ ಮಾಡಿ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಆ ಫೈಲ್ ಬೋರ್ಡ್ ಕಳಿಸಿದ್ದೀರಾ ನೋಡಿ ಅದು ಅಡ್ವಾನ್ಸ್ ಆಗಿದೆ
ಎಲ್ಲಿದ್ದೀರಿ ಈ ದಸರಾ ಸೆಂಟರ್ ನಮ್ಮೊಬ್ಬರನ್ನೇ ಬುಕ್ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿಂದ ಹೆವಿ ಕೆಲಸ ಈಗ ದೇವಿಗೆ
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ವಿ 3 ಡೇಸ್ ಲಿಸ್ಟ್
ರೀಚ್ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ ಬೆಳಗ್ಗೆ 10:30 ಫೋನ್ ಮಾಡಿ ಬಂದ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೋಬೇಕು
ಕೊಲೀಗ್ಸ್ ಕಂಟೆಂಟ್ಸ್ ಕೊಲೀಗ್ಸ್
ಗೊತ್ತಿಲ್ಲ ಏನಾಯ್ತು ಇವಾಗ
ಇಲ್ಲ ಲಿಸ್ಟ್ ರೀಚ್ ಆಗಿಲ್ಲ
ಅದೇ ಕರೆಕ್ಟ್ ಅದೇ ಯಾವ ಡೇಟ್ ಹೋಯ್ತು
21/7
ಇವ್ರೆ ನೀವು ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ
ಮಂಡೇನು ಬಂದಿದೆ
ನಮ್ಮ ಮೇಡಮೇ ಆರ್ಡರ್ ಮಾಡಿರೋದಾ ಯಾವತ್ತು ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಇವ್ರೆ ಅದು ಲಿಸ್ಟ್ ಆದ ಬೆಳಗ್ಗೆ ಬಂದು ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು ತಾನೆ
17ಕ್ಕೆ ಪಾಸ್ ಮಾಡೋದು ಪಾಸ್ ಮಾಡಿಲ್ಲ 18 ಡೇಟ್
ಟಿ ಶೇಷಗಿರಿರಾವ್ ನಮ್ಮ ಮೇಡಮ್ ಡೈರೆಕ್ಷನ್ ಇತ್ತಾ
355 189.
ರವಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ. ಗಂಗಾಧರ್ ಸರ್, ರವಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ. ಹಲೋ ಅಂಜಲಿ, ಅಲ್ಲಿ ನಮ್ಮ ರವಿ ಇದೆ, ಕೊಡೋ ಫೋನು. ಅಲ್ಲಿಗೆ ಬಂದಿಲ್ವಾ? ಲಿಸ್ಟ್ ತಗೊಂಡು ಬರ್ಲಿಲ್ವಾ ಅವರು? ಅಲ್ಲಪ್ಪ, ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿಲ್ವಮ್ಮ ಇನ್ನ ಅವ್ರಿಗೆ? ಹೌದಾ, ಆಯ್ತಾಯ್ತು. ಇದು ತಗೊಂಬರ್ಮ, ಸೀರಿಯಲ್ ನಂಬರು 37 ಒಂದು ನಾಳೆಗಂತೆ ಹಾಕ್ಬಿಡಿ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ರಿ. ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 37.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್,
ಅವಾಗ ಬಂದು ನೀವು ಎಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದ್ಸತಿ ಬಂದಿರ್ತದೆ, ಎಲ್ಲಾ ಕಡೆ ಹೇಳ್ಕೊಂಡು ಕೂತ್ಕೋಬೇಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 58 ಲಿಸ್ಟ್ 1. ಮೇಡಮ್ ಯಾವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಹೇಳ್ಬೋದಾ ಅಷ್ಟೇ? 58 ಲಿಸ್ಟ್ 1.
ಹಲೋ, ಲೈನಲ್ಲಿ ಇದ್ದೀರಾ?